ಇವತ್ತು ಏನು ರೇಟ್ ಹೇಳಿದ್ರೆ ಮಿನಿಮಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಮಿನಿಮಮ್ ಕೊಟ್ಟ ರೇಟ್ ಬೆಲೆ ಇಲ್ಲ.
ಹಲೋ, ಕೇಳ್ತೀರಿ? ಈ ಧಾರವಾಡ ಬೆಂಚ್ ಮ್ಯಾಟ್ರ್ ಯಾವಾಗ ಕರಿತೀರಿ ಕೋರ್ಟ್ ಆಫೀಸರ್?
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಮ್ಯಾಮ್ ಹೇಳಿ.
ಗಿರಿಜಾ ಹಿರೇಮಠ HCGP ಧಾರವಾಡ ಮೇಡಮ್.
ಸರಿ ಸರಿ ಆಯ್ತು
ಮೇಡಮ್ 2:30 ನಮ್ದು ಕೋರ್ಟ್ ಹಾಲ್ ಐತಿ ಮತ್ತೆ ಪ್ಲೀಸ್.
ಎಸ್ ಮ್ಯಾಮ್. ಓ ಇಲ್ಲ ಖಾಲಿ ಆಗಿದೆಯಲ್ಲಪ್ಪ.
ಇಲ್ಲಿ ಯಾವಾಗಲೂ ಅದೇ ಸಬ್ಜೆಕ್ಟ್ ಕೊಡಿ, ಇಲ್ಲಿ ಯಾವಾಗಲೂ ರಶ್ ಇದ್ದೇ ಇರುತ್ತೆ.
ಯಾವತ್ತಿಂದ ಹೇಳಿದ್ರಂತ? ಸೀರಿಯಲ್ ನಂಬರ್ ಏನು? ಲಿಸ್ಟ್ 1. ಅಲ್ಲ, ಯು ಟೇಕ್ ಔಟ್ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಅಂದ್ರು ಅಷ್ಟೇ ಅನ್ಕೋತೀನಿ. ಡಿಕ್ಟೇಷನ್ ಕೊಟ್ಟಿರಲ್ಲ. ಡಿಕ್ಟೇಷನ್ ಕೊಟ್ಟಿರಲ್ಲ.
ನಿನ್ನೆ ಮಂಡೇ ಡೇಟ್ ಕೊಟ್ಟು ಅದು ಮಂಡೇ ಬರಲಿಲ್ಲ, ಇನ್ನುವರೆಗೆ ಬರಲಿಲ್ಲ. ನಮಸ್ಕಾರ. ಅಲ್ಲಿ ಇದಾರ ಸಾಹೇಬರು? ಕೂತ್ಕೊಳ್ಳಿ, ಕೂತ್ಕೊಳ್ಳಿ ತೋರಿಸಿ, ಪೇಪರ್ ತೋರಿಸಿ. ಇದೆ ಹೋಟೆಲ್ ಇದ್ದೀನಿ, ಹೋಟೆಲ್ ನಂಬರ್ 15
What is this?
May I make one submission? Tomorrow is the public auction.
Wait. Memo GMCPC ಕೊಡಿ.
ಅಲ್ಲ, public auction.
Monday full ಆಗಿರುತ್ತೆ, Wednesday or Friday.
My lord, end of
Wills ಕೊಡಿ.
This is for.
Wait.
Rejection of compromise is under challenge. However, by virtue of entry matter, the trial court is not protecting my property. There is a legal foundation. Not may kindly what I do. Wait until
Monday ಅದು ಬೇರೆ ಎಲ್ಲ ಕೊಡಿ. ಅದೊಂದು ವೇಟ್, ನೀವು ಇರಿ ಒಂದು ನಿಮಿಷ. ಬೇರೆ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ ಮೆಮೋಸ್.
My lord,
ಆಲ್
I have
ಜನರಲ್
one
ಮೆಮೋಸ್
submission.
ಗಿಫ್ಟ್.
My lord, my submission is that the executing court, the matter is set down today, where the judgment debtors and the delivery warrant may be issued for eviction of the whole property, my lord. It may be taken up at the end of the list.
2:30, take it.
My lord, tomorrow is the public auction.
No, she went away. Wait, 2:30 ವೇಟ್ ಮಾಡಿ. ಮಿಕ್ಕಿದೆಲ್ಲ ಮೆಮೋಸ್ ಕೊಟ್ಬಿಡಿ. ಮಿಕ್ಕಿದೆಲ್ಲ ಮೆಮೋಸ್ ಕೊಟ್ಬಿಡಿ. ಮಂಡೇಗೆ ಆಗಲ್ಲ. ಮಂಡೇ ಅವ್ರು ವೆಡ್ನೆಸ್ಡೇ ಲುಕಿಂಗ್ ಅಟ್ ದಿ ಎಲೆಕ್ಟ್. ಅದು ಅಂತ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ವೇಟ್. ಗಿವ್ ಇಟ್ ಸರ್. Wait. Yes. Give it. 9th. ಎಲೆಕ್ಷನ್ ಇಲ್ಲ ಯಾಕೆ ಬಂತು? ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಇಲ್ಲ ಕೊಡಿ. ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಆರ್ ವೆನ್ಸ್ಡೇ ವಿಲ್ ಕಮ್. 2:30. Yes. ಮಂಡೇ ಸರ್. ಯಾಕೆ? ಹಾ, ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ? ಇಲ್ಲಿವರೆಗೆ 9 ವರ್ಷ 11 ವರ್ಷ ಗೊತ್ತಾಗ್ಲಿಲ್ವಾ ಅದು? ಬೇಡದೆಲ್ಲ ಬೇಡಬೇಡಿ, ಮಂಡೇ ಕೊಡಿ. ಗಿವ್ ಇಟ್ ಫಾರ್ ಮಂಡೇ. ಎಲ್ಲೇ ಬಿಡಿ ಅದೆಲ್ಲ ಕೊಡಿ. 1 minute. ಎಲ್ಲೇ ಬಿಡಿ, ವಾಟ್ ಎವರ್ ಇಸ್ ದೇರ್ ಪ್ಲೀಸ್ ಗಿವ್. It will come on Tuesday or Thursday. Give it. ಎಲ್ಲೇ ಬಿಡಿ, ಐ ಆಮ್ ಆಸ್ಕಿಂಗ್ ಎಲ್ಲೇ ಬಿಡಿ. ಮಂಡೇ ಆಗಲ್ಲ, ಕೊಡಿ. ಎಲ್ಲೇ ಬಿಡಿ ಕೊಡಿ, ಎಲ್ಲ ಎಲ್ಲೇ ಬಿಡಿ ಕೊಡಿ. Tuesday or Thursday it will come. Give it. ಎಲ್ಲರೂ ಹೇಳಿದ್ರೆ ನಾನು ಒಂದು ಮೆಮೊನು ತಗೊಳಲ್ಲ. ಎಲ್ಲೇ ಬಿಡಿ ಅಂತ ಹೇಳಿದೆ ತಾನೇ? ವೆಯ್ಟ್. ಎಲ್ಲೇ ಬಿಡಿ ಅದಾಯ್ತಾ? ನಿಮ್ದೇನು? ವೆಯ್ಟ್. ನಿಮ್ದೇನು? ಕೊಡಿ. So what? Go and make the arguments. Come, ಕೊಡಿ. No, I can't take. ಪರವಾಗಿಲ್ಲ, ಏನ್ ತೊಂದರೆ ಇಲ್ಲ, ಕೊಡಿ. ಮಂಡೇ or Wednesday ಕೊಡಿ. No adjournment. Yes, next. ಕೊಡಿ. Entry matter grant surface act. GMCPC ಇಲ್ಲ ಕೊಡಿ. ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್ ಫ್ರೆಶ್ ಏನ್ ಪರವಾಗಿಲ್ಲ. Suit is of the year. Correctly rejected. No urgency. Give it. Yes. No problem, sir. No problem, sir. Give it, sir. No worries. Give it. Yes. Why? Eviction. Tenant. Monday, sir. ಪರವಾಗಿಲ್ಲ ಸರ್, ಏನ್ ತೊಂದರೆ ಇಲ್ಲ, ಕೊಡಿ. Again, I'm telling you, all of you are talking at once. You missed the bus. Wait. Yes. No problem. Give it, madam. Yes. It will come. Yes. Wait. Yes. Vacating stay na. Kodi. 9th.
Contempt of proceeding. Contempt ನಮಗೆ revenue entry ಆಗಿತ್ತು ಮೇಡಮ್.
What?
Contempt proceeding ಅಲ್ಲಿ 2021 RTC ಆಗಿತ್ತು ಮೇಡಮ್. ಇಲ್ಲಿ GMCP
ಈಗ ಏನಾಗಿದೆ?
ಅರ್ಜೆನ್ಸಿ ಮಲ್ಟಿಪಲ್ ಪ್ರೊಸೀಡಿಂಗ್ ಖಾತೆ ಮಾಡ್ತಾರೆ ಸೋಮವಾರಕ್ಕೆ ಆಯ್ತು ಮೇಡಮ್.
2:30 ಇಲ್ಲ, ಮಂಡೇ.
ಸೀನಿಯರ್ ಎಂಗೇಜ್ಮೆಂಟ್.
ಮಂಡೇ ಸರ್.
ಪ್ಲೀಸ್ ರಿಕ್ವೆಸ್ಟ್ ಮೇಡಮ್, ಪ್ಲೀಸ್.
ಮಂಡೇ ಸರ್. ಮಂಡೇಗೆ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿ ಸೀನಿಯರ್ಗೆ.
ಸೀನಿಯರ್ ಇವತ್ತು ಕಾರ್ಯಕ್ರಮ
ಆಯ್ತು, 2:30 ಕೊಡಿ.
That's a suit for eviction. No, executing court ready to execute.
ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್ ಸರ್, ಕೊಡಿ ಸರ್.
Kindly
It won't come on Monday. It will come on Monday or Wednesday or Friday. Give it. We'll see.
Public action is scheduled to be held tomorrow. ಇವತ್ತಿಗೆ ಡೇಟ್ ಕೊಟ್ಟಿತ್ತು, ಬಂದಿಲ್ಲ, ಪೋಸ್ಟ್ ಆಗಿಲ್ಲ.
2:30 ತಗೊಳ್ಳಿ
Please.
Lordship, kindly, yesterday BDA matter has been referred up, my lord. The damages has been not considered, my lord. They have taken position in the year 1982 till
ನಾನು
today.
ಹೇಳ್ಬೇಕಾಗಿತ್ತು ಮತ್ತೆ.
I forgotten, my lord. Sorry, my lord, for being spoken to, my lord.
Next Wednesday ಹಾಕಿದ್ being spoken.
Lordship, I am challenging the impugned order. The next date of hearing 10th of this month.
What impugned order?
IML ಇದು ಆರ್ಡರ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಏನ್ ಆರ್ಡರ್ ಆಗಿದೆ ಸರ್?
ಇಂಪ್ಲೀಟಿಂಗ್ ಅಪ್ಲಿಕೆಂಟ್ಸ್ ಅಲೋ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ, ಅದಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್.
9th ಕೊಡಿ.
Please rewrite the objection for the third time, though I have viewed it on the previous 2 dates.
Now what is the matter? Fresh matter?
Fresh matter on Monday, my lord, because it is posted for judgment on Tuesday.
All right, Monday. Yes. Monday give it.
My lords.
Fresh pending ಅದು Monday or Wednesday it will come. Misusing your age. ರೆಸ್ಪಾಂಡೆಂಟ್ ಈಗ ಕೊಡಿ.
7 rule.
ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ಹಾಕಿ.
7 rule 7 rule.
Yes sir. 1 minute. Next Thursday, give it. No problem, give it Thursday, yes. Monday.
My lord,
16 matter. Hangel, Kodi, yes.
next week.
ಅದೊಂದು ಡಿಸ್ಪೋಸ್ ಮಾಡಕ್ ವೆಡ್ನೆಸ್ಡೇ ಹಾಕಿ. No, I've released it from part heard.
This one is remaining.
No, nothing. Tender ಯಾವುದು ಇಟ್ಕೊಂಡಿಲ್ಲ, ಎಲ್ಲ ರಿಲೀಸ್ ಫ್ರಮ್ ಪಾರ್ಟ್ ಹೆಡ್ ಮಾಡಿದ್ದೀನಿ. ಅವತ್ತೇ ಮಾಡಿದ್ದೀನಿ.
This one is still pending.
ಮೇಡಮ್ ನೋಡಿ ಅದು ಯಾವುದು. Yes.
482
Give that memo.
Posted for the hearing. Crime of 23 state, 5 connected matters, 5 different. Adu, the other day.
That lady.
Illa, this is Mr. D.R. Ravishankar sir had argued it in part. It was before my lords. My lords sought to release it to go before the regular court, but they said no because it was part heard by my.
You want me to release it now? We'll post it at 2:30 and release it.
No, my lords. Any date my lords may fix. I haven't taken their.
Then 11th.
Yep, very good.
My lord, it's a LABDA matter, my lord. It's a set of
Give it.
demolition.
Give it.
7 rule 11 application has been rejected. My lord.
Correct, Kodi.
It's
Next
posted for
Thursday.
evidence.
Yeah, sir.
Extended Monday and
ತಗೊಳ್ಳಿ.
Good. Being spoken to.
ಅದನ್ನ ತಗೊಳ್ಳಿ.
Monday ಆಗ್ಬೋದಾ?
Land acquisition matter not for being good people.
CPC matter, my lords, your lordships had ordered for attachment. Now we
Why you have ordered for attachment?
attachment of the bank account, my lords. Now we've realized that the bank account, they have only 30 lakhs and the amount was 14 crores. So therefore, we are seeking to attach another bank account, freeze another bank account. Any date.
Tuesday, Wednesday or Thursday ಬರುತ್ತೆ ಕೊಡಿ.
Lord Civil Court
Who is
rejected.
Lokesh here?
Lord Civil Court rejected the interim application challenging surface proceedings. They filed a writ petition here, my lord. This court had told not to alienate, but the borrower is not permitting the bank to take physical possession of the property, telling that there is an interim order. Only modification, clarification.
Sorry. ಅದು ಫ್ರೈಡೆ ಹಾಕಿ ನೆಕ್ಸ್ಟ್ ಕೊಡಿ ಸರ್. ಗಿವ್ ಇಟ್.
LA matter, my lord. Compensation is not paid. since
ಗಿವ್ ಇಟ್.
Friday.
ಗಿವ್ ಇಟ್. ಬಂದ್ಬಿಟ್ಟಿದ್ಯಾ? ಯಾವಾಗ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ? ಯಾವಾಗ ಆಕ್ಷನ್? ಯಾವತ್ತು ಗೊತ್ತಿಲ್ವಾ? ಮತ್ತೆ ಬಂದ್ಬಿಟ್ಟಿದೆ ಅಂದ್ರೆ ಕೊಡಿ. ಮಂಡೇ ಆರ್ ವೆಡ್ನೆಸ್ಡೇ.
GM RES.
RES ಆಕ್ಷನ್ ಏನು ಆಕ್ಷನ್ಗೆ? GM CPCನ ಸರ್ಫೇಸಿನ? ರನ್. Yes.
My lords, one mention with respect to smart meter case, my lords.
ಇವತ್ತಿದೆಯಾ?
ಇವತ್ತು ಬರ್ಬೇಕಿತ್ತು, my lords, but then the file is in the board branch itself.
So why is it smartly missed? Yes, we'll see. Yes, madam, you tell the other side. I'll have it listed.
Please.
2:30 ಆಗ್ಬೋದಾ ಕೇಳಿ ಅವರಿಗೆ.
Please.
ಯಾರಿಗೆ? Advocate General and Panindra sir, I guess. You tell them, we'll get it listed. Your date ಕೊಟ್ಟಿತ್ತಾ?
Your date ಕೊಟ್ಟಿದ್ದು.
ಯಾಕೆ madam list ಆಗಿಲ್ಲ?
My lords, that is because there's another matter which needs to be connected with it, my lords. No, my lord.
Another
30th.
matter clubbing, don't ask. Yes.
Because of that clubbing, the file has been.
Other
stuck
matter
in
is
the
clubbed, it goes to the other court. I will club it, no problem. You want me to club? I will club.
But what he's trying to say is our matter is affected as a result of they attempting to club this matter here.
First
What
court
he's
ಅಲ್ಲಿ.
trying to say.
In the first court.
Not the first court. One more fresh petition came about. That was to be connected with our matter. As a result of that, probably our matter is not listed as interested.
Could be, I don't know, because it goes to the senior judge. That's why clubbing you should not ask. Yes. Tender. ಅದು ಕರೆದಾಗ ಹೇಳಿ. ಧಾರವಾಡ ಗಿರಿಜಾ ಮೇಡಮ್.
Please, your lordship.
I'll take it at 2:30. All Dharwad matters, I'll take it at 2:30. All right?
My lords.
You come at 2:30.
Please. Your lordship, court hall matters are there, your lordship, at 2:30.
ಆಯ್ತು 3:30 ಬನ್ನಿ.
Please, your lordship.
ಎಲ್ಲ ಮುಗಿಸ್ಕೊಂಡ್ ಬನ್ನಿ. Yes.
Sorry.
It's not there, is it? It is. No problem. You come at 12, we will take it.
My lords, if I may mention a matter, my
No,
lords.
memo?
No, my lords.
No
for
adjournment,
adjournment.
yes.
My lord, GMCPC, my lord, 2024.
1:30 you make a mention. Adjournment will grant it 1:30.
Please, my
My
lord.
lord, GMCPC, my lord, matter of the year 2024, not even listed once before the court.
Not even list, why sir?
Lord, fresh matter, my lord.
ಕೊಡಿ ಮಂಡೆಗೆ ಹಾಕಿ ಅದು. ಬರುತ್ತೆ ಎಲ್ಲ, ನೀವೆಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರೆ ಎಲ್ಲ ಬರುತ್ತೆ.
Now it is complaint. Get.
ಸುರನ ಸರ್ ಏನಕ್ಕೆ ಇದು being spoken to?
Serial number 4, Supreme Court election matter.
ಕರೆಕ್ಟ್, ಅದು ಅರ್ಜೆನ್ಸಿ. ಇನ್ನೇನ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ರಿಓಪನ್ ಆಗ್ತಾ ಇದೆ ಬಿಡಿ.
My lord, only ordered 5 lakh rupees. They said that they have owed the money. He has sold the property for 1 crore 75 lakhs.
When?
On 28/11/24.
ಅಲ್ಲ, ಶೂಟ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಇರ್ಲಿ. ಸೇಲ್ ಮಾಡಿದೀರಾ ನಿಮ್ ಪ್ರಾಪರ್ಟಿನ? Neighbor's property you sold, is it? Then whatever property you have sold or not.
Or 1 crore 75 lakhs.
Then another 25 lakhs you pay.
Let them pay. Supreme Court.
11/6, this court on 11/6/2025. Baby.
Supreme Court has directed to pay 20 lakhs.
Who is counsel on record? Sandeep Larry had a baby. Deepika Joshi had a baby. That's all right. What is Sandeep Larry doing?
3 years back.
I know, sir. What is he doing?
A statement was made that he has no money. Supreme, from 3 years, they are enjoying
Baby
the
problem ಹೇಳ್ತಾ ಇದ್ದಾರೆ. Wait, sir. No, you have to pay some more money. Monday in the same stage. Yes. Another 25 lakhs you have to pay. Which is the document which he has sold? The learned counsel, Sri P.D. Surana, moves the matter for being spoken to on the score that the petitioner who has sold a property of his which is at rupees
1 crore 75 lakhs.
1 crore 75 lakhs
On
is
28/11/24.
is feigning ignorance of the sale and is now projecting that he does not have money to even deposit. The said statement would clearly belie the statement of said sale deed would clearly belie the statement of the petitioner. Therefore, if the interim order has to be continued, the respondent shall seek, the petitioner shall seek instruction with regard to deposit of another 25 lakhs list on Monday in the same stage. Avat interim order continue madala. 5 is all right. 25 lakhs if you don't deposit, I am not going to continue the order. Misplaced sympathy jurisdictions ಎಲ್ಲ invoke ಮಾಡಬೇಡಿ. Yes.
Order still number 2.
Appearing for respondent number 2, my lords. Sincere apologies, my lords. One
ಪರವಾಗಿಲ್ಲ ಸರ್ ಹೇಳಿ ಅಂತ.
ವಕಾಲತ್ತು ಬೆಳಗ್ಗೆ ಸಿಕ್ಕಿದೆ. Meanwhile, I'll file the wakalat, my lords. Kindly have it on Monday or Tuesday.
ಗೊತ್ತು ಸರ್, ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ವಾ? ಸೆಟಲ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಯಾಕೆ ಕೋಆಪರೇಟ್ ಮಾಡ್ತಾ ಕ್ಲೋಸ್ ಆಗಕ್ಕೆ?
I'll file wakalat, my lords. That is the only reason. Please, my lords.
ಅಷ್ಟೇ ಸಾಕಾ? ಆಮೇಲೆ ಕೋಆಪರೇಟ್ ಮಾಡ್ತೀರಾ?
Please, my lords.
The learned counsel appearing for the respondent complainant submits that he has instructions to appear and would file his wakalat in the course of the day. Registry to print the name of so and so is appearing for the second respondent complainant. The issue in the list is with regard to settlement that is drawn between the husband and the wife, and notwithstanding the same, the complainant wife wanting to pursue proceedings in the subject CC. List 3221 of 24. List the matter next Friday. Avat close ಮಾಡ್ತೀನಿ.
Please, my lords.
Interim order subsisting will continue to the next day.
Much obliged, my lords.
Yes.
Still number 3.
Records ಬಂದಿದೆ madam. This court on 6/6/2025, while granting an interim order on this court that affidavit appended to the private complaint as necessary in terms of the law laid down by the apex court in the case of Babu Venkatesh was not followed, had granted an interim order of stay and had directed the registry to secure the original records from the concerned court. The records are yet to come. The registry is thus directed to secure the records by telephonic instruction by the next date of hearing, next Friday. Interim order subsisting will continue to the next date of hearing. ಪಾಸ್ ಓವರ್ ಕೇಳಲೇ ಬಿಡಿ. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ
Lord,
ನೀವ್ ಇರ್ಲಿಲ್ವಾ? ಹಾ, ಏನ್ ಮಿಸ್ಲೀಡಿಂಗು? Evading appearance before the concerned court prior to the grant of interim order.
Yes.
ಅದು ಹೇಳಿ ಕೊಡಿ. Hmm.
Yes. Can you see the first page, Miller? Itself, Miller, appeal number, appeal persons appear before the trial court and they have filed an application under section 451 and 457. Then, Miller, it came to be rejected.
451, 457 ಬಿಡಿ ಸರ್, ಅಪಿಯರೆನ್ಸ್ ಹೇಳಿ. Come here at page case called reissue summons to accused 1 to 5.
Next page,
Reissue summons.
last page, on 22/5.
ಇಲ್ಲೂ ಅಷ್ಟೇ 451 ಅಪ್ಲಿಕೇಶನ್ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಬರೀ ಇಶ್ಯೂ ಸಮನ್ಸ್ ಟು A1 to A5. reissue summons. I will vacate the interim order if this is your conduct. Cognizance bidi sir. After cognizance, why have you not appeared?
Trial court has issued summons to on that day itself, Millets.
Correct.
Till then, Millets, we have not received the summons. When we received the summons, immediately we have appeared before the trial
When
court.
did you appear?
On 22/5/2021, 2025, Millets.
ಅಲ್ಲಿವರೆಗೂ ಸಮನ್ಸೇ ಬಂದಿಲ್ಲ.
Summons bandila, Millets. Even the trial court has not issued this NBW also. If we are awaiting the receiving of summons, then the trial court have option to issue an NBW and trial court have every option to cancel my bail
ಚಾರ್ಜ್ ಫ್ರೇಮ್
application.
ಆಗಿದೆಯಾ?
No, Millets.
Yes, Millets.
ಯಾವತ್ತು?
No, sorry, Millets.
Date.
Charge is not filed. Charge sheet is filed.
Charge sheet is.
Lord, another one more conduct I want to bring to this honorable court.
Another conduct.
Another misconduct to the.
Misconduct. ಕೊಡಿ.
The
Conduct, okay,
it has
then
been issued on
misconduct.
5th. They are so powerful.
ಯಾರು?
The petitioners before this honorable court, they can even manipulate the court documents. That's what the Siristedar issued given the acknowledgement.
B report.
B report file ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ನಮ್ಮ ಕೇಸಲ್ಲಿ they have what the case which they have, the complaint which they have filed, and it is marked, it is produced before annexure F this before this honorable court in page number 379.
ಏನ್ ಕಾಂಡಕ್ಟ್ ಹೇಳಿ.
ಸ್ವಾಮಿ ಇದರಲ್ಲಿ ಎಂಟೈರ್ ಫೈಲ್ಸ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಿಸ್ ಆಗಿದೆ. ಮಿಸ್ ಆಗಿದೆ. Siristedar was unable to give a copy. Kindly look at the document which I produced.
ಯಾವ ಕೇಸಲ್ಲಿ? CC 290.
PCR.
We filed a PCR, Millets, against the very complainant himself. Produced a page
ಯಾವ್ದು
number. PCR number 2.
PCR 86 of 22.
Yes, ma'am.
Yes, ma'am.
ಅದೇನಾ?
Produced page number 379.
ಯಾರು ಕಂಪ್ಲೇಂಟ್ ಅದರಲ್ಲಿ?
I am the complainant
against him.
Against him.
Against me. The B report.
ಅದರದ್ದು ಮಿಸ್ ಆಗ್ಬಿಟ್ಟಿದ್ಯಾ?
Entire report.
ಅದರದ್ದು ಮಿಸ್ ಆಗಿದೆಯಾ?
Also, because they don't want to produce these documents before the CBI case which is pending before the honorable Madras High Court.
CBI ಬೇರೆ ಇದೆಯಾ?
Also,
Against him, Millets, CBI has filed a
Yes.
charge sheet.
not only me, my lord.
Complaint.
This is what
Clear
the
allegation.
misrepresentation by the learned counsel.
Entire file is missing.
Entire files.
The registry by telephonic instruction is directed to secure the entire records before the third additional civil judge. ಎಲ್ಲಿ ಆನೇಕಲ್? Civil judge Anekal. In PCR 86 of 2022.
First additional.
First additional. In PCR 86 of 2022, records, I mean, the entire records by the next date of hearing, list on 11th.
Except on 11th.
ನಿಮ್ಗೆ ಯಾಕೆ ರೆಕಾರ್ಡ್ಸ್ ನೋಡಕ್ಕಷ್ಟೇ, ನೀವೇನೋ ಸಿಗ್ತಾ ಇಲ್ಲ ಅಂದ್ರಲ್ಲ.
ಒಂದ್ ದಿವಸ ಬಿಟ್ಟು ಏನಾದ್ರು ನೆಕ್ಸ್ಟ್
12 Saturdays.
14th 11th ನಾನು ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್ ಇದ್ದೀನಿ.
ಪರವಾಗಿ ನೀವಿರೋದು ಬೇಕಾಗಿಲ್ಲ, ರೆಕಾರ್ಡ್ಸ್ ನೋಡ್ಬೇಕಷ್ಟೇ. ಅವ್ರು ಇಲ್ದೇ ಇದ್ದಾಗ ನೀವು ಒಂದು ಆರ್ಡರ್ ಮಾಡಿಸಿದಿರಲ್ಲ, ನೀವು ಇಲ್ದೇ ಇದ್ದಾಗ ಒಂದು ಆರ್ಡರ್ ಮಾಡೋಣ.
ಅವ್ರು ಇಲ್ದೇ ಇದ್ದಾಗಿಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರ ಕಲೀಗ್ ಅಪಿಯರ್ ಆಗಿ
ನಿಮ್ ಕೊಲೀಗ್ ಕಳಿಸಿ. Yes. Interim order subsisting will continue to the next date of hearing.
5.
ಅದು ಎಷ್ಟು ಪವರ್ಫುಲ್ ನೋಡ್ಬೇಡ ಅಂತ ಅಷ್ಟೇ, ಅದೇನೋ ಹೇಳಿದ್ರಲ್ಲ.
ಸ್ವಾಮಿ ಇದು ಈ ಕೇಸಲ್ಲಿ ತಾವು ಹೇಳಿದ್ರೆ ನಾವು ಬರೀ ಬಿಹಾರ್ ಪಿಕ್ಚರ್ಗಳಲ್ಲಿ ನೋಡಿದ್ವಿ.
ಬಿಹಾರ್ ಪಿಕ್ಚರ್,
ಬಿಹಾರ್ ಹಿಂದಿ ಪಿಕ್ಚರ್ಗಳಲ್ಲಿ ಯಾವ ರೀತಿ ಒಬ್ಬ
ಯಾವ್ದು
ಮೇಲೆ
ನೋಡಿಲ್ಲ.
ಇಲ್ಲಿಗಲ್ ಆಗಿ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ
ಬಿಹಾರ್ ಅಂತ ಪಿಕ್ಚರ್ ಇದೆಯಾ?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಬಿಹಾರ್ ಈ ಸೈಡ್ ಅಲ್ಲೆಲ್ಲ ನಡೆಯುವಂತದನ್ನ ಸ್ಟೋರೀಸ್ ಏನ್ ತೋರಿಸ್ತಾರೆ
ಎಲ್ಲಿ?
ಸೇಮ್ ವಿತ್ ಅದೇ ರೀತಿ ನಮ್ಮ ಇದ್ರಲ್ಲಾಗಿದೆ.
ಸೈಡ್ ಅಲ್ಲಿ ನಡೆಯೋದು.
The respondent number 2 was taken illegal custody by the Krishnagiri police and he was subjected to harassment for more than 2 years to get 2 days to get cancelled the MOU which has been submitted. That's what the brief be report before this honorable.
CBI ನಿಮ್ಮ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರಲ್ವಾ?
ಸ್ವಾಮಿ ನನ್ನ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿರ್ತಕ್ಕಂಥದ್ದು it is because of the conduct of the petitioner.
ಪರವಾಗಿಲ್ಲ.
Petitioners ಏನ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ
That's
they
all right.
forged the document.
No, don't worry. Both of you are in glass houses. Don't throw stones against each other. Come on, 11th. Yes.
Much.
Lord, the petitioner is accused number 7, accused number 1 to 6
ಕೊಡಿ.
proceedings are passed.
Yes, Jagdish.
KP Act, my lord, 155 to violation.
Page.
I have
Then
to-
judgment. The petitioner is accused number 7, accused number 1 to 6. This court has quashed the proceedings in so and so. The learned counsel appearing for the petitioner submits the reasons so rendered, while quashing the proceedings against accused number 1 to 6 would squarely become applicable to the facts of the case at hand, accused number 7 as well. This court has held as follows. In the light of the order passed, accused number 6, the petitioner stands to benefit with the same order.
Bless.
ಅಲ್ಲೇ ಸೇಮ್ ಅಲೋಡ್ ಕಾಸ್ಟ್ ಮಾಡಿ ಅಲ್ಲಿ ಕೋಟ್ ಮಾಡ್ಬಿಡಿ, ಫುಲ್ ಆರ್ಡರ್ ಮಾಡ್ಬಿಟ್ಟು ಅಲೋಡ್. ಎಸ್.
Petitioner's counsel. The submission is this, not the relevant portion is produced order
ಬೈ
sheet.
ಮಿಸ್ಟೇಕ್ ಬಂದ್ಬಿಟ್ರೆ ಇಲ್ಲಿ ಬರೋದೇ ಇಲ್ಲ ಈಗ. ಎಸ್.
Lord, on 19/11/2024, my lord,
ಏನು ಆಫೀಸ್
interim order has been granted. My lord, the relevant portion of the order sheet has been produced.
ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಏನಾಗಿದೆ?
My lord, during the
ಪಂಪು ಎಲ್ಲ
my lord, during the pendency of the case, my lord, interim order was subsisting. They filed charge sheet. Therefore, we withdrawn that petition, my lord, and now filed fresh petition.
ಅದಕ್ಕೆ ಇಲ್ಲಿ ಬಂದಿರೋದು.
My lord, on 19/11/24,
ಏನ್ ಒಫೆನ್ಸ್?
interim order was granted. 153, my lord, the corresponding.
153 ಏನ್ ಮಾಡಿದ್ರಿ?
Lord, one person, my lord, give a challenge to the petitioner that if you come to a particular place,
ನೋಡ್ಕೊಂತೀನಿ.
then they went there
ಹಾ,
and
ನೋಡ್ಕೊಂಡ್ರಾ?
held a sabha there.
ನೋಡ್ಕೊಂಡ್ರ?
ಅದಕ್ಕೆ ಒಂದು ಇನ್ನೊಬ್ಬರ ಹತ್ರ ಕಂಪ್ಲೇಂಟ್ ಹಾಕ್ಸಿದ್ದಾರೆ ಅಷ್ಟೇ. They should have taken action against the person whom my lord gave challenge and incited this my lord mob. This is what happened, my lord. But
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದೀರಾ?
ಅಲ್ಲ ಇವರೇ ಚಾಲೆಂಜ್ ಕೊಟ್ಟವರು.
ನೀವೇ ನೋಡ್ಕೊಂತೀನಿ ಅಂತ ಹೇಳಿದ್ದ?
ಅಲ್ಲ ಅವ್ರು ಹೇಳಿದ್ದು, ಅವರು ನೀವು
ನೋಡ್ಕೊಳ್ತೀವಿ ಅಂತ.
ತಾಕತ್ತಿದ್ರೆ ಬನ್ನಿ ನೋಡ್ಕೊಳ್ಳಿ.
ಆಯ್ತು, ಅವರು ಬರ್ಲಿ, ಇಬ್ರು ನೋಡ್ಕೊಳ್ಳೋರು. ಎಸ್. The heard the learned senior counsel Arun Shyam appearing for the petitioner. During the subsistence of the interim order in criminal petition?
In criminal petition number 11394 of
2024, the investigating officer had filed his charge sheet and therefore the petitioner is withdrawn the petition and presented the subject petition calling in question the charge sheet so filed. The learned senior counsel would submit that the interim order was subsisting at the time when the petition was pending at the stage of crime. Even otherwise, the issue in the list is concerning offense under section 153A. VNSS alva? VNS alva?
VNSS ಅಲ್ಲಿ
189, 190, 191, 352 and 351 and 352 of the BNSS, which would be 295A na idu? 153A, 504, 506 of the IPC.
43, 142, 143.
143 ಯಾವುದು? 189 191?
191 is the 153.
153 ಬೇಡ, ಇಲ್ಲೇ ಬರ್ಕೊಳ್ಳಿ. A perusal at the summary of the charge sheet on the face of it would not indicate the ingredients of the offenses being present in the case at hand. ಅದು ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ
ಸ್ಪೀಚ್ ಮಾಡಿದ್ದಾರೆ, ಅಲ್ಲಿ ಹೋಗಿ ಸ್ಪೀಚ್.
ಏನ್ ಸ್ಪೀಚ್ ಮಾಡಿದ್ರಿ? ಪ್ರಚೋದಕಾರಿ ಹೇಳಿಕೆ ಏನ್ ಮಾಡಿ?
ಕರ್ದವನಿಗೆ 2 ಬೈದಿದ್ದಾರೆ. ಕರ್ದವನಿಗೆ 2 ಬೈದಿದ್ದಾರೆ, ಚಾಲೆಂಜ್ ಮಾಡೋದವನಿಗೆ. That is the allegation. He set up one more person, my lord, to file a complaint.
ತೊಂದರೆ. In that light, there shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing. emergent, one additional SPP, two emergent notice returnable by the 31st July. 31st for Friday, no, sorry, 1st August. Non-filing of acknowledgement, Ketan.
ಟ್ಯೂಸ್ಡೇನೆ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ, ನಿನ್ನೆ ಸೇಮ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಆಗಿತ್ತು, ಪ್ರಿಲಿಮಿನರಿ ಲಿಸ್ಟ್ ಮಾಡಿ ಅಂತ ಡೈರೆಕ್ಷನ್.
Post the matter for admission on next Thursday.
Please,
The Learned Council submits, needful has been done, office to verify and post the matter on next Thursday, 10th. Next.
8.
Respondent.
Non-furnishing of, argument ನಿಂತ್ಕೊಂಡ್ರಿ ಇಬ್ರು ಬಂದಿರೋದು ಆರ್ಡರ್ಸ್ಗೆ. Non-furnishing of FPF.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ತಾವು ಎಸ್ಟರ್ಡೇ ಅದು ಆರ್ಡರ್ಸ್ ರಿಫ್ಲೆಕ್ಟ್ ಆಗಿಲ್ಲ, ತಾವು ಕ್ಲಿಯರ್ ಮಾಡಿದ್ದೆ ಅದೆಲ್ಲಾನು. And your lordship also directed the matter to come up in the admission.
Correct. Why did it come now like this?
Maybe some mistake.
List the mat. FPF R2 ಯಾರ ಪೇರ್ ಆಗ್ತದೆ?
I prefer R2 Miller.
This court on 3/7 ನೆನ್ನೆದ ಇದು. Yes, ಆಗಿರಲಿ. List the matter on 10th in admission. Yes.
9.
I appear for this. Well, this is that service benefits, my lord.
Jafar, you are here.
I think, my preliminary instructions from the department are this, my lord. They have not made an application to us directly. They have come here before the court seeking for a modification.
Representation ಕೊಟ್ರೆ ಮಾಡ್ತೀರಾ?
Yes, sir. Your lordship may also kindly observe, whoever are the beneficiaries, let them make an application along with the necessary documents. We will consider.
Seek instructions and come. I'll pass it over. ಸಾಯಂಕಾಲದೊಳಗೆ ಆರ್ಡರ್ ಮಾಡಿ, ನಿಮ್ಗೆ ಯಾವಾಗ ಫ್ರೀ ಆಗ್ತೀರಾ ಅವಾಗ ಬನ್ನಿ.
Yes, grateful.
10.
Furnishing of FPF. R5, 9 and 10.
Please, my lords, this matter was listed on, my lords, 18/6/2025, my lords, again on 27/6/2025. My lords, the respondents are the plaintiffs before the trial court, being represented by Shri CK Manjunath, my lords. Now wakalat has been filed only for respondent.
CK Manjunath ಸರ್ವ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ.
ಸರ್ವ್ ಮಾಡಾಗಿದೆ ಸರ್. ಮಾಡಿ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಕೂಡ ಫೈಲ್ ಮಾಡಿದೆ.
ಈಗೇನು ಎಂಟ್ರಿ ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ ಸರ್.
ಈಗ ಕೊಡೋಣ ಬಿಡಿ, ಬರ್ತಾರೆ ಅವಾಗ. Yes.
I am for the R1, 2, 3, 4, 6 and 7, my lords.
What is the issue?
My lords, the application filed for amendment came to be allowed, my lords. Suit was initially filed for the relief of declaration and permanent injunction.
ಈಗೇನು partition ಕೇಳಿದಾರಾ?
Partition ಅಲ್ಲ ಸರ್. Declaration to declare that the plaintiffs are the owners of.
ಈಗ ಏನು amendment ಏನು?
Amendment to possession ಕೇಳಿದ್ದಾರೆ. In the alternative, if the court finds that the plaintiffs are not in possession of the scheduled property, to direct the defendants to hand over the possession of the scheduled property.
Contradictory.
Prayers.
ಅದನ್ನ allow ಮಾಡಿದಾರಾ?
ಅದನ್ನ allow ಮಾಡಿದ್ರು.
The petitioners are the defendants. The respondents, the plaintiffs. A suit for declaration and possession is preferred in OS 241 of 2016. Issues are framed on 24/6/2017. Evidence was on and the trial was at the stage of conclusion. An application comes by the plaintiff seeking amendment of the plaint and the prior by incorporating an alternate prior. In the event the plaintiffs would not succeed in declaration and possession, a direction to hand over possession of the property should be direction for possession, hand over the property to the hands of the plaintiffs should be granted. The prior, notwithstanding the fact that is contradictory to what is already prayed, it is at the fag end of the trial. The concerned court ought not to have entertained this application, and allow it. Therefore, there shall be an interim order of stay of the order dated, order date 27/9/2024 till the next date of hearing. It is made clear further the trial before the concerned court is not stayed except the order dated 27/9/2024. Yes.
11.
Awaiting service. Post immediately after service of notice upon the respondents. 11 ಯಾರ್ದು?
Lords, I am appearing for the respondents. in this.
First respondent, R1 to R9 ನೀವೇನಾ?
Yes, my lords.
Learned, series name is it?
Please, madam.
Learned counsel Srimati Siri R accepts notice for R1 to R9 in all the cases?
Please.
My lord, I appear for the petitioner, my lord, serial number 11.
ಅಲ್ಲ, ಒಂದು ನಿಮಿಷ. ಏನಾಗಿದೆ ಇಲ್ಲಿ? ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀವಾ?
Yes, please.
How the status quo has been directed, madam.
ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಕರೆಕ್ಟಾ?
ಹೌದು. 11 in all the 4 matters, my lord. 11, 11.1, 11.2 and 11.3.
ಅಲ್ಲ, ಒಂದರಲ್ಲಿದೆ, ಎಲ್ಲದರಲ್ಲೂ ಕೊಟ್ಟಿದ್ದಾರೆ.
This one.
My lords,
And my lord,
the challenge is to compromise which has been settled before the Lok Adalat. No doubt, my lords, the writ petition is maintainable.
Please,
But
yes.
the question is when the allegation of fraud is made, lords, there are at least 2 judgments of the coordinate bench which takes the view that such are the matters which has to be relegated before the civil court because establishment of fraud requires an inquiry.
Evidence, yes.
That is all. That is the only point. If your lords were to take it up,
there are judgments of this honorable
hurdle is
court
crossed, my
also-
lords, then you will have to argue on the merits otherwise.
Yes.
My lord, question when a matter is, my lord,
I'll take it on Friday.
Please, my lords.
Yes.
Okay.
So list the
Next
matter on 11th in preliminary hearing.
my lord, if my learned friend is appearing for all the respondents in all the matters, my lord.
All the respondents in all the cases.
Yes, please. Grateful.
Copy
Interim
the-
order may be extended in all the matters, my lord.
Interim order stands extended till the next date of hearing.
Great.
Great.
ಇವತ್ತು ಬಂದಿದ್ದೀರಾ?
I
My lord, this is a
undertaking
disposed
affidavit,
matter.
my lord. It's filed in the counter also.
ಕೊಟ್ಟಿದ್ದಾರೆ undertaking.
Copy ಕೊಟ್ಟಿದ್ದಾರೆ, but this is a disposed of matter and there was a modification of the order.
Modification ನೀವು
Modification ಏನಂತ ಆಗಿತ್ತು ಅಂದ್ರೆ possession to be handed over after 4 lakhs is paid. And then affidavit saying when the balance amount shall be clear. That is what.
Undertaking ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
ಅವ್ರು ಇವಾಗ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂದ್ರೆ if the matter is, if the account is regularized, they will pay the EMIs regularly ಅಂತ affidavit ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಕೌಂಟ್ ಕ್ಲಿಯರ್ ಆಗಕ್ಕೆ ಯಾಕೆ ಕೇಳ್ತಾ ಇದೆ? ಎಲ್ಲಿವರೆಗಿದೆ ಮೇಡಮ್?
ಅಲ್ಲ, ಇದು
20 ವರ್ಷದ ಲೋನ್ 2018
ARC, this ARC have already taken over the.
Right, ಈಗ EMI diligent ಆಗಿ ಪೇ ಮಾಡ್ತಾರಲ್ಲ, ಈಗ ARC has taken over. No problem. Now the account has become regular. No problem.
ಇಲ್ಲ, account ಇನ್ನು ರೆಗ್ಯುಲರ್ ಆಗಿಲ್ಲ. OTS settlement ಅನ್ನು we already gave on 16/1/2025, which they didn't even accept. They didn't pay anything under the OTS.
OTS ಬೇಡ. ನಾವು
ಬೇಡ?
EMI ಕಟ್ಕೊಂಡು ಹೋಗ್ತೀವಿ. 2018
The equitable order, let them at least.
20 ವರ್ಷದ ಲೋನ್ ಈಗ 5 ವರ್ಷದಲ್ಲಿ ತೀರ್ಮಾನ ಮಾಡಿ.
ಅಲ್ಲ, regularize ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಅಂತ. That is what my submission.
Whatever,
ARC is
you
already
take
taken.
recourse to law. Just undertaking, I will record it and close it.
Yes, my lord.
No modification in beda in the light of the undertaking. The subject petitions to disposed by an order dated 18/3/2025, the respondent bank has now preferred an application seeking modification of the interim order on the score that the petitioners have not undertaken as to when they would clear the loan amount. The learned counsel appearing for the petitioner, Srimati Sandhya Prabhu, would submit that the loan is for a period of 20 years and they are not willing to accept or seek any one-time settlement, but would diligently pay the amount to the bank, month on month. The affidavit of undertaking to that effect is also filed before the court. The affidavit of undertaking reads as follows. In the light of the affidavit of undertaking so filed, there is no necessity of modification of the order dated 18/3/2025. In the event the petitioners would breach the undertaking so filed, it is open to the bank to initiate steps in accordance with law. Yes. Ordered accordingly. Next. Post immediately after service of notice upon the first respondent.
Interim order.
Interim order continue ಮಾಡಿ ನಾನು ಹೇಳಿದೆ ಅದು. 14 same order. 14 Manu Kulkarni ಇದೆ.
I filed wakalat this morning. Serial number 14. Interim order.
Serial number 14 ಅಲ್ಲಿ ಇದ್ದಾರೆ, ಒಂದು ನಿಮಿಷ ತಾಳಿ.
I undertake to file wakalat for respondent 1 and 2.
ಯಾವ್ದ್ರಲ್ಲಿ?
14 serial number.
Learned counsel so and so undertakes to enter appearance for respondent 1 and 2. Counsel Manu Kulkarni submits that he has already entered appearance for the third respondent. Registry to print the respective names in the cause list as appearing for the respective respondents. ಏನಾಗಿದೆ ಅದರಲ್ಲಿ?
Kindly.
Pass on.
My lords have granted an interim order. It looks like respondent number 1 and 2 have complied. So, in fact, if it's a injunction suit, if there is no dispute, then the entire proceedings can be closed. But they have to.
Let them come on record.
Please.
We'll take it on 11th.
Please.
List on 11th, interim order subsisting will continue to the next date of hearing. 11th and preliminary hearing.
Milords, in serial number 15, Milords, I undertake to file wakalat for R1 and 2, Milords.
Manu,
Mr. T.N. Vishwanath.
this side.
Yes.
Learned Counsel T.N. Vishwanath undertakes to enter appearance for respondents 1 and 2. Registry to print the name of so and so is appearing for respondent 1 and 2. List on 18th. Interim order, yeah? Interim order subsisting will continue to the next date of hearing. Yes, next. Post immediately after service of notice upon the respondent. Interim order continue.
17.
Interim order idre continue agutte. Yes, sir.
17.
Rectification of office objections raised.
Can this matter not be taken off on Monday for final disposal?
Why final disposal?
Several dates have been taken.
No, I'll tell you, this was
Sir, this is
challenging.
the institution, my lord, the admission is problem is there.
I'll just point out, the suit what was filed by the other side may not survive. Because the matter has been referred to an arbitrator at the hands of this coordinate bench. And not even before the trial court, we had filed the same application under section 8, stating that this is an arbitrable issue, there's an arbitration agreement.
And we'll take it in preliminary hearing on Monday.
Even writ petition itself is not maintainable.
Our suit maintainable, writ petition maintainable. First court ಅಲ್ಲಿ ತುಂಬಾ ವರ್ಷದಿಂದ ಆಗಿದೆ ಹೇಳ್ಬೇಡಿ. Yes.
Fundable.
Notice to respond number 2 and 3 may be dispensed.
Learned Counsel with the petition submits notice to respondents 2 and 3 need not be issued on the score that no relief is claimed against them.
And the interim order
At the risk of the petition, issuance of notice to the respondents 2 and 3 is dispensed with. Interim order subsisting would continue to the next date of hearing. Next. 18. Post immediately after service. Learned Counsel Jai Prabhu accepts notice, undertakes to enter appearance for the respondent 1 to 4. Respondents 1 to 4. Registry to print the name of so and so is appearing for respondent 1 to 4. Next Friday.
But Milord, by going by prayer, Milord, he has to file CRP.
Could he?
Order 7, Rule 11.
No, that
Allowed.
application has not been disposed of.
Rejected.
That application is pending.
So CRP.
The only thing
if it
is
is allowed, then he had to file.
Inquiry has to take.
Ega. Consider the application order 7 rule 11.
Quashing the order.
ಏನ್ ಕ್ವಾಶಿಂಗ್
ಅದು ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಮಾಡಾಗಿದೆಯಾ?
ಮಾಡಿ ಆಗಿದೆ.
ಮಾಡಾಗ ಏನಾಗಿದೆ?
So it has been
ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಏನು?
ರಿಜೆಕ್ಟ್ ಆಗಿದೆ.
File a CRP.
ಇಲ್ಲ ರಿಜೆಕ್ಟ್ ಆಗಿಲ್ಲ ಸರ್. It was kept in abeyance. They said that inquiry has to take place. For that preliminary issue has been framed. I am on the point that on the face of it, by reading the plaint itself, it is clear that
11th. 11th. Next Friday, yes. So next Thursday, sorry, 10th. WP or CRP?
WP.
Under 11th, yes. Next. Next date, ಯಾವತ್ತಿದೆ ಹರೀಶ್?
I'm met to get.
Then 11th, yes.
ನಾಳೆ.
Take adjournment then, yes. On filing of copies.
Acknowledgement
Ponnappa, you have not done the needful?
Acknowledgement has been filed, my lord. And also
Cover for R8, my lord.
Learned Counsel
P.N. Harish.
Ravi Shankar.
P.N. Harish.
B.N. Harish, sorry. P.N. Harish undertakes to enter
Already filed, my lord.
submits that is entered appearance for respondents 1 to?
Respondent 8 only, others
8
discussed.
only now. Respondent number 8. Others are not contesting?
No, my lords, others are not contesting.
Dispense ಆಗಿದೆಯಾ? Then list the matter on Friday in preliminary hearing.
Matter is coming up on Tuesday, my lords. It was posted.
List on Monday in preliminary hearing. Yes. Now, Monday 7th. Next.
20.
For petition, I undertake to appear, my lords, for response, my lord.
Interim order ಇದೆಯಲ್ಲ? Yes.
Then interim order.
Learned Counsel
PH Virupakshaya. PH Virupakshaya.
So and so undertakes to enter appearance for the respondent 1 to 3.
1 to 3.
Petitioner to serve registry to print the name of so and so is appearing for respondent 1 to 3.
Copy of writ petition.
Kotilva?
I don't have a
Counsel to serve writ petition papers upon the counsel for respondent 1 to 3. Forthwith. List on 18th.
Interim order.
Interim order subsisting will continue to the next date of hearing.
21.
My lord, I appear for the petitioner, my lord. Lord,
Post immediately after service of notice upon respondents 3 and 4. Entry ಮಾಡಿದ್ರೆ continue ಮಾಡಿ.
Entry ಮಾಡೋದು.
Yes, next.
Public.
22.
Non-filing of acknowledgement having served.
Respondents 11 to 13. From yesterday it has been posted to today. For the simple reason, Panchayat Parikat is entered in 79. 89, the husband of the first petitioner signs as a witness to the sale deed, which is two sale deeds which are executed. You have produced that. Now in the year, property has changed hands. Now in the year 2023, they file a suit. They ask for
Suit for?
suit for partition after 46 years. And in that they ask for a relief of not paying the compensation. The court only says KDB has taken possession of the land. The trial court says status quo regarding possession. They don't file an MFA, they come before this court. They don't produce the sale deed. Whether we have produced the sale deed, we are producing a
What is the
better
prayer,
copy
sir, in
also.
this suit?
Same relief.
Prayer. It's at page
Page 30, come.
20,
Sorry, 29.
28.
When declare the plaintiff entitled to 1/3 share joint respect scheduled properties. So on.
May I make one submission?
Compensation amount, third.
8 to 10.
And declare the sale deeds. They don't give the details here.
Which sale deed?
Sale deed is
Dated?
27/12/1989.
Sorry?
27/12/1989.
Where is that said in your plaint or prayer?
It's in the pleading we have taken, my lord.
It's all right. Where is the prayer to that effect? Declare the plaintiffs are entitled to suit schedule. Yes, sir. Very tricky way of presenting a plaint.
My lords, may I make one submission?
Yes, sir.
That's in the statement of objections. Lordship may kindly peruse page number 9, my lords. In that.
Yes, you enter ಮಾಡಿದ್ಯಾ ಇದರಲ್ಲಿ?
ಇದೆ, not to disperse the compensation. Lordship has got it, my lords. Page number 9.
Statement of objections, tell me, sir.
Statement of objection, page number 9, my lords. That is the last page of the sale deed. The lordship has got.
Sale deed?
Yes, my lords.
Original ಇದೆ, sale deed.
ಕೊಡಿ, ಅದು ಇಸ್ಕೊಳ್ಳಿ ಮೇಡಮ್. Now, who are you?
My lords, I am the LRs of KM Anjanappa. Please, what has happened in this? Let's in one
minute.
sale deed.
Yes, sir.
Page 14, please. Chikkananjappa.
Page 14.
Chikka Anjanappa.
ಯಾವ 14? Which
Page-
14?
Page 14.
Of
ಇವಾಗ ಕೊಟ್ನಲ್ಲ ಅದ್ರ.
page 14 ಇಲ್ಲ ಇಲ್ಲಿ. ಇದ್ರ last. Ink page is it?
Ink page 14. Sorry.
Yes.
Chikka Anjanappa, ಆರನೇ witness.
Well, it's
Both
a
the
forged-
two sale deeds are executed in both.
No,
This is
Both he is the
sale deed,
witness.
is it?
Sale deed, ಹೌದು.
well, it's a forced signature, my lords.
Forged.
It's
Thank you.
absolutely.
Yes, ಆಮೇಲೆ
My lords.
ಇವಾಗ ಕಾಂಪನ್ಸೇಷನ್ ಬಂದಾಗ ಜ್ಞಾನೋದಯ ಆಯ್ತಾ ಫೋರ್ಜ್ ಆಗಿದೆ ಅಂತ?
ಇಲ್ಲ, my lords.
ಮತ್ತೆ
My lords,
ವಾಟ್ ಪ್ರೊಸೀಡಿಂಗ್ ಹ್ಯಾವ್ ಯು ಯಾವ ಡೇಟ್ ಏನಿದೆ ಸೇಲ್ ಡೀಡ್?
sale deed 27/12/1989.
8/12/1989, two sale deeds. Both he has signed.
8/12/1989.
Produce the Panchayat Parikat also, he has signed that also.
Page?
Page 1. Page
1.
1. ಕೆಳಗಡೆ ಚಿಕ್ಕ ಅಂಜಿನಪ್ಪ.
Now, who is Chikkanjanappa?
He is the husband of the first petitioner and father of petitioners 2 and 3.
Oh, he's no more, is it now?
He's no more.
No more. 99 he dies.
Yes, sir.
My lords, page number 9, my lords. Lordship. This is the another sale deed which they have produced, my lords.
Page number 9.
9 of the statement of objection, my lords.
Page number?
9.
Which is this sale deed?
Certified copy.
There are two sale deed, my lords.
Correct.
One is to the extent of 9 acres. Another is to the extent of 10 acres. My lords. In the 9 acres, my lords, they have written the name of KM Chikkanjanappa and they have strike it down, my lords.
Where is that?
Page
strike?
number 9, my lords.
Page number 9.
Please, my lords. Of the statement of objection, my lords.
ಚಿಕ್ಕಾಂಜನಪ್ಪ ಕೊಡದಾಕಿದ್ದೀರಾ?
ಹೊಡೆದಾಕಿದ್ದಾರೆ sir. Subsequently, my lords, there is one more. Now they have inserted KM Chikkanjanappa name.
Where?
In the 10th line, my lords, there only.
ಅದೇ ಪೇಜ್ ಅಲ್ಲ?
ಅದೇ ಪೇಜ್ ಅಲ್ಲಿ.
ಎಲ್ಲಿ ಇನ್ಸರ್ಷನ್ ಇದೆ?
ಇಲ್ಲಿ. I may be permitted to.
ಚಿಕ್ಕಾಂಜನಪ್ಪ ಹೊಡೆದಾಕಿರೋದು ಕಾಣ್ತಾ ಇದೆ.
Subsequently, the second line, my lords. The second line.
Read writer license. ಇಲ್ಲಿ ಎಸ್ ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ.
Yes, my lords.
KM ಚಿಕ್ಕಾಂಜನಪ್ಪ ಅಲ್ಲಿ ಹೊಡೆದಾಕಿದ್ ಯಾಕೆ, ಇಲ್ಲಿ ಮತ್ತೆ ಬರ್ದಿದ್ ಯಾಕೆ?
Please, let they have to
Certified
answer,
copy.
my lords. My lords, with respect to the limitation in this.
No, this is written in the books. Now where is the sale deed itself?
ಕೊಟ್ಟಿದ್ದೀವಿ.
ಇದೇನಾ?
Same thing, 1703. Original ಕೊಟ್ಟಿದ್ದೀವಿ, color xerox.
ಇದರಲ್ಲಿ ಹೊಡೆದಾಕಿದಾರಾ?
ಇಲ್ಲ. ಅದಕ್ಕೆ ಇದು.
My lords, it's a forged
Page number
document, my
14.
lords.
Page number 14 and.
ಅಲ್ಲ ಅಲ್ಲಿ ಹೊಡೆದಾಕಿದಾರೆ ಪರವಾಗಿಲ್ಲ.
ಅಲ್ಲ my lords.
ಒಂದ್ ನಿಮಿಷ ಹೊಡೆದಾಕಿದ್ರೆ ಪರವಾಗಿಲ್ಲ. ಬೇರೆ ಪೇಜ್ ಅಲ್ಲಿ ಬಂದಿದ್ರೆ ಅಲ್ಲೇ ಇದೆ ಕೆಳಗಡೆ ಮತ್ತೆ.
ಅಲ್ಲ my lords.
ಏನು? ಅಲ್ಲಿ ವಿಟ್ನೆಸ್ ಅಂತ ಸೈನ್ ಮಾಡಿರೋದು ಹೊಡೆದಾಕಿದ್ರೆ ಕೆಳಗಡೆ ವಿಟ್ನೆಸ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ.
ಅಲ್ಲ, there is one more.
ಏನು ಅದರಿಂದ ವಾಟ್ ಹ್ಯಾಸ್ ಬಿಕಮ್ ಆಫ್ ದಿಸ್? ನಥಿಂಗ್.
No, my lords.
And it is written by the writer there. This is registry entry idu. It's a certified copy. This is original here.
Please, my lord. But it's a forged documents. That's what we are.
What
alleging.
is forged in this?
The signature itself, my lords.
Which
because
signature?
He's the illiterate, my lords. The signature is in English. My lords, with respect to. With respect.
ಪಂಚಾಯತ್ ಪರಿಕತ್ತಲ್ಲೂ ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಸೈನ್ ಮಾಡಿದ್ದಾರೆ. Page 1.
KM
Chikkanjanappa.
The first document produced today, even in that he has signed in English.
KM Chikkanjanappa.
That's also forged signature, my lords. My lords, with respect to. My lords, with respect to the limitation period.
No, these are 1989 sale deeds.
Please, my lords.
What is that you are claiming now?
I'm claiming a share in that property, my lords.
Which property?
Shoot schedule property.
ಸೇಲ್ ಡೀಡ್ ಆದ್ಮೇಲೆ ಸೂಟ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ನೇಚರ್ ಏನಾಯ್ತು?
It's the same, my lords. It's agriculture.
It's agriculture only. So where are you there? In the suit schedule property,
Please.
what is that you're claiming and how are you placed from 1989 to 2022? ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
My lords, we were not aware of the entire transaction itself, my lords. We're not aware. Only after when my father died, then we went to the defendants. We asked for a share in this.
1999.
No, my lords.
Your father died in 99.
99. Correct.
99. ಆಮೇಲೆ?
No, my lords.
When did he
recently
die?
died, my lords.
Recently?
Yeah, 2020.
ಈಗ ಇದು ಸೇಲ್ ಡೀಡ್ ಆದ್ಮೇಲೆ
Please.
purchasers did not come into possession of the property?
No, they were in.
They were in possession. What were you doing?
Lords, we were not aware of it.
Our purchasers ಬಂದು ಪ್ರಾಪರ್ಟಿ ಕೂತಿದ್ರು, you were not aware.
We were not aware of the entire transaction.
Then how did the purchasers come ಅಂತ ಗೊತ್ತಾಗ್ಲಿಲ್ವಾ?
ನಮ್ಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ.
ಅಯ್ಯೋ.
And in the plaint there is an averment.
Compensation ಬಂದಿದೆ ಅಂತ ಇವೆಲ್ಲ ಸ್ಟಾರ್ಟ್.
No, my lords.
Anything else, sir? We'll dismiss with costs.
No, my lords. It's one suggestion, my lords.
Suggestion? I don't take suggestions.
My lords, one.
Yes. Only decision.
Let's one submission. Let's.
Submission. Yes.
Let's. Ultimately, the SLO has to decide the issue.
SLO will not decide anything. They're all bogus claims, springing after 40 years.
Let's with
Some sale deed agide in your property, somebody else is there for the last 35 years, and you're absolutely silent. Now, when compensation comes, you want a claim in that. These kind of suits are filed, sir, many a time on compensation. This is one such breed. When compensation springs, everybody spring. Allivargu ಏನು ಗೊತ್ತೇ ಇರಲ್ಲ. Anything else? Anything else? I will withdraw or impose costs.
I'll withdraw.
Yes. Counsel for the petitioner, after arguing the matter at length, seeks leave of this court to withdraw the petition. Petition dismissed as withdrawn.
Deeply obliged.
Yes.
Shows my name for respondent number 2 million in cause list.
Then withdraw ಮಾಡಕ್ ಬಿಡಬಾರ್ದಾ?
My lord, in cause list, my
Ah.
name is shown for example number 2.
You are not
but
appearing.
My lord, it is KIDB acquisition, my lord. My lord, it's,
No problem.
name is reflecting this.
GS Prasanna Kumar ಇದಾರಲ್ಲ ಅವ್ರು ಇವ್ರಿಗೆ registry to delete the name of Shilpa Shah as appearing for second respondent.
2 and 3.
ನೀವು ಇದ್ದೀರಲ್ಲ ಸರ್ ಆಲ್ರೆಡಿ.
Grateful.
23.
Lordship, on the last day, the petitioner was present before the court, but the PO was on leave, Lordship.
Huh?
The presiding officer, the trial court judge was on leave on the last day.
On leave?
Yes, Lordship. Also, I made a wrong submission on the last day, Lordship. The date was on 1/7. By mistake, I told 2/7, Lordship. The order, trial court's order date is.
A week's time is granted to do the needful. Interim order subsisting will continue to the next date of hearing.
Great.
Next.
54.
What's the challenges to the
Yes, Vachan.
below the challenges to the
What
decree,
maintainability?
although I've approached this writ jurisdiction instead of filing an appeal before the
What are you challenging?
my lord, the judgment, my lord, which has been
What
fraudulently
judgment?
obtained. My lord, suit for declaration and possession has been decreed.
Decreed?
My lord. Decreed.
File an appeal.
My lord, may I
Anything
submit?
else?
May I just submit this?
Yes, sir.
I pass on the judgment.
ಕೊಡಿ ಎಲ್ಲದಕ್ಕೂ JMCPC ಹಾಕಿದ್ರೆ ಕೊಡಿ
Maintainable.
ಯಾಕೆ
Reported judgment. my lord. This is also
ಲೋಕ
a
ಅದಾಲತಲ್ಲಿ ಆಗಿದ್ದ
compromise decree, fraudulently.
ಕಾಂಪ್ರಮೈಸ್ ಡಿಗ್ರಿ ವೇರ್
Lok Adalat, but then along with the court. Court has,
23 ಅಲ್ಲೇ ಹಾಕಿ
may I just read
Yes,
one
sir.
paragraph? May I read one paragraph?
ಹೇಳಿ.
Paragraph number 17, my lord, page
Yes,
number
sir.
4. It is to be borne in mind that every presiding judge of a court of the Lok Adalat or the Lok Adalat shoulders an onerous duty of finding out if the terms of the compromise are lawful, and in a suit for declaration of title to find out whether the person in whose favor declaration is sought has got a valid title to the property or not. My lord, my case
If
here
it
is
is Lok Adalat, I will entertain. If it is compromise recorded by the court under 23 ಅಲ್ಲಿ ಅಲ್ಲೇ ಮಾಡಿ.
it is neither
Anything
of the,
else, sir?
it's an adjudication, my lord, on merits. The
Then file
defendants
an
were placed
then file an
ex-
appeal, sir.
defendants were placed ex parte, my lord. May I just take your merit for a
File an
moment?
appeal.
May I just say this, my lord? May I read this paragraph fully, ma'am?
Much water has flown after that judgment, sir, by the apex court, plethora of judgments. You have not seen?
2012-14 judgment, my lord.
Correct, sir. ಇವಾಗ 25 ಅಲ್ಲಿ ಇದೀವಿ. 11 ವರ್ಷದಲ್ಲಿ ಬೇಕಾದಷ್ಟು ಬಂದಿದೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್.
Fraud has been played on.
ಕರೆಕ್ಟ್, ಅದಕ್ಕೆ ಹೇಳಿದೆ 23
Supervisory jurisdiction.
No, sir. 23 go before the same court. If it is challenged in the decree on its merit, go before the
I'm
appellate
not a
court.
party there, my lord.
No problem.
I'm not a party.
So all right, then.
There's an earlier suit pending. my lord.
File 23 sir.
There's an earlier suit pending without disclosing that suit. In the RTC also, my lord, the name of my vendor is
It is a judgment and decree. How are you challenging it in GMCPC unless it is a judgment decree born out of a Lok Adalat compromise?
My lord, but the decision, my lord, by this honorable court says that where, my lord, a decree is obtained by playing fraud on the court, the GMCPC petition was entertained, my lord. If there is no fraud involved, my lord, if there are other terms,
Everybody will tell fraud is there, sir.
I'll disclose, my lord, why there is fraud. I'll just
That
place it for
needs
your
evidence, sir.
may not be, my lord, may not be. I'll just say this.
If you are wanting a decree to be annulled by way for on the allegation of fraud, it needs evidence.
What has been done here, my lord, is that I'm not seeking annulment. The matter was remanded back to the trial court for the purposes of reconsideration, my lord. It was not, my lord, set aside as it is, my lord, without there being any reprieve or an appeal to be filed. Lordship, I kindly see the observations made, my lord. Writ petition is allowed, impugned order set aside, suit is restored back to file, and the trial court
Same between the same parties, sir. Justice N. Kumar ಅವ್ರದ್ದು.
Parties are different. I'm using this as a precedent. The third relief, my lord. Suit is restored back to file, and the trial court shall proceed with the suit on merits after adding the petitioner herein as a party.
You are not a party. Who are you?
My lord, I am the present owner of the property, my lord.
Present owner.
Present owner of the property. Now, what has happened?
What is the suit for?
Suit for declaration, my lord, to redemption mortgage, and my lord, to put the plaintiff back in possession of the property.
What is the relationship between you and the plaintiff?
I have no relationship. I have no relationship.
Then how are you saying you're in possession of the property?
By virtue of a sale deed, my lord.
Where is the sale deed?
My lord, I produce a sale deed, my lord, at page number 36, my lord, annexure C. That is my vendor sale deed, my lord. Subsequent thereto, my lord, my sale deed, lordship will find it at Page number 49. my lord.
Keeping open the issue of maintainability, list the matter on Monday in preliminary hearing.
My request for a stay, my lord. Our property hತ್ರ ಬಂದ್ಬಿಟ್ಟು they try to take possession of the property. They have filed an execution also. my lord.
ತೊಂದ್ರೆ ಇಲ್ಲ sir.
ಅಲ್ಲ,
List
execution
on
ಒಂದೇ-
Mondays, Monday.
I just place it.
Monday sir.
What is happening, my lord? I just place it for your lord.
Ready? ತೊಂದ್ರೆ ಇಲ್ಲ. Yes.
ಅಲ್ಲ, may I just say
Place it in the file.
ಅಲ್ಲ, ಏನಾಗಿದೆ ಇಲ್ಲಿ?
No, I am not
What is-
convinced about maintainability itself.
ಅಲ್ಲ,
Yes,
what-
Monday.
My lord, may I just say this? I just say this. What is happening, my lord, is that a suit for declaration, my lord, is a suit in rem, my lord. It's in personam, it's not in rem.
Correct.
But my lord, I am not in a position to explain that to the local police or the local people, that it's in a suit in personam, I am not a party, it can't be executed against me. People came near the property, wanted to dispossess me. I'm not in a ability to protect my position. The court is in Anekal, my lord. The manner in which the decree has been passed, I can take my lord to the judgment. The RTC is produced as marked as exhibit P4. The RTC marks my vendor as the current owner of the property, my lord. In spite of that, my lord, the learned trial judge proceeds to pass a decree, my lords. The defendant remained ex parte. The defendants, my lord, were the mortgagees in the suit scheduled property in the year 1967, my lord. Their father was a mortgagee. These people are this grandfather was a mortgager. They remain ex parte. It's a collusive decree. And now, my lord, they come near the property, they place a big board near the property and say, the suit has been decreed, possession has been ordered to be given to
When
me.
was the decree?
Decree, my lord, was passed on 29/4/25. And they've already filed an execution, my lord. Lordship may kindly say they've already filed an execution. Execution is at page number 12. And my lord, Lordship may kindly see notice has already been ordered to the respondents. Respondents will not appear, my lord.
Keeping open the issue of maintainability of the subject petition and owing to the urgency projected by the petitioner, the impugned judgment and decree shall remain stayed in the light of the judgment rendered by the coordinate bench in so and so till the next date of hearing. Petitioner shall serve on the counsel representing the defendants or serve the defendants by way of hand summons. Serve the plaintiffs by way of hand summons. Plaintiffs thane?
Plaintiff.
By way of hand summons. List the matter on 10th.
Obligation, my lord.
Yes. Serve ಮಾಡಿ acknowledgement ಹಾಕಿ.
Please.
Monday ಇಲ್ಲಾಂದ್ರೆ entry order 10th vacate ಮಾಡ್ತೀನಿ.
Please, my lord.
25.
But so, I appear for the petition in this case, my lord. Insofar as the office note is concerned on the council submission, I may be permitted to serve a copy of the petition on the panel council of BESCOM. Respond number 3.
Your lordship, I have instructions to accept notice for respondent number 3 BESCOM in this matter, your lordship.
What's your name?
Shahbaz Hussein's name may be reflected.
So and so accepts notice for the third respondent BESCOM. ಇನ್ಯಾರಿಗೆ ಕೊಡ್ಬೇಕು?
The other respondents are private parties, my lords.
List on Monday in
Lords, I have
preliminary
sought
hearing.
for an interim prayer, my
Monday
lords.
in preliminary
No, my
hearing.
lords, there is an urgency.
What
my lords.
urgency?
My lords, petitioner is a special purpose vehicle, my lord.
Ah.
It was constituted to execute and operate 1 megawatt solar project under the power purchase agreement dated 1/7/2015, my lords. The power purchase agreement has been produced. in
What
connections-
ಇವಾಗ ಎಮರ್ಜೆನ್ಸಿ ಮಂಡೇ ವರ್ಗ ಆಗದೆ ಇರೋದು?
My lords, there is an interim stay operating against me wherein the BESCOM is restrained from disbursing the bills
ಅಷ್ಟೇ ಅಲ್ವಾ?
generated.
List on Wednesday in preliminary hearing. Next.
From last 3 months.
No, sir. List on Wednesday in preliminary hearing.
My lords, from last 3 months, I have not been able to operate my project. I have invested huge amount.
List on Wednesday in preliminary hearing. Yes, next.
My lords, may I make one submission?
Wednesday in preliminary hearing.
The order has been passed without jurisdiction, my lords.
That we'll see, sir, on Wednesday, yes.
My lords, it's an urgency, my lord.
ಏನ್ urgency? Wednesday, all right.
I have my EMIs to be paid.
Correct, you have
I
invested
raised-
money, that's all right.
Yes, my lord.
Wednesday, sir.
My lords, I'll be declared NPA. My account will be declared NPA. I have used
Let that be
6
declared,
crores.
we'll see, yes.
My lord, 6 crores of rupees have been invested.
List on Wednesday
The
in
order which was
preliminary hearing.
passed lacks jurisdiction, my lord.
I told you Monday, you did not listen. So Wednesday, yes. There is no urgency in this. Next.
Lords, Monday, my lords. Monday, please.
Wednesday, yes, next.
This is a matter where.
File an appeal, sir.
My lord, KVIT is filed
No,
without.
sir.
My KVIT is on record, my lord. My lords may kindly see KVIT
No
is on
problem.
record. I'm not on the merits at all, my lord,
No,
of the matter.
what is the order under challenge?
My lord, order on the challenge, orders with regard to not giving me a chance at all. No notice was also issued to me, my lord.
Order is.
My lords may kindly see.
It's an order passed.
If my lords may kindly see Annexure
File
D.
an appeal, sir.
My lords may
43
kindly
R.
see Annexure
No,
D.
sir.
I have served them a copy.
File an appeal,
My lord,
yes.
may I just take my lords only to Annexure D? You can, I will
Of his
not, I will not
objections
insist.
sustained, petitioner is at liberty to file an appeal for the statistical purposes The petition stands disposed.
My lord, may I just take my lord's only to
No,
annexity?
sir, I will not.
My lord, I will not insist.
ಎಲ್ಲ entertain ಮಾಡ್ತಾ ಕೂತ್ಕೊಂಡ್ರೆ ಇಲ್ಲಿ ಇರೋದೇ ಇಲ್ಲ
My
ಅದಕ್ಕೆ.
lord, here, because I filed it in March, my lord. In March, despite me having filed it, she then changes her address to overcome that caveat and then
No
she files it
problem,
here, my
sir.
lord.
ಎಲ್ಲ appellate court ಕೇಳಿ.
My lord, but then this, I may not be able to challenge this before the appellate court only for the simple reason that I am challenging the fact that caveat itself, my lord, I have not been served a copy.
There is an order passed already by the concerned
Please,
court.
please.
Please challenge it in appeal. Yes.
My lord, may I just,
ಬರೋದೆಲ್ಲ ಇಲ್ಲಿ GMCPC ಹಾಕಿದ್ರೆ.
I am not on the merits at all, my lord. I am not at all on the merits because the fact that they have filed this.
Merits or demerits, there's an order passed already.
Please.
Yes, sir.
But in so far as, my lord, principles of natural justice, I'm only on that. my lord, to say that
PONG
whether-
ಅಲ್ಲೇ ಹೇಳಿ. Yes.
Please.
Preliminary item
Next.
27.
Apologies, my lords. Serial number 25, I may be permitted to serve copies of the petition on the other parties, private parties.
Sir. Counsel for the petitioner to serve on the counsel who represents the respondents 1 and 2 before the concerned court.
Please.
27.
In this case, I appear for the petitioner, my lord, in the first
ಅಲ್ಲ
case.
617 ಅಲೋ ಮಾಡಿರೋದ್ರ ಮೇಲೆ 9 ವರ್ಷದಿಂದ ಸ್ಟೇ ಇದೆ ಇಲ್ಲಿ. Will, not a minute I will hold it now. Yes, tell me.
Lord, in the first case, I appear for the.
Why did the application come to be allowed or rejected either?
ಇದು ಇವ್ರ ಕೇಸ್ ನಲ್ಲಿ ಅದು ನನ್ನ ಕೇಸ್
And
ನಲ್ಲಿ.
I am holding
Application for
R
amendment.
Gopal's matter.
Yes,
R Gopal ಯಾರು?
yes, ನಾನು.
ಹೇಳಿ.
Lord, in this case, Lord, the respondent number 1.
What are you challenging, sir?
Lord, I rejecting the application for amendment. Lord, to seek a prayer for.
Rejecting the application.
For-
Yes, I am going to allow this. ನೀವು ಕ್ಲೈಂಟ್ ಅಮೆಂಡ್ ಮಾಡ್ಬಿಟ್ಟು
Yes.
ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಆಗುತ್ತೆ, ಅದಕ್ಕೆ ಅವ್ರು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಮೆಂಡ್ ಮಾಡಬಾರ್ದಾ?
My lord.
Why do you object for such things and 9 years suit is pending?
He slept over.
ಏನ್ slept
On the
over?
date of judgment, my lord. When the
Whatever
matter
it is,
posted
sir.
for
When
judgment, my
did the plaint get amended? ಅದು ಅಲೋ ಆಗಿದೆಯಾ ಇಲ್ವೋ?
Allow again.
What is sauce for the goose is sauce for the gander. What is it?
He slept over, my lord.
What slept over?
And
You can do it. You can do it. 617 allowed. Plaint amendment. Because of the plaint amendment, he wants to amend the written statement.
immediately could have. my lord.
ಯಾವಾಗ ಆಗಿದ್ದು ಅದು ಹೇಳಿ, ಡೇಟ್ಸ್ ಹೇಳಿ. ಅದಕ್ಕೆ 9 years in the matter is pending. ಏನ್ ಯಾರು, whose benefit is it? Suit is not proceeded. Neither for you nor for him.
Brothers, my lord.
ಅರೆ ಬ್ರದರ್ಸ್ ಇದೆಲ್ಲ ಪ್ರಾಬ್ಲಮ್ ಆಗೋದು, not
Wife and
others.
children, my lord.
Only in brothers. Yes.
Wife and children, my lord. One of the brothers died.
ಯಾವ ಡೇಟ್ ಹೇಳಿ? 2016 in there is an interim order operating.
(29/8, 2015).
29/8,
2015.
15.
Was rejected.
ಏನು?
I was rejected.
ಅದು ನನಗೂ ಗೊತ್ತು. ನಿಮ್ ಪ್ಲೇಂಟ್ ಯಾವಾಗ ಮಾಡಿದ್ರಿ ಅದ ಹೇಳಿ ಅಂದ್ರೆ?
Application IA number 25.
ಅವ್ರದ್ದು.
Was allowed, my lord, on 21/3/2013.
21/3/2013.
Thereafter, my lord, he filed.
ಅಪ್ಲಿಕೇಶನ್ ಯಾವತ್ತು ಹಾಕಿದ್ರಿ ನೀವು?
ನಾವು ಹಾಕಿದ್ದು, my lord, 12/3/2014, my lord.
12/3/2014. That is rejected on 29/8/2015.
15, my lord. Let suit for declaration was
That's all
filed.
right. Anything else? Declaration ಆಮೇಲೆ ಪಾರ್ಟಿಷನ್ ಕನ್ವರ್ಟ್ ಮಾಡಿ ಅದ್ ಮಾಡಿದ್ಮೇಲೆ WS ಹಾಕ್ಬಾರ್ದಾ? ಅಮೆಂಡ್ ಮಾಡಿ ನೀವು ಮಾತ್ರ ಮಾಡ್ಬೋದು, ಅವ್ರು ಮಾಡಬಾರ್ದು. ಅದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ ಅಂಡ್ ಅದಕ್ಕೆ ಇಲ್ಲಿ ಸ್ಟೇ 9 ವರ್ಷ. We're all responsible, sir, including me.
On the direction, my lord.
No, it's not correct, sir. 9 years the matter you have taken stay of this. For whose benefit? Why did you object that? ಸುಮ್ನೆ ಒಂದು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕೋದು.
No, my lord, entire proceeding is.
What entire proceeding?
They are dragging it, my lord.
How, sir?
Only because, my
9
lord,
years in the it is here. Who is dragging?
State, my lord.
What state? This is where should all be responsible and accountable.
Intrinsic is that, my lord.
What intrinsic?
The, brothers.
As
deceased
simple as
brothers,
that, sir.
Children
You
are the.
file, that's why I asked the dates. You file an application seeking amendment of the plaint, including partition. It was suit for declaration and possession. You convert it to a partition suit, all right? When was that application allowed?
It was in the 2013.
2000?
21/3/2013.
Application allow agidde avata?
ಅವತ್ತೆ.
12/3/2014. ನೀವು ಒಂದು ವರ್ಷ ತಗೊಂಡಿದ್ದೀರಾ ಹಾಕಕ್ಕೆ? Will impose cost and allow it. ಅಷ್ಟೇ, ಅದನ್ನ ಅಲ್ಲೇ ಮಾಡ್ಬೋದಿತ್ತು. Sir, it got necessitated because of your action.
I agree with you.
Then
Thing is that since the daughters are there,
so
they
that
don't
is
want to
that is
give-
on the merit of the matter. That is on the merit of the matter.
No things is there. Since though no
OS,
real issues.
OS is 2010.
Yes, ma'am.
9 years it is pending before this court. In execution ಆಗಿ ಎಲ್ಲ 2040 ಆಗುತ್ತೆ. Yes. The petitioner.
I'll make by time fixing my,
That I will not do.
at least. as
The
early as
petitioner is before this court calling in question an order dated 29/8/2015 passed on IA 18 in OS 14 of 2010 rejecting the application filed by the petitioner defendant under Order 6 Rule 17 seeking amendment of the written statement. The petitioner is defendant number 6. The respondent, the first respondent, the plaintiff. The first respondent institutes a suit, 2001 suit ಯಾವುದು?
ಅದೇ ಹೊನ್ನಾಳಿ ಒಳಗಿತ್ತು. It was converted
Suit is
into
2001.
ಅದು ಹೊನ್ನಾಳಿ ಒಳಗಿದ್ದು ಟ್ರಾನ್ಸ್ಫರ್ ಆಯ್ತು to be clubbed along with Milord.
Situation is appalling. The first respondent institutes a suit in OS 181 of 2001 seeking declaration and injunction. During the subsistence of the suit, the plaintiff files an application under Order 6 Rule 17 on 21/17 seeking amendment of the plaint and the amendment of the plaint and the prayer in this suit. The amendment was to the effect that the petitioner who had sought, the plaintiff who had sought a declaration and injunction now includes relief of partition in the suit. The said application comes to be allowed on 21/3/2013. In the light of the amendment application filed by the plaintiff being allowed by permitting amendment of the plaint and the prayer, the petitioner defendant number 6. The petitioner defendant number 6 files an application under Order 6 Rule 17 seeking amendment of the written statement. The amendment of the written statement comes to be rejected by the concerned court on the score that it is only a ruse to drag the proceedings. It is this that drives the defendant number 6 before this court in the subject petition. This court, in terms of its order dated so and so 2016, grants an interim order of stay of further proceedings before the concerned court. The proceedings have not gone on for the last 9 years. The issue is plain and simple, whether the application filed by the petitioner defendant number 6 ought to have been merited consideration in the teeth of the circumstances that led the defendant to file an application. It is not in dispute that the plaintiff changed the stance from declaration and possession to that of seeking relief of partition in the year 2013. It is then the cause of action arose to the defendant to file an application under Order 6 Rule 17 seeking amendment of the plaint. He does it, but after a year, the concerned court, noticing the fact that it is after a year, rejects the application. It rejects the application. The order of the concerned court is on the face of it contrary to law, as it is settled, as it is trite, TRIT, as it is trite that what is sauce for the goose is sauce for the gander. If the petitioner, if the plaintiff was permitted an amendment after 2013, after 12 years of institution of the suit by permitting an amendment, 2013, after 14 years, 12 years of institution of the suit, the delay in filing an application by the defendant ought not to have taken note of by the concerned court. In that light, I deem it appropriate to set aside the order passed on 29/8/2025, rejecting the application in Order 6 Rule 17 of the defendant, and permit and allow the said application. For the aforesaid reasons, the following order. The application in IA number 18 in OS 14 of 2010 is seeking amendment of the written statement under Order 6 Rule 17 stands allowed. The petitioner defendant number 6 is permitted 2 weeks time. ಹಾಕಿದ್ರೆ already.
ಇಲ್ಲ, ಈಗ ಹಾಕ್ಬೇಕು.
2 weeks time to file the amended written statement before the concerned court. Since the suit is of the year 2001 and 24 years have passed by, I deem it appropriate to infuse finality in the conclusion of the suit. Therefore, the suit shall conclude within 3 months from the date of receipt of the copy of this order, in copy of, if not earlier, strictly in consonance with law. Ordered accordingly. Next day, Nimdo.
Namdo, in this writ petition number 49317 of 2016, what has happened, my lord, is that petition number 3, who is the petitioner herein, he was cross-examining
come to the mic.
DW1.
Mic.
He was crossing DW1. The court records that there is a collusion between DW1 and DW3. Therefore, further
What is challenge? Heli ashte. Collusion amale. Idu again it is pending for 9 years.
The impugned order, my lord, it is at page 75, typed copy. That is 16/6/2016.
Where is the impugned order?
Impugned order, my lord, that page 77 at dated 9/8/16.
77
typed copy.
Typed copy is at page 85.
Early 77 ಯಾವುದು ಇಲ್ಲ order.
Page 85 typed copy.
Which 85?
Page 85 in my.
79 ವಕಾಲತ್.
No. 9/8/16, my lord, this is the order copy. Indeed.
It's an order.
Yes. That is the only.
Present, it further appears DW1 and both DW1 different one are colluded with each other, sailing in the boat. Hence, no further examination of DW1 different required.
Yes.
Hence, further so and so is taken as nil.
Take a note of their conduct.
Prima facie collusion come to conclusion.
Not prima facie, based on the written and.
What written?
That is not
written
written.
statement is similar.
That is
Written statement is similar.
In what is similar?
There difference.
Defense. Replica of defendant number 1 and defendant number 3. Weren't
So
the
what?
same.
So what?
Defendant number 1 already cross-examined in detail.
ಆಯ್ತು.
After closure of the evidence, he has filed application
Closure of the evidence, he has filed application for what?
for recalling the PW1. for
Recalling
cross-examination.
PW1.
PW1.
Yes, sir. We'll reject it. We'll uphold the order.
No. What is the basis for coming to that conclusion, my lord? The point you
The
raised that-
statement of DW1 and DW3 are same.
Where is the proof to show that?
DW1 and DW3 are same. ಅಲ್ಲ ಇದು ಏನ್ reason ಕೊಟ್ರು? There should be some reason writing.
Anyway, it is reopened, my lord.
Now 617 ಆಗಿರೋದ್ರಿಂದ it is reopened. Now we will quash this order also and permit.
3 months will render
All,
justice.
Yes.
all parties can do anything, conclude it.
The petitioner is defendant number 3 in OS 2001 ಹಿಂದೆ ಹೇಳಿದ್ನಲ್ಲ ಅದೇನೆ. So and so. The facts obtaining in the case at hand is identical to the facts obtaining in the companion petition. The issue in the list is with regard to ಇದ್ಯಾವ್ದು 2007 ಯಾವ್ದು ಪ್ರೊಸೀಡಿಂಗ್ಸ್? OS 2007 ಯಾವ್ದು?
Oh, no, we have filed it.
2001 ಯಾವ್ದು ಅದು? ಕನೆಕ್ಟ್ ಯಾಕಾಗಿದೆ ಇದು?
Please, my lord, in family members, it is 2 suits. There were 2 suits.
ಅದು ಬೇಡ, facts ಬೇಡ. The petitioner defendant number 3 and the respondents, plaintiffs are members of the same family and have instituted the subject suit in OS 103 of 2007 for suit for
partition and
suit for partition and separate possession. The issue in the list does not pertain to the merit of the matter. Before the concerned court, an application is filed by the petitioner seeking recall of PW1 for cross-examination. The said application comes to be rejected by the concerned court on the score that the DW1 and 3, DW1 karadra PW1?
DW1.
DW1. DW1 and DW3 have colluded and have given the same evidence, and therefore he is not permitting. The order passed by the concerned court, which is impugned in the subject petition, is 9/8/2016, and it reads as follows. Flag it.
One clarification, I think. The present respondent number 1 to 3 are the plaintiffs in OS number 103 of 2007, and present petitioner is the plaintiff who filed for declaration and injunction.
Adaralli 2001 alli. All right, yes.
180 of 2001.
We are not getting into that, yes. The order that is impugned, passed by the concerned court, to say the least, is preposterous, as it does not consider any submission made by the petitioner in the application, or as to the reason why DW1 should not be brought back for further cross-examination. It is on the statement of the plaintiffs indicated by the court that both DW1 and DW3 have colluded with each other, and therefore he would not permit. The said reason springs from nowhere, as it is no foundation, in law, without there being any evidence to that effect. A conclusion of collusion could not have been drawn by the concerned court. In that light, the order that suffers from blatant non-application of mind and perversity requires the acts of this court to quash the same. In the light of the direction issued in the companion petition for conclusion of the proceedings within 3 months, the application filed by the petitioner shall merit consideration, and DW1 shall be cross-examined on the date fixed by the concerned court. It is made clear that the date fixed by the concerned court will be the only date on which DW1 will be permitted to be cross-examined, and not any other date. Since these suits are of the year 2001, the direction that is issued for conclusion of 2001, and the offshoot of the suit in 2001 is the subject suit in 2007. The direction that is issued in the companion petition to conclude the proceedings within 3 months shall apply to the subject suit as well. Ordered accordingly.
The observation made should not be influenced by the court.
How observation? Collusion. As observations made in the course of the order shall not influence or bind the act. It's made clear.
Yes.
First matter, that awaiting service of notice to R7 and may be dispensed with, because they are not the contesting respondents.
9 ವರ್ಷ ಆದ್ಮೇಲೆ ಗೊತ್ತಾಯ್ತಾ ಇದು?
ಈಗ ನೋಟ್ ಮಾಡಿದ್ದಾರೆ. They are not the contesting.
Dispense with anta ಮಾಡಿ, not ಗೊತ್ತಾಯ್ತಾ?
They are sailing with other defendants.
Yes.
In other petition,
27.2.
Yes. So here what has happened is defendant number 3, he has filed counter claim. In the written statement, he has filed the counter claim, and he was not allowed to read any evidence in the matter.
ಯಾರು ಕೋರ್ಟ್ ಈ ತರ ಮಾಡಿರೋದಿಲ್ಲ? ಮನಸ್ಸಿಗೆ ಬಂದಂಗೆ ಆರ್ಡರ್ ಮಾಡಿ.
number 36 was filed and all this.
For a decade, they are dragging the proceeding, my lord. Only dragging the proceeding, my lord.
ಯಾವ ಡ್ರ್ಯಾಗಿಂಗ್ ಹೇಳ್ತಾ ಇಲ್ಲ? 10 years ಆಗಿದೆ ಇಲ್ಲಿ.
10 years. ಇಲ್ಲಿ 10 years.
ಮತ್ತೆ ಇಲ್ಲಿ 10 years ಆಗಿದೆ, ಅಲ್ಲಿ 20 years ಆಗಿದೆ. What dragging the proceeding? ಹೆಸರಿಗೊಂದು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕೋದು, ಅಬ್ಜೆಕ್ಷನ್ ಇಸ್ ಟೇಕನ್ ನೋಟ್ ಆಫ್ ಅಂಡ್ ಗಾನ್. ಎಲ್ಲದಕ್ಕೂ ಒಂದು ಮ್ಯಾಂಡೇಟರಿ ಇದೆ. ಏನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು ಒಂದು ಅಬ್ಜೆಕ್ಷನ್, ಅಲ್ಲೋ ಆದ್ಮೇಲೆ ಒಂದು GMCPC. ಇದು ಫಂಡಮೆಂಟಲ್ ಡ್ಯೂಟಿ ತರ ಎಲ್ಲರೂ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಎಸ್, the petitioner is defendant number 3 na?
Yes, defendant number 3.
Defendant number 3.
The petitioner, defendant number 3, calls in question an order dated 9/6/2022 passed in OS 103 of 2007, which is clubbed with OS 14 of 2010, which arose out of 103 of 2001. The issue is closure of the evidence of the petitioner, of the petitioner defendant number 3, without affording any opportunity. The learned counsel for the respondents would submit that in the light of the orders that are passed in the companion petition, the petitioner also be permitted to lead his evidence, and the suit be directed to be concluded within 3 months, as is directed in the companion petition. In the light of the submissions made in unison, I deem it appropriate to set aside the order dated 9/6/2022 and 9/6/2022 and permit the petitioner to lead his evidence on a date that is fixed by the concerned court. The rider of no adjournment to lead the evidence applies to this case as well, and the outer limit for conclusion of the proceedings, as they are intertwined, applies to the subject suit as well. Yes, ordered account of ಯಾರದು ವರದರಾಜ್ ಗೋಪಾಲ್. ಫಸ್ಟ್ ಪೆಟಿಷನ್ ಕಾಸ್ಟ್ ರೇಟ್ ಅಮೆಂಡ್ ಮಾಡಿಲ್ವಲ್ಲ? I will have passed an order on dead person sum ಮಾಡಿ ಈಗಲೇ. ಅದಕ್ಕೆ 2035 ಆಗ್ಬೇಕಾ? ಎಸ್,
28.
ವಿಡ್ರಾ ಮಾಡ್ತೀರಾ? 617.
Please. Plaintiff's petition, my lords.
Yes,
In a
sir.
suit for bare injunction, file an
Correct.
application, my lords,
Amendment.
to amend the prior, my lords, for declaration
When did you file, sir?
after lapse of 5 years.
Lapse of
5 years.
anything else, sir?
Even if a suit
OS
for,
of 2014.
please, even if a suit for injunction is dismissed, my lords, he can file a subsequently a suit for declaration, my lords. Now the parties are at least, my lord. So once for all, it can be settled, my lord, the dispute
What
between the
settled?
parties.
Notice ಆಗಿಲ್ವ ಇದರಲ್ಲಿ?
Agide,
He is Sunil Rao, is it?
not Sunil Rao, some other.
There is no representation by of the petitioner. As the last chance of the respondent, as the last heard the learned counsel for the petition, the last chance Monday in preliminary hearing. Next,
Entry matter.
entry order subsisting will continue to the next date of hearing. Yes.
29.
I appear for the petition.
Number 1. My lords, before learned counsel for the petitioner starts, my lords, before the learned counsel for the petitioner starts, this is a matter that can be disposed, my lords. Now it's on a narrow compass. My lords, initially the grievance of the petitioner was that he was not heard. Thereafter, there was re-inspection. Thereafter, my lords, by an order of this honorable court, there was a fresh inspection which has been conducted. That also has deficiencies. My lords, under the Dentist Act, there's a procedure prescribed to carry forth this report. There will be an opportunity given, a decision has to be taken. So, my lords, your lordships may relegate the petitioner to and also permit the DCI to carry out action on the report in accordance with law.
A fresh inspection.
No, a fresh inspection has already been conducted. The report is placed. It was by an order of
Then
this
he has to
honorable
comply
court.
with those
My lords,
deficiencies.
whether he has to comply or not, the DCI has to take a call in the manner.
This honorable court noting that possibly the inspection report is not served on them, or there was some issue with it, directed us to conduct another fresh inspection in the presence of the officials of RGUHS minutes, as also minutes, the state government minutes. That inspection has been placed before your lordships now minutes. Now, in terms of section 16A, my lords, it's left to the authority to decide what they have to do with the inspection report. Accordingly, either recommend to the central government for withdrawal of recognition. Thereafter, the central government will give them an opportunity of hearing, check if they will comply with it, and then take it forward, my lords. Otherwise, my lords, if this inspection report is kept pending, then nothing will happen.
Yes, Chidanand sir.
Right. Now let this writ petition be pending. One second, I'll just say.
Let an application for local inspection by the university.
Correct.
Because that question does not arise now because there's a DCI inspection report. Till such time there is some action taken on it, the local inspection will not serve any purpose at this point.
All right, yes.
Right. Now, what is the suggestion, my lord, your lordship, to keep the writ petition pending? My lord, let them make available the copy of the report, my lord. Those deficiencies are all curable, my lord. They are not the. One second,
All right.
please. This is what exactly
No
I'm finding
problem.
difficult. my
You
lord.
cure
If-
the deficiencies.
No, and they will issue notice, call
No,
upon
no,
me to.
cure the deficiencies and report such curing to
Central
DCI
government.
or to the.
No, central government under 16A, my lord.
Uh,
Now, on the basis of the report of the DCI, notice will have to be issued to me. And then I have to comply those observations made by the inspectors and they will take a decision. Now, in so far
Till then
as
admission ಮಾಡಕ್ ಕೊಡಲ್ಲ.
my lord, admission is concerned, the reason is, my lord, kindly see, I will take 5 minutes of your lordship's, my lord. Kindly come to, my lord. The inspection was
In
done.
a college that has deficiencies, I will not put the student's career to
My lord,
peril.
the deficiencies are not at all there at all, my lord. Kindly see, my lord, annexure F page for a minute. 46, kindly see.
ಆಯ್ತು ಮಂಡೆ ಕೇಳೋಣ ಬಿಡಿ.
Hello, now, let the inspection be done for the reason, my lord. Now,
Well,
there is
no,
an
no.
interim order granted. by
See,
the-
there is a suggestion made.
Yes.
Now you cure the deficiencies or whatever and report curing to the DCI. DCI, right? To the DCI.
Should you get
If they
submitted-
accept it, I will permit you to
Let
make
my-
admission.
Just if your lordship.
ಅಲ್ಲ
give me-
ಎರಡು ವರ್ಷದಿಂದ ಪೆಂಡಿಂಗ್ ಇದೆ ಒಂದು ನಿಮಿಷ
Let
2
now-
years 2 years ಇಂದ ಪೆಂಡಿಂಗ್ ಇದೆ.
Now the
ಲಾಸ್ಟ್ ಇಯರ್ ಅಡ್ಮಿಷನ್ಸ್ ಏನ್ ಮಾಡಿದ್ರಿ?
admission they have admitted, my lord. They are admitting the students, my lord. We are not admitting. Karnataka, one second. my lord. I really do not know, my lord. I am not way to.
ನೀವು ಹೇಳಿ.
My lord, the report is submitted to us, my lord, on 5th of October 2010, pointing out 2 deficiencies we have complied. Then, my lord, again they inspected and submitted a report. That report pertains to not to the petitioner college. It is a dental college of Ludhiana. We pointed out saying that that doesn't pertain to our college. Therefore, make available the inspection report of our college. The second time they issue notice, same report they send, the report of deficiencies of Jaswant Singh Dental College, Ludhiana. Then on the basis of those 2 notices, my lord, this order is passed
So if you
prohibiting
want me to
admission.
hear it on its merit, I'll take it on Monday.
Please, I am, my lord,
If
your
you
lordship.
if you want this suggestion, then we'll close it on Monday.
Let that suggestion I am acceptable because that is a procedure, my lord. But the fact of the matter is, my lord, if they don't admit the student for this year, I will lose admission.
ಅದಕ್ಕೆ ಮಂಡೇ ತಗೊಳ್ಳೋಣ. We'll
Let
we'll hear you on Monday.
Well,
In the same stage.
The other aspect is all the previous inspections pale into insignificance because there's a fresh inspection
By the
report
DCI.
by the DCI pursuant an order of this honorable court. So therefore, whatever did or did not happen previously should not matter now. There are deficiencies even in this report.
Monday we'll hear it.
Very
Yes. List on Monday in the same stage.
Please. Interim orders content.
Interim order subsisting will continue to the next date of hearing. ಮೇಡಮ್ ಟೆಂಡರ್ ಮ್ಯಾಟರ್ ಬಂದಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ಉದಯ ಹೊಳ್ಳ ಸರ್ AG 1 minute ಬೇಕು ಸರ್. We can take it, sir. We can take it.
ಹಾಕ್ಬೋದಲ್ಲ?
Yes.
ಧ್ಯಾನ
ನಿಮಗೇನ್ ತೊಂದರೆ ಇಲ್ಲ.
ನನಗೇನ್ ತೊಂದರೆ ಇಲ್ಲ. ಧ್ಯಾನ್ ಅವ್ರು ಇಲ್ಲಿದ್ರು ಈಗ.
He was here. I saw him now.
Just had to go to another court, my lords, in the meanwhile.
ತಾವು start ಮಾಡಿ. AG is ready.
Please.
As always.
My lord, what has happened is there was a bid invited. We challenged it, my lord, saying that, my lord, the terms are all bad in law. That, my lord, withdrawn.
Yes.
Then, my lord, a second bid was opened.
Challenged and
That was challenged.
Rejected.
That was, my lord, rejected. That, my lord, subsequent to rejection by this honorable court, they, my lord, withdraw the very
second bid also.
Then, my lord,
now the third bid.
Third bid. My submission to your lordships is that, my lord, the terms, my lord, having withdrawn, my lord, we had challenged the order of the learned single judge before the division bench. But it has now become infructuous.
Because it is withdrawn.
Naturally. Therefore, my lord, your lordships will have to, my lord, look at it afresh, would be my submission before your lordships.
Yes, sir.
All that I am saying is, my lord, that please look at, my lord, the 4 terms, my lord, which have been done. Last time, my lord, they withdrew the bid because only one bidder, my lord, came. They made, my lord, the terms are so rigorous that, my lord, there are no bidders, my lord. It is tailor-made, my lord, for that particular gentleman or that entity is what, my lord, we are contending before your lordships.
Yes.
First of all, my lord, our submission to your lordships is that the please look at, my lord, clause.
These 4 terms on what page, sir?
Tender, my lords, get that, my lord, at running page. Tavu yava writ petition 15,797 of 25. Yav it
19,7?
15,797 of 15,797 of 25.
ಈಗಲೇ ಕಳ್ಸಕ್ಕೆ ಹೇಳಿ.
ಇಲ್ವಾ? ಹಾಗಾದ್ರೆ ಇನ್ನೊಂದ್ರದ್ದು ನಾನು
ಇಲ್ಲ ಇದು ಹೇಳಿ, ನೀವು ಹೇಳಿ ಸರ್. 15,797 ಪೇಜ್.
My lord, page 54. Sorry, one is 52. It's 3.2, my lord. Clause 3.2, pre-qualification requirement. We should have, my lord, a capacity. My lord, B says tenderer on its own or its subsidiary, 100% wholly owned by the tenderer, shall have satisfactorily executed the work lifting of beneficiation. This is, my lord, for washing of coal.
Yes, coal washing.
Coal washing. 12.37 lakh metric tons of raw coal, or, my lord, value, my lord, not less than rupees 30.92 crores.
Yes.
In any one of the years, my lord, from 2019-20 to 23-24.
Yes.
According to us, my lord, this number, my lord, is too rigorous, my lord, or too, my lord, steep, and therefore, my lord, it does not attract competition. Would be, my lord, first submission before your lordships. Secondly, my lord, there is a note, my lord, appended to clause 3.2.3 at page 54.
Yes.
Clause, my lord, note number 3. Experience in the main contract shall only be considered for satisfying the experience criteria. Contract should have been backed by the utility from whom, my lord, washed coal is transported, handled, and executed by the agency in its own name. My lord, as far as this is concerned, we are, my lord, we have 6 coal, my lord, washeries in, my lord, Maharashtra itself. We, my lord, have an installed capacity of 14.6 million tons. In Maharashtra, my lord, what they do is, there is, my lord, an entity called, my lord, the Maharashtra State Mining Corporation.
Yes.
They, my lord, the electricity, my lord, all these are, my lord, electricity, my lord, generating companies will not require this coal. They, my lord, give it only to, my lord, Maharashtra State Mining Corporation. Maharashtra Mining Corporation does not have colliery washeries. They, in turn, my lord, give it to us. We have produced, my lord, this, my lord, clause 3 says.
So you are wanting this experience to be taken?
Yes. Experience in the main contract only will be considered. And, my lord, I should have backed it. I have backed it, but then, my lord, first, my lord, backed by Maharashtra Mining Corporation, State Mining Corporation. It does not have collieries, washeries, nothing.
Yes, correct.
Then, my lord, my lord, have, my lord, similarly, my lord, others also. Therefore, my lord,
so, sorry, sir.
Sorry.
Experience in which contract, in the before this state itself, is it?
Yes.
Or any contract?
Any contract. No, my lord, with regard to washeries only, my lord. It can't be, my lord, source.
It can't be anything else.
Correct.
Washeries only.
Correct, correct.
No, you said Maharashtra does not have washery.
No, Maharashtra Mining, my lord, State Mining Corporation does not have washeries.
Yes.
No, I think what just the question is, my lord, the tendering authority should.
Sir is saying, telling why, what's the problem?
No, just a small correction. Because what they're saying is, my lord, what the condition is, the successful tender should have with the main contract, not with the nodal agency.
Correct.
Main contract andre yavdu?
For whomever the work is done for. For example, my lord, they do the work for me. The contract should with me, but not with our nodal agency.
So now, is it
not with the generating company?
Is it that whoever issues the tender, now for instance, now the contract, the experience contract should be with the same person? Is that the one?
That's what they are saying, my lord. Let me give you a lot, my lord, what happens in Maharashtra. There's a, my lord, Maharashtra generation, my lord, electricity generation company.
Yes.
It calls for, my lord, coal, like, my lord, KPCL here.
Yes.
They do not, my lord, give directly to, my lord, the coal washeries. They give it to, my lord, State Mining Corporation, Maharashtra State Mining Corporation, which does not have washeries, does not have, my lord, does not do, my lord, coal washing, handling, nothing. They, my lord, Maharashtra State Mining Corporation in turn gives it to us. Ultimately, my lord, short question for my lord's consideration is, do I have the experience? Even for them, do I have the experience? Do I have the washeries? Have I, my lord, carried out, my lord, coal handling and beneficiation? My lord, beneficiation is, my lord, washing of the coal, my lord, is called a, I mean, terminology is very,
Yes.
terminology is very, very significant. But ultimately, my lord, it is only washing of coal. Taking out the dust and this.
Yes.
So, my lord, we have 6 coal washeries in Maharashtra. We have done an installed capacity of 14.6 million tons in all these 6 combined together of, my lord, beneficiation, transportation, everything. And, my lord, we are using, my lord, the latest technology.
Then what's the problem now?
This clause says you have to have, my lord, only with Mahajan, not with the Maharashtra State Mining Corporation. Tavu 54 ತಮಗೆ 54 ತಾವು ಬಂದ್ರೆ ನೋಟ್ ಅಂತಿದೆ.
Wicked petitions ಕೊಡಿ madam.
42 in the other.
All right, 42, my lord. I stand corrected.
42 in.
In WP number 15325.
I am holding 15325.
Page
All right,
42.
my lord, then you let me have a look at.
Page 42, clause 4(1).
Allah.
Sir, page 42 note bitter. Same.
Note.
Note, yes.
4(1).
So it's note here.
Huh?
This is the petition
All right.
right here.
Will you please come to, my lord, 4(1). Sorry. Thank you. Early. Right.
4(1).
Experience in the main.
Experience.
3, my lord. 3 if you lordship.
Experience as consortium.
Allah. 3 nodi.
Experience
In the main contract shall only be considered for satisfying the experience criteria prescribed in the PQR. Contracts should have been bagged by from the utility for whom the washed coal is transported, handled, and so, my lord, we must have a contract directly with Maharashtra Electricity Generation Company. My submission to your lordship says, there, my lord, it is not there at all. Maharashtra, my lord, State Mining Corporation does not, my lord, have anything. Therefore, my lord,
So
this
they
is arbitrary.
they notify the tender.
Correct.
And award the contract to you.
Correct.
That is not to be taken note of.
Correct.
Is clause 3.
Correct.
That's
Because,
all.
my lord, question is, my lord, ultimately, my lord, only submission.
Washing is coal washing.
Do I have the experience? Do I have the capacity? Do you have, my lord, the washeries?
ಅಲ್ಲ ಎಲ್ಲಿ ವಾಶ್ ಮಾಡಿದ್ರೆ ಏನಂತ
ಅಲ್ಲ
ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಇದೆಯಾ ಇಲ್ವಾ ಅಂತ ಅಷ್ಟೇ.
ಅದು ಮಾತ್ರ ಅಲ್ಲ, ನಮ್ಮ ಹತ್ರ ವಾಷರೀಸು ಇದೆ. 6 washeries, my lord. I have put all that, my lord, please before your lord. The experience also. The certificates, my lord, the certificates. 138 of my petition, my lord, I have produced, my lord, all that.
ವಾಷರೀಸ್.
Washeries.
ತಮ್ಮ ಪಿಟಿಷನ್ ಅಂದ್ರೆ ಇಟ್ ಇಸ್ 171 ಅಲ್ಲ
15797 ಅಲ್ಲಿ
page 138.
138, my lord.
Now, who has this, some particular person has this, now, why are you excluded now? Because of this.
Because of this clause.
Now, this clause is beneficial to someone?
Absolutely. In some state, my lord, in this state itself, my lord, it is directly given by KPCL. In some other states, my lord, it is given to, my lord, the state entity, who in turn, my lord, gives it.
So this is Annexure C, page 138 is Maharashtra State Mining Corporation.
Correct. They, my lord, specifically, my lord, indicate and say that I have lifted. My lord, please come to the bottom.
Yes.
Hind Energy Coal Beneficiation India Limited, having 51% joint venture consortium member, has executed the contracted work of lifting and beneficiation of so and so, and supply of beneficiated coal to Chandapur, Koradi, so and so of Mahajanco from southeastern coal fields, SCCL area from March 21 to March 2024 for the below mentioned quantities. ROM coal lifted 38 lakh metric tons, coal washed 30 lakh metric tons, washed coal supplied to Mahajanco 29 lakh 47,000, approximate values 183.94 crores. And next page, if you allow, is I am Mahajan Maharashtra
Maha Mining.
That's the petition before Lord in this particular case.
Yes.
Look at my quantities. 1 crore, ROM, my lord, coal lifted, 1 crore 44 lakhs 38,349. Quantity of washed coal, my lord, is 1 crore
So
20.
it is not the case that you have no experience.
No.
It is the case that the experience should be with the
Main-
main contract.
Correct.
And you should be the awardee of the contract.
That's right. But, my lord, as your lordship sees, my lord, this itself says, I have supplied it to Mahajan Co. Please look at, my lord, that first paragraph, page
Yes,
130.
I saw that, yes.
Therefore, my lord, this clause, my lord, is arbitrary. And therefore, my lord, then second thing is, please come to 4. That, my lord, adralage, nanna idralli 4 banni. Ade page 54 tav hitkondiddre.
Page 54, yes.
Alla, illere idralle ತೋರಿಸ್ತೀನಿ ನಾನು.
ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ತಮ್ಮದೇ ಇಟ್ಕೊಂಡಿದ್ದೀನಿ.
Experience as a consortium member, a joint venture shall not be considered for qualifying the experience criteria specified.
Yes.
Then, my lord, 2, clause 2, unless clause 2.
Yes.
Bidder shall also contain a declaration from other consortium members or the joint venture, then from all members, confirming the exact scope of work done and value of the work done. My lord, my submission to your lordship is, co-respondents kotre, avaru kottidike value enu. Here, my lord, as your lordship saw, my lord, the margin, my lord, the main adalri, namma idralli. 138, as your lordship saw, my lord. Given by, my lord, State Mining Corporation, and, my lord, specifically stating at 139 that I have supplied it to, my lord, Mahajan Co. Therefore, this, again, one of the consortium members, my lord, ಈಗ ನಾನು ಇವರು ಪಾರ್ಟ್ನರ್, ಇವ್ರು ಕೊಟ್ರೆ ಅವರ ಸರ್ಟಿಫಿಕೇಟ್ಗೆ ಬೆಲೆ ಏನಿರುತ್ತೆ, ಅದರ ಬದಲು, my lord, an authority, my lord, who has taken the work gives it.
That is mining, Maharashtra Mining Corporation.
Therefore, my lord, and it's a state entity. Therefore, my lord, it has a.
So the entire crux is that the experience that you have gained out of the contract
have been taken into account.
Contract Maharashtra from Maharashtra State Mining Corporation should be taken as experience under clause 3.
Right. That's right.
Yes. If you are excluded, it becomes arbitrary.
Correct. That's, my lord, our.
That's the crux of the matter.
Thing. And, my lord, this honorable court has, my lord, on an earlier occasion, not with regard to this, Eastico, my lord, that judgment, my lord, I have already.
Yes, sir.
Huh? No, that Eastico Coal Company, my lord, I don't know. Have you given it to the learned judge? ಸರಿ, ಹಿಂದೆ ಕೊಟ್ಟಿದ್ದೇವೆ. Where is the? My lord, please come to, my lord, page 33. The Advocate General's, my lord, this binds, my lord, the Advocate General.
He cannot argue. He cannot argue against this.
I'm using it in some other court.
Of course, my lord, there is also, my lord, that Justice Chandrachud Senior was overruled by, my lord, the junior Chandrachud, the former Chief Justice of
yes,
who retired in that emergency, my lord, whether, my lord, Article 21 life during emergency, my lord, is
now in the latest judgment.
Oh
yes,
that was overruled. Of course,
Authorized.
father's judgment was overruled by the son. Adu ide, but illi ಈಗ, my lord,
ಇಲ್ಲಿ ಬೈಂಡಿಂಗ್
ಅವ್ರೇನು ಮೇಲೆ ಕೂತ್ಕೊಳ್ಳಿಲ್ಲ, ಅವಾಗ ಓವರ್ರೂಲ್ ಮಾಡಬಹುದು. ಇಲ್ಲಿ ಇಟ್ಸ್ ಬೈಂಡಿಂಗ್ ಅಂತ ಹಾಗೆ ಅಷ್ಟೇ.
Yes, sir.
ಇದರಲ್ಲಿ
paragraph,
my lord, please come to, my lord, paragraph 17 and 23, my lord. ಅಷ್ಟೇ, if it is arbitrary, my lord, this
that is settled.
That's even the term.
If the clause is arbitrary,
normal rule is, my lord, terms are, my lord, not justiciable. But if it is arbitrary, my lord, court will interfere.
Michigan rubber. Michigan rubber is there. Jagdish Mandal, Michigan rubber,
right.
Tata Cellular.
Correct. That's all, my lord. Their judgments you give back.
My preliminary
And joint venture partner ಅದನ್ನ ತಗೋಬೇಕು ಅಂತ ಒಂದು ಎರಡು ಕೊಟ್ಟಿದ್ದೀನಿ ಅಷ್ಟೇ.
ಇದರಲ್ಲಿ ಇದೆಯಾ ಸರ್ ಅದು?
ಅದರಲ್ಲೇ ಕೊಟ್ಟಿದ್ದೀನಿ, ಮೇಲ್ಗಡೆನೇ ಕೊಟ್ಟಿದ್ದೀನಿ. And what is the object of tender process, my lord? Not that, my lord, this is, it's like carrying coal to Newcastle ಅಷ್ಟೇ. ನೀವು ದಿವಸ ಬೆಳಿಗ್ಗೆ ಮಾಡ್ತಾ ಇರ್ತೀರಿ.
Yes.
With the lordship's kindly synopsis copy.
ಅದಾದ್ಮೇಲೆ yes.
My lords,
If
just to
senior
give,
is not there, you can do it, no problem. Yes.
my lords, your lordship may kindly see the list of dates. My lord. First tender was on 2nd March 2024, my lords. Then second, pursuant to which that tender was challenged in WP number 9298 of 2024.
That tender was withdrawn.
Then the second tender was dated 25/11/2024, my lords, which came to be challenged.
Rejected.
Judgment came to be passed, which came to be rejected.
Judgment is rendered, rejecting and upholding the conditions of tender.
I didn't, very same
That's all
condition.
right, conditions of tender. You withdrew that also.
The reason is this, my lords. So usually what they say, if there's single tender, first opportunity we withdraw it, my lords. Because if it's a single bidder, my lords, the question is in the,
No, pursuant to the rejection of the writ petition, you found that it was a single bid.
bidder, that's the reason we withdrew it. We could have gone ahead. But we withdrew
Single
it.
bid you can't go ahead.
No, in the sense, my lords, first time we cannot go ahead, my lords.
Correct. Second time you can,
Second
because
time we can.
competition applies only for the first time.
Therefore, my lords, we have financial bid, my lords, to show that there are more than one bid this time.
Now,
my lords. Court of-
Could it?
More than one bid, namdu bid ಇದೆ.
ಅದು ಹೇಳಿದ್ದೀನಿ.
More than one eligible bid. I'll put it that way.
Oh, you have made them ineligible already?
No, my lord, your lordships have.
I have that cover.
Your lordships have that cover. There are, how many people have participated? Out of 4, my lords, according to them, these 2 people are not eligible. There are 2 other eligible people.
We'll see.
That is to your lordship.
No, the only issue is, if they have washed coal, they washed coal anywhere. Here also it is washing coal. What's the problem?
That's not the, your lordship may,
No,
take
whether this court would exercise judicial review to tinker with the condition is a different
I'll
thing.
satisfy your lordships, my lord. Why this page 1, my learned senior pointed out to their writ petition page, the document that is page number 1, which is 138, my lords. Your lordship may kindly see the certificate which is ought to be produced.
Correct. Maharashtra Mining Corporation.
Please, my lords. Your lordship may kindly see, they are only a tendering authority, page 130.
138. 138 in WP 15979.
Your lordship may kindly see, my lords. This certificate is not given by the person to whom they have done the work. It is given by
It is by the tender inviting authority.
They don't know what work they have done. My lords, ultimately the tender for whom their work has been done says, yes, this work has been done, is entirely a different. Second thing, they refuse to get from the person whom with the joint venture partner also. The same certificate will be used by in this case, my lords, there are 3 joint venture partners. Everybody will use this certificate saying that I've done the same work for all the tenders. So therefore, my lords, if 3 people have done, they should say what specific work they have done. That is not forthcoming. Neither they give it, neither them.
Aito, ಈಗ pursuant to this tender,
Please, my lord.
they have been awarded work. It is here, they have indicated that work has been awarded to these people.
No, we can't believe the certificate to show that.
Why? It's a government entity.
No, it is given by the tendering authority, not for the person who is given. They don't have any basis to verify. It will be drafted by them and given to this authority to take a printout. Your lordship may kindly see.
No, ಇದರಲ್ಲಿ
Your lordship may kindly.
Maha being 45% may has executed. It is not that they have given now. To whomsoever it may concern ಅಂತ ಹೇಳಿರೋದು, they have already completed these works
No,
ಅಂತ.
that could have been done, given by Maharashtra Power
They are the
Corporation.
tender inviting authority. They have said we have awarded the contract to
For
these
example,
people. These people have executed that work.
Tomorrow, Keonix floats the tender, my lords, for KPCL. Can Keonix give a certificate saying that they have done the work for KPCL satisfactorily?
Keonix example, coal
No,
washing.
same thing. This is also the same.
No,
I
it
didn't
is
take-
mining corporation. Illu coal wash ಕೇಳಿರೋದು.
ಇಲ್ಲ. They are only tendering. They have no. They are like Keonix. My lord, your lordship may kindly take. Because
Right.
your lordship may kindly see. This is not a case. In Maharashtra, what happened, my lord? Maharashtra State Mining Corporation calls for tender for various people. It's not only regarding this, my lord. And your lordship may kindly see the tender condition clause, very important, my lord. Your lordship may kindly page 42 of the other writ petition, because your lordship have already marked that.
That
Page
is
42 of the
correct. That is 797.
797.
42 ಇದೆ ಇಲ್ಲಿ.
Your Lordship may kindly see what is the requirement here, my lords. The 42 serial number note 3.
Note 3, correct.
Experience in the main contract shall only be considered for satisfying the experience criteria specified in PQR. The contract should have backed from the utility from whom the wash coal is transported, handled, and executed by the agency in their own name. So therefore, my lord, what we are saying is
No, that is a clause that has now become the bone of contention.
and one other important, my lords, 4.2, the bidder shall also obtain a declaration from the other members of the consortium joint venture. If more than one member of the consortium bar joint venture, then from all the members confirming, this is very important, the exact scope of work done and value of the work done by each of the bidder and the other members of the consortium are not claiming the scope of the work and the value of work done by the said bidder as part of their own experience. Tomorrow, my lords, if it's 1 crore and the work done, everybody will give the certificate individually saying that I have done this. So all of them have to say 1 crore work I have done 20 lakhs, 20 lakhs, 20 lakhs if there are 5 partners, or what proportionate they have done and the nature of work done. They are saying that we will not produce that because all of us will say that we'll given 1 crore. So therefore, my lords, the object and purpose is to see whether their capability of doing it.
No, object and purpose of tender is to generate competition, not stifle competition.
Generate competition provided they are capable. We don't want incapable.
Capability, I'm not saying that.
No,
See, they are capable or not. With this clause, their entry itself is stopped.
Entry of people who are ineligible or who have no capacity to do it, Manoj. Your Lordship may kindly see, Manoj, the object of this is not claiming.
Now, this clause, yes, will consider whether it's arbitrary. The only problem that is now troubling the court with the judicial review of a particular clause. As senior put it, it is Michigan Rubber or Tata Steel, or if the court finds it to be arbitrary, it will interfere.
Correct.
Otherwise, it will not.
Please, Manoj.
Now, this is the clause this was the identical clause in the earlier petition.
Identical. Your Lordship may kindly.
Then why did you withdraw it?
We didn't withdraw it. Single bid.
No, single bid.
It is not the case where we withdraw the tender. It was a case of single bid. In fact, my lords, your Lordship may kindly see the statement of objection, page 12, my lords, for a moment in WP number 15325, my lords. Para 21. Page 12, para 21.
Yes.
It is a content of petition, the non-consideration of experience of the bidder when it has entered into contract with the government nodal agency of similar works is arbitrary and unreasonable. It is submitted this condition is extremely necessary as it is pertinent to assess if the bidder is capable of communicating and executing the work directly with KPCL, which is a utility from whom the work is being done as opposed to external agency. This condition has been included in the reason that in the event the bidder who has worked as subcontractor, the KPCL will not be in a position to assess the scope of work that the subcontractor was for. The subcontractor could be only for a portion of the work now sought to be awarded. So therefore, Maharaj, even today we don't know what is the exact scope of work which the petitioner herein has done and what is the quantity of work done, the amount of work and the nature of work that has been done. If going by their own certificate in
page 138. You mean to say page 138, they have no benefit of benefication?
We don't know what is the quantity, Melos. How much, what is the quantity?
Because you call washing benefication.
Washing benefication.
So they can't get any benefit of the benefication.
They can, Melos, to the extent if they get a certificate from the joint venture to what work they did. The benefication can be taken to the work done, not beyond the work done or capability they have done. Now, therefore, Malod, we have included this cost specifically saying that either you get it from the utility or get from your joint venture partners. Now they are saying that no, Malod, now what they're trying to say is the tendering authority has given this. It is not from the main utility or the joint venture partner. Para 23, my lord, the present tender.
No, you said earlier petitions had the same clause,
Yes, my lord.
but you have withdrawn those two tenders, so they should be considered afresh now.
No, my lord, the question is the finding of this court is binding in your, on your lordships insofar
Binding is
as.
binding.
Insofar as when the very same clause is, in fact, my lord, a judgment is sought to be shown is arbitrary. But when a very same clause is sought to be challenged and as finalized, it's become final, my lord. The question of going back is, my lord, is binding on your lordships insofar as that is concerned. My lord. A clear case of res judicata, my lord. Insofar as upholding clause 3.21a, my lord. In fact, your lordship, I have made that, your lordship may kindly take my note, my lord. I've just pointed out in page number, your lordship may kindly take page 4 of my note, my lords.
Yes,
I have mentioned the clause number, page 4, at page 5, my lords. I mentioned the clause numbers which is sought to be challenged in this, paragraph and page number in the earlier writ petition, paragraph page number in this writ petition, and the finding, my lords, of the learned single judge.
No, correct. The whole issue is those two tenders are not there at all.
No, finding of the judgment is there.
Finding on an earlier tender.
On the same condition.
That's all right. Finding on an earlier tender. Those tenders are gone now.
No, the condition is there. There's a judgment upholding these conditions. My lord, there's a.
You may at best call it identical condition,
No,
not the same condition.
No, same condition, not identical. If it was same.
Because those two are withdrawn now.
No, same condition is there, my lord. It's a different tender with the same condition.
Let's see.
No, your lordship may kindly compare. That's why, my lord, I put this table to show it is the same condition. My lord, let them say that even a dot or a word has changed from the earlier tender to this. That's not their case. Their case is because it is withdrawn. Your lordship may kindly see the judgment of this
court.
That
is what, because it is withdrawn, that would not become applicable. Is
my lord, the question is, my lord, even if an interpretation of a provision of law is made, because the party comes next time, doesn't mean that, my lords, the interpretation of the law will change, or a condition, for example, a condition in a contract has ought to be upheld. The identical condition when comes for judicial review will not change, my lords. An identical condition, my lords. So therefore, my lords, my respectful submission to your lordship's kind consideration is, my lords, when an identical condition, and one more aspect, apart from the identical, they have not been able to show what is arbitrary except for saying it is arbitrary. So, my lord,
clause is arbitrary.
What in that clause is arbitrary?
They are not able to show what clause is arbitrary.
Which portion? How does it make it arbitrary?
That is submission. It kills competition.
Kills competition does not mean it's arbitrary, my lord. The arbitrariness should be in the nature which disqualifies people who are capable. Here is a case, my lord, the person is not able to show that is capable, my lord. Then your lordship may kindly see. We have given all the page 7 onwards, my lord, all the conditions which have been sought to be challenged, my lord, and we have justified why it is not arbitrary and illegal.
Yes. Lord, by way of reply.
Sorry. Kindly permit us to. No, just the compilation citations, my lord.
Ilva? Oh, kodi.
Yes, sir. Auri put video. Same, my lord, new Michigan
rubber.
My lord, in scope of judicial review, my lord, and challenge to the criteria with regard to financial turnover not maintainable, my lord, and condition determining the capacity and capability of the bidder cannot be reappreciated. This is ultimately what they're saying is capability and capacity is wants as to be held arbitrary, my lord.
Yes, sir.
Lord, by way of a reply, please come to my lord page 138 for a minute. I'll tell you lordships why.
138.
Yes, my lord.
Yes, sir.
My learned friend said, other my lord persons can my lord claim 100% that they have done. It is not so. Now please come to the middle. There were 3 partners.
Yes.
Hind Energy, my lord, 51%. Maha Mineral petitioner, 45%. Clean Coal, my lord, this thing. And
consortium.
Please come to the first paragraph. What was the work? Second line. Work of lifting and beneficiation of ROM coal, supply of beneficiated coal to Chandapur, Karadi, forward the work to so and so, so and so. So, my lord, it is the same. Now, if your lords is come to my lord the present tender, which my lords get at my lord running page 40,
Yes.
same work, beneficiation of coal and my lord supplying it to Raichur Thermal Power Station. 40.
From there.
Ashte. Same thing, beneficiation in the middle, my lords, sorry. Beneficiation of washing coal of 24 lakh metric tons per year and my lord supply.
And two things. One is judicial review of a clause and the earlier finding.
I'll tell you, lords. My lord, I'll come back to it. Can I, my lord, in the background of this
Yes.
document, can I just request your lords, look at my lord, what is that been done? Look at the last paragraph, page 138.
138.
Yes.
Yes.
What, my lord, that Hind Energy, my lord, 51% has done, my lord, they have set it out. Who called for the
Tender.
Maharashtra state.
Yes.
We have, my lord, supplied it to, my lord, in terms of the tender.
Consortium.
And
Yes.
they say it is supplied to Mahagenco. Paragraph, my lord, line number 4. And mine,
Yes.
next page, same thing. 45%, I have supplied this. And beneficiated and supplied, page 139. Lastly, my lord,
here,
clean coal, 4%.
139 is Maha Mineral.
Correct.
It has supplied.
Correct. And then, my lord, coal clean, 4%. How is to?
Yes.
So each one, my lord, is bifurcated. It's not as if my learned friend said, how will we be able to know what has been done? My lord, that is clear in this one. Second, my submission is that the person, my lord, who called for the tender, my lord, he is in the best position, my lord, unless, my lord, please look at it. He, my lord, gets paid. Who? Maharashtra Mining Corporation. He, my lord, in turn gives us to us. So, my lord, he has to verify that he has done. Unless, my lord, he verifies, my lord, he will not be paying us. Therefore, my lord, this argument that the bifurcation is not known, my lord, is not correct. Then, secondly, what is the arbitrariness? Second, my lord, is what is arbitrariness? Arbitrariness is in, my lord, the clause which says, my lord, what is the work? Work is, my lord, like Eastico coal, my lord, if your lordship sees. What was the, my lord, tender there? They said, you must have an experience. My lord, the work called for was, my lord, by KPCL. They, my lord, wanted from road transportation to, my lord, to Raichur Thermal Power Station. But they said you should have an experience of taking through sea, land, and, my lord, land. This honorable court held you are taking it only through road in your as per tender. Therefore, my lord, requirement of sea route also, my lord, is arbitrary. Same thing is here. My submission is the clause, my lord, note 3, which says, my lord, experience, my lord, is to be ignored. My lord, on the face of it, my lord, similar to Eastico coal, my lord, is arbitrary. Then, my lord, whether, my lord, that earlier judgment becomes that.
Two things.
Yes, my lord,
Judicial
I
review and
understand.
earlier judgment.
I understand.
Yes, sir.
What, my lord, what happened is, we, my lord, challenged it before the division bench. In the meanwhile, my lord, they withdrew it.
That is what I'm asking.
Therefore, my lord, it becomes
none of those tenders that were
Correct.
subject matter of judicial
Correct.
review earlier are in
Correct.
existence. today.
Correct. Therefore, my submission to your lordship is, I could not have pursued, my lord, that. Therefore, it is now open book, and your lordship will have to reassess. My lord, the thing would be my submission. More than that, my lord, otherwise I'll be repeating myself.
That's what. Those are the two things that.
Yes, my lord, I understand. One is this. Second is, bani. ಅಷ್ಟೇ ನಾನು
Sir, that is.
ಆಯ್ತು ನಾವು ಎಷ್ಟು ಮಾಡಿದ್ರು ಇಷ್ಟೇ ನಾವು ಇದ್ರೆ ಹೇಳ್ತಾ ಇರ್ತೀವಿ.
State pre-tender scrutiny committee.
ಯಾವುದು?
There is a.
ಅದೊಂದು
We have to still file objections in that manner. That is an entirely different.
We are not
participant.
Which one?
The formation of the state pre-tender scrutiny committee.
In which petition is that?
My lord, that is 15274.
That only state is a party, my lord.
But that has a direct bearing on this issue.
Why?
Lord, what happens is the government has passed a government order, which is at page number 40. Where, my lord, the government order is in 2021.1. There shall be a pre-tender scrutiny committee headed by a retired honorable High Court judge and two other members having expertise in.
So there is no committee constituted here.
Committee had to be constituted for any contract above 50 crores, any project above 50 crores,
right.
and they must submit it there. So what the government does is, this government order exists, where, my lord, they are required to ensure that it should be there. They say now it is not there, therefore it is waived.
Now it is not there. What is not there?
The member's term.
No,
came to an
life
end.
of this order is in subsistence
The
today.
order is in subsistence even today. The member retired. The learned judge, my lord, who was the chairman.
So no new committee is
They don't
appointed.
form the committee.
from 2024 onwards, please see NH at page 96.
96.
96, NH
11/6/2024.
11/6/24.
ಮುಂದೆ ಪ್ರಸ್ತಾವನೆಗಳು ಮಂಡಿಸುವುದಕ್ಕೆ ಮುಂದಿನ ಆದೇಶದವರೆಗೆ ವಿನಾಯಿತಿ ನೀಡಲಾಗಿದೆ.
So, you have passed a government order saying it is essential for all tenders to be scrutinized, and there are good reasons why it has to be done, and they've said so. Please see, my lord, page 41.363.
41 point?
No, page 41, para 6(3). Pre-tender scrutiny committee shall further verify that the tender-related document is just, equitable, transparent, provide for equal opportunity, contain the suitable provisions for protection of the interests of the procurement entity.
Why the government has not reconstituted the committee?
On two things, my lord. They are yet to reconstitute. In this case, your lordship, kindly may take list of dates, my lord. On 26 February 2024, my synopsis, my lord, which I just given. The state pre-tender scrutiny has recommended on the tender number 1 considered the same.
First one.
First one. So therefore, my lord, on facts, even there's no committee. The committee was only for a period of 2 years. That is expired, my lord. We have not.
This
has been done, my lord. No. Even though
deliberate act.
Not deliberate act. Your lordship, it has already been
26 to 24. It gave us recommendations. That first tender was withdrawn.
So
both the tenders are withdrawn based on which the recommendations were given earlier.
Correct. Yes. That is withdrawn. Now they don't do it.
Now the new tender has no recommendation.
No recommendation.
No, ultimately, what was withdrawn is based on the first earlier tender and the second tender. The only question is very same conditions have been upheld. So therefore, my lords, this petition, according to me, is a clear case of abuse of process of law.
You have withdrawn and issued a new tender. Don't they have a right to challenge that?
The question is, having suffered an order, my lord, they should have taken it on appeal and challenged.
They have taken it on appeal in light of your withdrawal. That is not now.
The judgment is binding on your lordships, my lord.
That we will see.
The judgment is with regard to
your argument in terror binding on your lordships.
Is binding on your lordships insofar as not identical, but same clauses, my lords. If
that is what.
But what is different, my lord, is the fact that the objective of the act is to ensure competition and nothing else.
That's what I told him. See, objective of KDTP is to encourage competition, not to stifle it, or smaller eligible persons.
Therefore, if if they knew there was only one participant in the bid, why would you then call the same tender to ensure that the same person gets in? It can't be an empty formality to say, I am for the purposes of record ensuring that there's a second tender that is called for, but I'll do it on the same conditions. When everyone else is saying that these conditions are extremely difficult to meet, which means a premeditation in who you want to choose. There's nothing more to it. And that not premeditation becomes obvious from their conduct of ensuring that any protective measure which may be there is all removed, and then you proceed straight away to award a tender to a person of your choice. And that is really not the substance of this petition itself.
The other one, sir, is there anything to supplement?
I don't want to say.
Lord, we have also filed, then also, my lord, it's WP, that with regard to this, my lord, very contention. It has not been listed here, just tag it along. WP.
That will see.
16630.
I have heard you. I'll tag it and reserve it. Yes. Now, the records are with me. Now, don't proceed with anything till I pronounce.
Proceed. Please, my lord, not to award your lordship.
Exactly. Further proceedings you shall not continue till I pronounce the judgment. Yes.
My lord, then we will not award, my lord. Let the tender accepting authority take a decision on the tender.
Don't award the contract.
We won't award the contract. We'll take a decision on the tender. And we have given the technical and the financial.
Heard the learned senior counsel Shri Uday Holla appearing for the petitioner in so and so. Learned senior counsel Shri Dhyan Chinnappa appearing for the petitioner in so and so. And the learned advocate general representing the Karnataka Power Corporation Limited. This court on so and so earlier order had passed a detailed on 3/6/2025 had passed the following order, and again on 26/2025 the following order. The records of the scrutiny of the tender scrutiny committee, both technical and financial, are placed in a sealed cover before this court. In the light of the matter being heard and reserved, no contract shall be awarded till the pronouncement of the judgment.
Great.
Your Lordship, may I clarify the tender accepting authority can take a decision, my lord, because.
Except awarding of contract, you can do it.
Please.
Yes. Yes, sir. Weapons.
Next matter.
Yes, Prashant.
30.
My lord, I'm appearing through VC, my lord.
Yes,
Sorry, my lord.
what happened?
My lord,
Lordship,
in the last date of hearing, my lordship directed my lord to the government to submit Ram Mohan Das committee meetings.
Kudiyat.
Confidential report.
Oh, confidential. Kodisa.
My lord, it cannot be confidential. We'll have to go through it and my lord, then submit as to what is.
What is against you, we'll see. Monday. I'll see first.
Please.
List on Monday. Yes. Termination yavaga? Termination yavaga? When were you
Termination, my lord, that I have been, Allah, they have relieved me on my lord at 21/12/2023.
Why
I'm
post
sorry, my lord.
abolish aita?
Allah, ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ, they are insisting me, my lord, as they enter into an agreement that I should work on a contract basis. Therefore, they said 11 months agreement enter again. I said that I'll not, because I have my interim prayer is, my lord, for a moment, my lord, kindly turn to my lord the IA which I have been filed. I have been appointed as a my lord coordinator. I continue to work even to this day. My initial pay was my lord 10,000. Time to time it has been enhanced. As of now, they are paying 22,000. But my lord, while I was working from my lord January 2021 to 2023, they are paid only 75,000, 75% of the pay instead of my lord the full pay.
Cancelling the contract.
ಅದನ್ನ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ವರ್ಕ್ ಮಾಡಿದ್ದು ಸ್ಯಾಲರಿ ಕೊಡ್ರಿ ಅಂತ ಕೇಳಿದ್ರೆ ಕೊಡಲ್ಲ ಅಂತ.
ಇಲ್ಲ ಸ್ಯಾಲರಿ ಅಷ್ಟೇನಾ ಅಥವಾ ಇದು ಕ್ಯಾನ್ಸಲಿಂಗ್ ಕಾಂಟ್ರಾಕ್ಟ್
ಮ್ಯಾಟರ್ ಬರ್ತದೆ ಸ್ವಾಮಿ. ಐಎ ಫಾರ್ ಗ್ರಾಂಟಿಂಗ್ ದಿ ಸ್ಯಾಲರಿ ವಿಚ್ ದೇ ಹ್ಯಾವ್ ವಿಥೆಲ್ಡ್ ಫ್ರಮ್ ಮೀ.
ಫೈಲ್ ಯುವರ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಮೇಡಮ್.
ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅವರು.
ದಿ ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್
ಐಎ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ, ಎಲ್ಲ ವೇಗಾಗಿ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಅದಕ್ಕೆ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್. They heard the learned counsel C. Jagadish appearing for the petitioner. Counsel Srimati Sumana Baliga seeks 10 days time, 2 weeks. 2 weeks time to file statement of objections. Objections, if any, by the next date. List the matter on 24th. Yes. Next.
32.
Yes, sir.
Lords, the plaintiff's petition, my lords. IA, my lords, was filed seeking for production of a document because Section 8 application has been filed by me. Seeking for reference of the suit to arbitration. Oh, my lords, the entire plaint government says when I was a director, lords, it is actually set up by my husband, the suit, after I had filed. Now, my lords.
MC case illa bekadashtu.
May I make one submission?
Suggestion. Solution.
Make one submission, my lords. Their application, my lords, is under Order 9, Rule 17. And the grounds on which, my lords, they have filed this writ petition asking to set aside the impugned order is because they want to argue the Section 8.
Correct.
Section 8, they had to argue. When the writ petition was filed, no interim order was granted. They don't appear before the trial court. I have the dates. If my lords wants, I will point out. I have the certified copy of the order sheet. I can submit it. They don't appear before the trial court to argue the Section 8. My lords, might take Section 8 to proviso. It clearly says either the original or a duly certified copy. For the purpose of arguing Section 8, I'll produce a notarized copy. Let them argue the Section 8.
Yes, sir.
Lords, if they say so, I have no issues. If they have to produce, not me, I don't have.
Correct. Our produce
notarized copy. In fact,
certified copy he will produce.
Notarized, my lord. It's an unregistered LLP. It's a notarized copy. The original itself is a notarized copy. I'll produce a notarized photocopy. Notarized, I'll produce.
Please see their objection. I came only because they said, my lords, I have no issue.
Now that he is suggesting, we'll close it saying that you will produce it there under subsection 2 of Section 8. And let the proceedings go on.
In fact, my lords, it's not like that. During the pendency of this, the mistake occurred in the trial court. The trial court, my lord, the presiding judge had changed while this was
That's
pending.
all right. Don't get touchy about all that.
That's all.
What has happened is the impugned order here
that was challenged. On that same IA, one more order came to be passed. And
As
the next day
allowing the
recalled.
IA, but then the.
IA ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಅಲ್ಲಿ.
ಇಲ್ಲ IA rejected.
ಇನ್ನೊಂದು IA ಅಲೋ ಆಗಿದೆಯಾ?
No, no.
ಇದೇ
The
IA
same
ಮತ್ತೆ allow
IA,
ಮಾಡಿದ್ದಾರೆ.
the presiding judge passed an order allowing it, but he recalled
What
it.
remains, I will not go deep into it. I will only record your submission, undertaking that he will produce a notarized copy
Notarized copy.
and proceeding, it will go further.
My lords, it is like this notarized copy I produce. If section 8 is allowed, suit goes. If section 8 is dismissed, I have to produce the original for trial.
LLP can't be an
Before the
unregistered.
arbitrator.
But the LLP can't be an unregistered thing. It's a registered LLP. Today, I don't know how he's saying it's a unregistered.
When I say unregistered, it is not, it is my lords, it's a registered LLP. Yes, it is there on the MCA portal also. My only this thing is that the original this thing is only notarized. That's all.
ಆಯ್ತು, ಏನಿದೆ
What I'm saying, I will produce notarized copy.
ಅಲ್ಲ, ಏನಿದೆ ಅದು ಕೊಡಿ, you take objection if you want there. Anyway, IA is allowed in the subsequent application is allowed.
No. My lords, what happened? Section 8 application is pending.
Section 8 is pending.
This
In that
is-
you file an application seeking production of the document.
Yes, ma'am.
That is rejected.
Yes,
You are here. Which is another application that you have
It
filed.
is not another application, same application. Mele ignore order. It is a
Same
mistake.
application again taken up.
ಅವರು ಮಿಸ್ಟೇಕ್ ಆಗಿ ತಗೊಂಡು ಆರ್ಡರ್.
What happened was
he
it was
recalled that order having realized
It was,
mistake
no
ಆಗಿತ್ತು.
problem.
it was reserved for orders on IA number 2, but orders was passed on IA number 3.
IA
ಅಷ್ಟೇ.
8 ಮೇಲೆ
That is all has happened.
The petitioner, the plaintiff is before this court.
No,
Calling
petitioner
in-
is a defendant. I am the
Defendant,
plaintiff.
huh?
Respondent is the
Petitioner, the
plaintiff.
defendant, is before this court calling in question the proceedings calling in question an order dated 6/3/2024 passed on IA 3, rejecting the application filed by the petitioner seeking the plaintiff to place on record the document the LLP agreement. The learned counsel appearing, the learned senior counsel, Ken Panindra, appearing for the petitioner, would submit that the document ought to have been produced before the concerned court ought to have allowed the application as for a reference to the arbitrator. The document that was sought for was imperative. The learned counsel appearing for the plaintiff would submit that the LLP agreement and the notarized document notarized covering or the LLP agreement that is in his possession, a certified copy, notarized copy, or even the original will be placed before the court, on the next date of hearing.
31st of July.
On the next date of hearing, which is set to be on 31st of July. In the light of the said undertaking, the learned senior counsel submits that this court need not delve deep into the matter. In that light, as a matter of form, the order dated so and so stands quashed. The undertaking of the plaintiff is placed on record. He shall produce the aforesaid document in the aforesaid manner on the next date of hearing, i.e. 37 so and so, ordered accordingly.
LLP agreement dated 30/10/2010.
LLP agreement 30/10?
2010.
What background is this, my lords?
Background I know.
It is that my wife resigned as a LLP. One more partner has come in. Now the original,
No, that's
earlier
because-
agreement now has to.
That's because you're in a squabble now, all this has happened.
Very well, I'm grateful.
Yes. ಅದು date ಬರ್ಕೊಂಡು agreement.
In this case, on the last date of hearing, my lord, I have produced the original resolution, copy of the resolution and the membership book. Clearly, my lord, reveals-
ಆನಂದ್ ಏನೋ ಹಾಕ್ಬೇಕು ಅಂದ್ರಲ್ಲ.
Before that, my lord, I
Hold,
request
one
lordship.
minute.
We'll hear
My
it.
learned friend, my learned friend produced only resolutions. Not the, he permitted to
Whatever, produce ಮಾಡಿದ್ದೀರಾ ಈಗ? ಅಲ್ಲ ಏನೋ ಕಾಪಿ ಕೊಡ್ತೀನಿ ಅಂದ್ರಲ್ಲ, something.
Even ನಾನು already ಕೊಟ್ಟಿರೋದ್ರಲ್ಲೇ ದಾಖಲೆ ಇದೆ, your
Just
lordship.
the matter on 11th, yes.
My lord, what happened, my lord, since my lord,
Not
actually-
subsisting, will continue to the next date.
Really, ಏನ್ ಹೇಳ್ತಾ ಇದೆ? You my lord, now my friend learned friend is produced the document showing that I am the member in the year 2013, but he has not produced the membership application.
We will
And moreover,
See, prima facie, we'll set this order aside, send it back to the court to examine everything and pass orders.
till then, this dispute proceedings, my lord. Otherwise, my lord,
Next week, yes.
please,
11th.
oblige.
That's what I'll do. Till then, we'll see what's to be done.
Till then, whatever the undertaken given by my learned friend may be entered.
But what happens?
That will
Lord?
continue.
Lord,
Please.
what happens? Lord, undertaken put ಅಲ್ಲಿ plaintiff evidence finally ಅಂತ ಹೋಗ್ತಾ ಇದೆ.
ಪರವಾಗಿಲ್ಲ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. 11th, yes.
ಅಲ್ಲ dismiss ಮಾಡೋದಕ್ಕೆ ತಾವು ಆರ್ಡರ್ ಮಾಡಿ. Let there be an order from this court.
Court order.
ಯಾಕೆಂದ್ರೆ ನಾನು ಅಲ್ಲಿ ಹೋಗಿ ಹೇಳಿದೆ.
One ನಿಮಿಷ. The matter is heard and to hear them further, list the matter on further hearing ಅಂತ ಹಾಕ್ಬೇಡಿ. Hear them further, list the matter on 11th. The learned counsel for the petitioner submits that the proceedings before the registrar,
Deputy Registrar of Cooperative Societies.
DRCS is fast progressing and no adjournment is granted. In the light of the subsistence of the subject petition
Adjournment ಕೊಟ್ಟಿದ್ದಾರೆ, but now
and
again and
subsistence
again we are seeking.
subsistence of the subject petition as also the issue involved, the proceedings before the DRCS shall remain stayed till the next date of hearing.
Oh, please. Oh, please.
My interim order also may be continued.
This is over and above what is undertaken by the learned counsel appearing for the petition. Yes, next.
Bless.
34.
My lord, for the petitioner, my lord. Lord, the case of the petitioner is, petitioners are.
I appear for the respondent 7, contesting respondent.
I appear for respondent 6, my lord.
You're not contesting?
No, my lord, I will explain why the housing board is a party.
Housing board.
Housing.
Oh, the-
They are not necessary parties, but the decree passed, compromise decree, my lord, is challenged before this honorable court. He will explain.
2011 decree you're challenging now.
My lord.
Karana.
Yes, my lord. Yes, my lord. My lord,
Why?
my lord, the.
After 14 years.
My lord, the fact of the matter is, at the time of institution of the suit and passing of the decree, the petitioners who had obtained the lands by way of Sagoli chits, my lord. My lord, it's annexure A and B, my lord. I'll just take you to the Sagoli chits, my lord. My lord, it's at page number 23, my lord. The Sagoli chit made to petition number 1. And the Sagoli chit made to petition number 2 is at page number 30, my lord. My lord, condition number 7 of the said Sagoli chits were that the land granted.
Your grantees, is it?
Yes, my lord, we are grantees.
Non-alienation clause ಇತ್ತಾ?
ಇತ್ತು, my lord.
ಎಷ್ಟು ವರ್ಷಕ್ಕೆ?
My lord, 15 years.
ಎರಡೇ ಹೇಳ್ಬೇಕು. Date of grant.
My lord, date of
Non-alienation
grant,
clause how many years?
My lord, 1997.
19?
15 years ಬರುತ್ತೆ. 18/5/2012 ವರೆಗೂ ಇರುತ್ತೆ.
18/5/2012
ವರೆಗೂ ಇರುತ್ತೆ.
Suit and date of compromise.
My lord, date of suit is 23/8/2011. The suit is
23/8/2011.
Yes, yes, my
Date
lord.
of
And
compromise.
27/8/2011, my lord.
4 days ಅಲ್ಲ?
Yes, my lord. That is what I want to bring to the notice of this honorable court. My lord, 4 days early notice is made. The petitioners are called. My lord, the petitioner number 1 and 2, to whom the award has been made, they are illiterates, my lord. My lord, in the compromise decree, my lord.
Compromise. Who are the respondents? Contesting ನೀವೇನಾ?
Please.
Yes, sir.
My suit.
Your suit.
May I make my suit?
Who is the grantee? They are the
There is no
grantees.
dispute about that.
ಒಂದು ನಿಮಿಷ, ನೀವು ಸುಮ್ಮನೆ ಇದ್ಬಿಡಿ.
I'm sorry, my lord.
They are the grantees.
Please.
It was a non-alienation period when you purchased the property?
Not disputed.
Not disputed.
Not disputed.
Section 4(2) of the PTCL Act kicks in, and every agreement to sale or sale is null and void if it is done during the non-alienation period, except on the permission of the state. Where is the permission of the assistant commissioner or deputy commissioner?
My submission, my lord, is there is one more exception which has been laid down by this honorable court recently, my lord. I'll just point out from the judgment.
What exceptions?
What it says is, when the agreement itself stipulates that the sale deed will be executed after the expiry of the period of non-alienation, in such event, my lord, then.
No
because
problem.
The reason.
We will accept that also.
Please.
Before the non-alienation period would get over, suit is compromised, decree is done, everything is done. 4 days early, how did you do it without these grantees getting to know anything?
It was consent decree because.
Consent by whom?
I'll point
You
out
are the
to that.
respondents there?
Yes, my lord.
They are the
We will
defendants.
respond, my lord.
They have.
What is the consideration?
For agreement for.
ಒಂದು ನಿಮಿಷ. What is the consideration?
My lord, the consideration was, there's
9
My
lakhs.
lord,
was the
my lord, the.
Now, why did you wait for 14 years?
My lord, my lord, I will bring that to my lord's notice. My
ಇಲ್ಲ
lord,
ಈಗ ಲ್ಯಾಂಡ್ ವ್ಯಾಲ್ಯೂ ಜಾಸ್ತಿ ಆಗಿದೆ ಅಂತ ಈಗ
ಇಲ್ಲ,
ಮಾಡ್ತಾ
my lord.
ಇದ್ದೀರಾ ಅದು
ಇಲ್ಲ, my
ಗೊತ್ತು.
lord. ಇಲ್ಲ, my lord,
But
ಹಂಗಲ್ಲ.
why did you wait for 11
My
years?
lord, I am in possession of the land. I am very much in possession of the land. Until till date, they have not come to possession of the lands. I am in possession of the lands. I have been tilling the lands. I have been using the lands for my
Where are
livelihood.
the lands?
My lord, the lands are situated in Anekal, my lord.
ಆನೆಕಲ್ಲಿ ಟಿಲ್ಲಿಂಗ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಇನ್ನು?
My lord, ಅಲ್ಲಿ ಇವ್ರು ಬೇರೆ ಏನು ಗೊತ್ತಿಲ್ಲ, my lord. They don't know anything else.
ಅಲ್ಲಿ
Now,
ಎಲ್ಲಿದೆ ಟಿಲ್ಲಿಂಗ್ ಗೆ?
my lord, now.
Yes, you are only telling ಅಷ್ಟೇ, no tilling.
ಇಲ್ಲ, my lord, page number 64, I have to bring my lord to page number 64, my lord. My lord, ಅಲ್ಲಿ it is the respondent number 1 and it is the petitioner number 1 and 2 to whom the lands have been granted.
That's
My
all
lord,
right.
ಅವರು
No, you have a point in law. Yes, it's void ab initio. If sale deed were to be executed after the non-alienation period, no qualm. Suit is decreed in 4 days of its filing, long before the non-alienation period. The decree vests the right of the property in you.
No, my lord. What I'm trying to say, my lord, is the decree does not itself convey the title in favor of the.
What was the
respondent.
suit for, sir?
Suit for specific performance.
Correct.
Agreement of sale.
Agreement yavattu, sir?
My lord, agreement of sale dated 17/6/2000, sorry, date of grant so and so. And agreement is 17/6/2010. 9 lakhs was the sale consideration to be paid. 5 lakhs was paid. Thereafter, that is admitted. Further advance of 1,25,000.
Again, what is the present
agreement
status?
is admitted. Decree is admitted.
No problem.
Now, they can only claim for setting aside the Lok Adalat award only when they prove fraud, my lord. That is what been held by the.
No, this is fraud Allah. This is void ab initio because contrary to the statute, nobody need prove any fraud here.
Right, my lord.
There is no fraud here.
My lord, this honorable court.
If it's illegal by its birth, it goes.
This honorable court has held, the coordinate bench has held, my lord, that I'll just point out, my lord, from the judgment of this honorable
Yes,
court.
sir.
It says that there has not been any sale in the sale agreement itself does not convey any title. Therefore, this honorable court holds that.
What is the agreement with possession?
My lord,
Was the agreement with possession?
no, my lord. No, position is with me. There is no agreement. with possession.
ಹೇಳಿದ್ದೆ agreement ಅಲ್ಲಿ ಏನಿದೆ ಅಂತ.
My lord, agreement ಅಲ್ಲಿ.
Annexure F, for a minute, your compromise petition, my lord, your lordship sees.
Now.
Petition ನಾವು ಕೊಟ್ಟಿಲ್ಲ, ಅಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿದ್ವಿ. It is an agreement without petition, my lord. No position has been given.
The delay also, why they have done it is, the land has now been acquired.
By
Acquired by the Karnataka Housing Board, my lord. Now, the only question is compensation has been deposited. Who has to take the compensation is the only question, my lord. It is not even the question of land.
We'll see.
So that is the reason, my lord.
Let the housing board, you've come on record?
Yes, my lord, we need time.
Pradeep
to
Kumar
file
is here, is it? Yes. Now, don't disperse compensation to anybody.
My lord.
The petition is preferred by the judgment debtors. The petitioners become judgment debtors on a peculiar circumstance. They are the grantees from the hands of the state under the provisions of the Karnataka, under the, as being members of the scheduled caste or scheduled tribe, as the case would be. The Saguli chit issued.
My lord, just a small correction. My lord, they don't belong to scheduled caste, scheduled tribe, my lord.
ಮತ್ತೆ ಗ್ರಾಂಟ್ ಯಾವ್ದಕ್ಕೆ?
My lord, ಇದು ಸಾಗುವಳಿ ಚೀಟಿ ಅಂತ ಬಂದಿದೆ.
ಯಾವ್ದು ಗ್ರಾಂಟ್, ಯಾವ್ದ್ರಲ್ಲಿ ಗ್ರಾಂಟ್ ಕೊಟ್ರು? ಗ್ರಾಂಟ್ ಯಾವ್ದ್ರಲ್ಲಿ ಕೊಟ್ರು?
Land grant rules, my lord. It's not.
And grant rules ಅಲ್ಲ.
Yes, my lord.
ಹಂಗಾರೇನ್ apply? Yes.
It's not under the.
Then
SC/ST
PTCL
Act.
won't apply at all.
PTCL won't
PTCL
apply.
won't. I'm sorry.
Then you file your objections, yes.
I'll just point out here one judgment of this one.
Then that goes on a different footing. No.
Please.
Yes. List the matter on 18th, yes.
What's all?
If it is PTCL, 4-2 kicks in.
It's not.
Not
PTCL,
this,
my lord.
yes.
Land grant rules.
My lord, the award
Here
not been made.
Here delay comes, yes.
My lord, I will.
14 years have kept quiet, here delay
ಇಲ್ಲ,
comes.
ಕೊಡ್ತೀನಿ, I will produce judgment.
It is not void
Next
ab
date.
initio. Yes.
35. Obligement.
Lord, the petition is by the successful
Very
award
for
holder in
responding,
an
my lord.
arbitration.
Milord, we've engaged the senior counsel.
I'll
Milord.
point
He's
out-
on his feet in CH-7. Kindly pass it to him.
On his way. Yes. Pass over bada, passed over to Monday.
My lords have it on the preliminary list if that's possible.
Preliminary hearing, ಈಗಲೂ ಅದರಲ್ಲೇ ಇರೋದು. Yes.
Grateful.
36.
Just next week.
37.
delay. ಅವ್ರು ಇಲ್ವಲ್ಲ? 11th. Pass over ಮಾಡ್ಲಾ?
Pass over ಮಾಡ್ಬಿಡಿ.
I don't know whether it will be taken up or not. Yes.
Monday.
36. 36. You are there?
I'm there. 30, sorry.
35, there's an interim order.
Oh, that like, what is this? You're appearing for the first time before me. What is this? Yes. Yes, that is. Monday, 11th. List on 11th.
I am for the petitioner in the first writ petition.
Appear for the petitioner in second petition.
May make one submission. The second petition is nowhere connected with the first petition.
Why?
No.
It has been filed by me.
That's what, let me.
Against
No.
society.
We will deal, ಎರಡು same parties.
Same parties, same properties, same parties, same properties. In a
Different
first
suit, my lord.
No.
In first subsequent suit, my lord 47, I filed a suit for declaration. I am not a party in the first suit.
He is the plaintiff.
He is the-
You are not a party in the first suit.
He is the plaintiff in the first writ petition.
ಮತ್ತೆ ಪಾರ್ಟಿ ಅಲ್ವಾ plaintiff ಅಂದ್ರೆ? ಮತ್ತೆ?
I am the plaintiff in the first suit, and in the second suit, I have the plaintiff in the second suit, wherein I filed a suit against society.
So what?
Suit
Issue order 16 rule 5, order 1 rule 10.
Yes, ma'am.
ಎರಡು
That's it.
ಅಷ್ಟೇ ತಾನೇ ಇರೋದು.
Different suit, different in, yes.
Yes.
My applications was rejected solely on the ground that I have nowhere concerned with the suit filed by the.
What documents you wanted to summon from the deputy commissioner?
He filed an application.
ನಿಮ್ದು, yes.
He filed an application.
ಏನದು?
Deputy Commissioner from my lord that the grant certificate issued in favor of Ramaya.
What's the suit for?
Suit for declaration and injunction.
Mine
ನೀವು
is
ಯಾರಿಗೆ?
only injunction.
ನೀವು ಯಾರಿಗೆ?
My suit.
He is the respondent in the first writ petition.
Injunction.
Only for injunction from last 10 years.
ಅದರಲ್ಲಿ impleading application.
Injunction is in my favor.
Who filed
For their
impleading?
injunction.
Impleading ಯಾರು ಹಾಕಿದ್ರು?
I am the defendant in the second writ petition.
Correct, but why did you want impleading in that suit?
But I will make a few facts before this. Let the respondent in the first writ petitions had filed a suit for the vendor of the petition respondent Sunil Kumar filed a suit against the petitioner before this honorable court in OS number 11153 of 2006 in respect of the same suit shadow property, and said suit was came to be rejected, dismissed, and against which they prepared an appeal also dismissed. Then thereafter, my lord, the respondent herein by colluded with this vendor filed a suit in OS number 6075 of 2000.
ಈಗ ಬರೀ ಅಪ್ಲಿಕೇಶನ್ ಏನಕ್ಕೆ ಅಂತ ಹೇಳಿ ಸೂಟ್ ಆರ್ಗ್ಯೂ ಮಾಡಬೇಡಿ ಇಲ್ಲಿ.
No, I'm not.
Then
The facts may be, sir.
ಯಾವ ಫ್ಯಾಕ್ಟ್ಸ್? ಯು ಗೋ ಇಂಟು ದ ಸೂಟ್ ಫಸ್ಟ್ ಅಪ್ಲಿಕೇಶನ್ ನೀವು ಹಾಕಿದ್ದೇನು?
I filed an application in the suit, injunction suit filed by the respondent herein against this vendor who lost the decree against me.
Order 1 rule 10.
Please, ma'am.
You wanted to implead.
Please, ma'am.
That is rejected.
Please, ma'am.
Suit for injunction on the basis of what?
Based on the sale deed executed by their vendor.
Correct?
Please.
Who are you there?
I am the society, they what?
Which society?
I am the Gavipuram House Building.
It is between his vendor and him. Why are you worried?
Because that is what my earlier suit ಬಗ್ಗೆ ಹೇಳಿದ್ದು sir.
ಯಾವ earlier suit ಯಾರು ಹಾಕಿದ್ರು?
Earlier suit is the vendor of the respondent herein.
Against you?
Please, my lord.
What happened to that suit?
That suit came to be dismissed by holding that the property they claim it's an acquired by the society and government on behalf of the society.
After that, he has entered into a sale with.
Please, my lord. And thereafter they have prepared an appeal. Appeal also came to be dismissed. In the appeal also, the very respondent.
All right, wait. Yes, sir.
May I please? I have filed objections in this case. This land is not required.
Mike though.
The land in question is not acquired. I have filed in my objections in which, my lord, it was a subject
So
matter
land in question is not acquired. What is the earlier suit is referring to?
against me, my lord.
No, against your vendor.
I think I am not a party to that, my lord. I don't know about it.
No, you are not a party to that. He says
Here-
Your vendor had a suit against him.
No,
That suit is dismissed, appeal is dismissed.
Just make one-
After dismissal of the suit, he has sold the property to you, so he becomes a necessary part.
No,
That's his submission.
Before buying this property, I have taken permission from the government. And the government, it was a subject matter in the assembly also. The chief minister has answered that it is not acquired. All this I have put it in my objection statement. Where is the question of he saying now that it was acquired and therefore I have got a right over it and his sale deed is there and all that. He has no sale deed. He has nothing to do with this. Kindly see my objections, my
Well,
statement.
thereafter, my lord, during the
statement.
pendency of the suit, the very respondent filed a suit against me after purchasing the property against me, against the society, seeking declaration.
ನೀವು ಸೊಸೈಟಿನಾ?
Please. One kade nanna our
ಎಲ್ಲಿ
vendor.
ಅಕ್ವಿಸಿಷನ್ ಎಲ್ಲಿದೆ?
Please.
Notification.
Notifications. I have in page
ಈ
number.
ಪ್ರಾಪರ್ಟಿನೇ ಆಗಿರ್ಬೇಕು. ಬೇರೆ ಯಾವ್ದಾದ್ರು ಪ್ರಾಪರ್ಟಿ ಆದ್ರೆ ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡ್ತೀನಿ.
Please, madam.
It should be this property only, subject matter of acquisition.
Survey
If you
number
want to
20.
infer something, I'll impose cost.
No, my request, lordship, kindly see.
You said your vendor, his vendor had a dispute with you with this suit schedule property.
Please, madam.
If it is not the suit schedule property and you are playing with it, I'm going to impose cost.
No, that's what, my lord, they filed a declaration suit. Kindly see for a moment, the observation in the earlier suit, page number 100. They say that the learned trial judge, whatever the property claimed by them is not at all existence.
My lord,
Relevant portion, suit is commencing from page number, annexure A,
ಈಗ
page number 83.
This suit schedule property has nothing to do with his claim.
Well, no, my lord, that's not. a
Under
part
the
of
different
property.
name, they are claiming the acquired property. Under the different name, they are claiming the acquired property. Earlier suit, I am permitted to read the page number 100.
File a separate suit if you want.
They are already filed against the suit, my lord.
ಇನ್ನೊಂದು ಹಾಕಿ.
Kindly see the page number 100.
You can't enter into the dispute between the two vendor and
The
purchaser.
vendor is already suffered a decree against me, my lord. Page number 100, for a moment, kindly see the
We'll
page
see.
number 100.
We'll hear it on 11th, list on 11th, yes. Interim order subsisting in 37.1 shall continue to the next date of hearing, yes.
Lordship, in this case, I am for the petitioner. Can it be taken up next week on 11th? The parties are still
List on
exploring some sort
18th
of settlement.
At the request of the council, you responded, huh?
Respondent number 4 and 17, my lord.
There's no interim order?
No, Your
At the request of the council appearing for the petitioner, list the matter on 18th, yes, next.
Grateful.
For the petitioner, what lords would recollect, this is the application for police protection. And MA
Well,
has been allowed, my lord. MA has been allowed on 1st of this month. I seek for 3 weeks' time, my lord. I'll file appeal, writ petition against that MA order, my lord. Till then,
In the event no orders would come about, consider on merits. Yes, sir.
every day they had asked for adjournment because there is an MA pending.
The MA I have filed is allowed, my lords. Matter could be disposed of.
List the matter after 3 weeks at the request of the council for the petitioner. Pendency of this petition will not come in the way of any for any fora. Next.
In an FTP proceedings, where the daughters have succeeded for getting the partition, my lord, at page number, after the death of the mother, the respondent have filed an application, page number 29, my lord, for reapportionment of the share as IA number 9. Against that, one
So
more
what?
application. I'm the son, my lord.
Correct. So what? Your daughters are getting.
Daughters
So
have
sisters are getting, yes.
daughters reapportionment of the share by me itself, I have filed IA number 9, my lord. Against that, they have filed one IA number 10, stating that will has been executed by the mother on 7/5/2020.
You serve on the respondents.
Yes.
What is the next date?
My lord, next date is today, tomorrow, I think so. Tomorrow.
The petitioner shall serve on the council to represent the respondents before the concerned court and file an acknowledgement. List on 18th.
Final decree, drawing up of the final decree will be.
The concerned court shall not draw up its final decree without the leave of the court. Next, yes.
Is this that administrator matter, my lords? My lords,
Then I got,
sorry, my lords, I was on
Dharwad.
Alla, who should be appointed antala?
My lords,
My
they are
lord,
not
that is not the
agreeable.
No, yesterday's matter is different.
Correct, correct.
This is different.
That's
This is different. The only question before the court is whether the PNSE is to be converted into a TOS or
That
not.
can't be
My
because
lords,
you're not dispute.
judgment.
You're
My
not
lords, I have a
disputing the
judgment.
will.
I have a judgment now. That's just
Even if you don't dispute.
yes, my lord, regarding executor. I'll just ponder. Give me 2 minutes. That's all.
2:30.
Sir, very well.
There's a meeting now.
Sir,
We'll continue at 2:30. All right. In nimde an eviction? No? In what? Adaithu, ಏನು what? Evicting from where? ಅದನ್ನೇ ಕೇಳಿದ್ದು, ರೆಸ್ಟೋರೆಂಟ್ ಏನು ಅರ್ಜೆನ್ಸಿ ಇರೋದೆಲ್ಲ ಅದಕ್ಕೆ, ಈಗ ವೀಕೆಂಡ್ ಕಲೆಕ್ಷನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ. ಆಯ್ತು ಸರ್. Yes, continue the list, man.
Number 41.
Kodi. Then we'll reserve it and pass. No time now. By Monday, Tuesday, we'll do it. Very well. ಏನ್ ಬೇಡ ಅದ್ರಲ್ಲಿ ಇದೆ ಅಲ್ವಾ? ಏನ್ ಹೇಳಿ?
Letters of administration is granted where an executor is not being named in the bill. In this case, the person who is being named as an executor are all dead. Therefore, he started petition by letters of execution. Letters of execution is not just a proceedings in rem, it is a proceedings for the representative because the executor has to represent everybody. There is a judgment number, paragraph 14 of the judgment refers to Madras High Court judgment and the Calcutta High Court judgment which explain the distinction. So my submission is that insofar as that aspect is concerned, that the letters of administration, executor yaar aagta, then there is a conflict of interest. That's first point. Second point, that he has undertaken in the other proceeding, in the petition before this one report, that he will not alienate the property falling to my share. Now the difficulty is that it is undivided property. So he can't, if he can't alienate it.
Which share ಅಂತ ಗೊತ್ತಿಲ್ಲ. Undivided property now.
It is undivided. There are three properties. The testator has left the three property for all the respondents. Now what has happened is that whatever comes to my share, he has undertaken and he will not alienate it. So the difficulty is this: when it's undivided, how do you want?
That is exactly the point. Yes.
That's what I'm saying. Find a wire with the.
May I just make my submission?
Yes, sir.
Just 1 minute.
Sorry.
My lord is saying
Yes.
My lord, insofar as the undertaking is concerned, insofar as the undertaking is concerned, what is falling to his share is not the property. It is the proceeds of the property. So it is a fungible asset, which is not, and that undertaking will not come in the way of me alienating the lands. And that is anyway for the trial court to decide. Insofar as the two judgments that my learned friend has just passed on right now, one relates to a situation wherein an Order 22 Rule 3 application could have been maintained on the death of the executor. The Calcutta High Court held that no such right survives in view of the provisions of Indian Succession Act because the universal legatees are the only persons who can apply if the executor passes away. Insofar as the second judgment is concerned of the Bombay High Court, they relate to interpretation of rules of the Bombay High Court, and they have nothing to do with the provisions of the Indian Succession Act or the probate rules. And the last thing that I just want to pass on to my lords is that if we look at Rule 11 and 12 of the probate proceeding rules of 1966, they say that you will have to convert a PNSC into a testamentary suit only if there is a caveatable interest.
Correct.
And a caveatable interest ipso facto means that the person who has filed the caveat is setting up a title adverse to what is there in the will. So I'll
Not his case also.
That's not his case also. So in light of all these submissions, my lord, my prayer is it may be dismissed.
Shall not alienate or disturb the properties.
My lords, I have also synopsis is there, my lord.
Everything.
And one more judgment about caveatable interest.
Yes. Reserved. Yes. Next. On 11th. Next Friday. I will get it back.
Yes. Great.
42.
Concurrent finding. Divergent. Yes. The first appellate court has granted it.
Petitioner is a government employee. The respondent residing in 40 kilometers far away from the place and she is government employee. Stating that I am the agriculturist. When I was
Where is the document to show that she is a government employee? Plaintiff.
I have printed in my.
Where? Cost title ಹೇಳಿಲ್ಲ. What government employee ಅಂದ್ರೆ ಏನು? Where?
notes that I have taken panel number 11. Petition panel number 11.
Petitioner shall serve on the counsel or represented the plaintiff before the concerned court. He lists the matter on 18th. Till such time, the order of the first appellate court shall remain stayed.
Forty-three.
Where is the affidavit? Oh, we have shown it as served, yes. First suit or earlier Rita? 2025. Yes. The respondents. Why would they alienate the property? Why would they alienate? Correct. How?
I get to know there is a release deed executed in the year 2020 by my siblings in favor of my father in respect of our respective shares.
You are the son.
I am the son. Now, buyers approach every day, then I get to know there is a release deed. Now the property is trying to be sold. It's attempted to be sold.
We'll see. Yes. Till the appearance of the respondent, petition. Who is the contesting respondent? The respondents are served. The service of notice wanting to be effected upon the respondents has been refused, and therefore the petitioner has filed an affidavit. In that light, the direction was issued to show respondents 1 and 2 as served. The learned counsel for the petitioner submits that the father, the first defendant, is wanting to sell the properties in which the petitioner also has a right to claim. In that light, the respondent shall not alienate the property till the next date of hearing. List on 25th.
Forty-four.
We will dispose it, sir. Direction. Yes. The petitioner is before this court seeking the following prayer. The petitioners are defendants, and the suit instituted by the plaintiff in OS 385 of 2006 is for partition. Written statement ga iga. So the suit is said to be pending before the concerned. What stage is the suit in? The suit is said to be pending for the last 18 years and 5 months, and the concerned court is yet to frame the issues even. Therefore, the petitioner defendants are before this court seeking expeditious disposal of the suit. In the light of the issues yet to be framed by the concerned court as on date, I deem it appropriate to direct the concerned court to dispose the suit in accordance with law within an outer limit of 6 months, if not earlier, ordered accordingly. Next is
45.
25th. Yes, next.
46.
25th ಬೇಡ ಅದು 18th ಅಂತ ಮಾಡಿ ಎಂಟ್ರಿ ಮಾಡಿ ಕಂಟಿನ್ಯೂ ಮಾಡಿ 40. Yes, Ajay.
He said that I will involve the safety deposit box. So I said I filed an affidavit saying that more deposit key is more deposit locker key is. So I am waiting for a commissioner to be appointed. Go and see there is a bill.
Take him along with you and check the locker. Take him and see. Yes. Go with him.
I don't have authority. Today I don't have a succession.
Oh, the direction. Which bank?
There are 3 banks.
Vijaya Bank is the Bank of Baroda. Canada Bank is State Bank of India. story has the locker numbers. He says he's got the locker numbers.
The petitioner and the respondent are now in a squabble with regard to what is inside the locker. A locker attached to the accounts at 3 banks. Which banks are those? So and so. The learned counsel for the petitioner submits that if the respondent, the doubt of the respondent is that there is a will inside the locker. The learned counsel for the petitioner submits that he does not have a succession certificate as on date, and the bank would not permit the petitioner to open the locker and check it, or the respondent even. In that light, I deem it appropriate to direct the direct the so and so banks in the account numbers ellide ella. We'll list it after 4 weeks. Where are the account? Where are the account numbers? In what locker shall I say then?
I have.
You have the case. Which is the account number? Locker number is attached to some account number. Which is that account?
Page 37, where I am the nominee, I have mentioned in para 9.
Page
37 of the writ petition. My application, para 9, I have mentioned where I am the nominee, where I suspect that there's a will.
Yavida?
Para 9,
Canara Bank.
Lalbagh West Branch, bearing number so and so.
Para 7 ಅಲ್ಲಿ ಇರೋದು ಯಾವುದು?
Para 9,
Para 9 ಮಾತ್ರನಾ?
Those are the term deposits. The locker is para number 9.
Locker is?
Para number 9,
ಅಲ್ಲೇ ಇದೀನಿ. Maintained further statement so and so bank Lalbagh West Branch and said locker, the applicant number 1 here and Srimati so and so are nominees.
Please.
You are suspecting a will being there, is it?
No, I suspect that there's a will in this locker.
So only this account, this locker. Account number kodi. If you don't have it, you can't box in thin air. Then what? He said this is the locker that is there. You tell me which is the locker that is there. ಅಷ್ಟೇ ತಾನೆ? ಮತ್ತೆ ಇನ್ನೆರಡು ಅಕೌಂಟ್ ಯಾವುದು?
Let's see.
Him.
No, not me.
Me, you, yes. ಈಗ ಫಸ್ಟ್ ಈ ಲಾಕರ್ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ. Yes. In the locker maintained in Canara Bank, madam, page 37, para 9 ಅಲ್ಲಿ details ಇದೆ. The bank officials shall permit inspection of the locker. The inspection shall take place in the presence of the manager of the bank and the presence of both these petitioners. The manager of the bank shall drop the contents in the locker and place it in a sealed cover. Our will party illa. The officials of the bank shall, officials/manager of the bank shall drop an inventory of the contents in the locker. Yes.
Let's, apart from the respondent, there's another nominee. In
First
her
you Muxi
presence as
locker. Yes, next. List on 18th.
well.
Next.
47.
I appear for response.
Objections ಹಾಕಲ್ವಾ?
My lord, ಇದರಲ್ಲಿ will call for ಮಾಡಿದ್ದಾರೆ sub registrar office ಇಂದ under IN number 6 which is challenged in the impugned petition.
So what, let it come.
ಆಮೇಲೆ reason on one submission, the reason for calling this will, my lord, IN number 25 also allowed another will in respect of 2000. Both with one will in favor of plaintiff, another will in favor of first defendant. It's a suit for partition. ಅವನಿದ್ಯಾ ಅವನು will ಇದೆ ಅಂತ ಹೇಳಿದಲ್ಲ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ.
ಈಗ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಮಾಡಿ ಹಾಕಿದ್ದೇನಾಯ್ತು? What happened to that?
Allowed.
ಅವ್ರು ಹಾಕಿದ ಅಪ್ಲಿಕೇಶನ್ ಯಾಕೆ ಬೇಡ? Why are you objecting to that application? No, coming to that, yes. ಈಗ ವಿಲ್ ಇದೆಯಾ ಇಲ್ವಾ? ವಿಲ್ ಇದೆ ತಾನೆ? ವಿಲ್ ಇದೆ ತಾನೆ? ಅವ್ರು ಹಾಕಿರೋ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಇದು Will has to, will is there.
Yes.
Let it be brought before the court. So what?
Approximately just 2 minutes.
Yes, sir.
Interviewed by the plaintiff as its husband died intestate. Mother has filed the suit against two daughters and son. I'm intending for the son. And after receipt of the suit summons, the petitioner has entered appearance.
Now, according to you, there is a will in your favor.
Yes. I have disclosed that in my written statement.
Right.
Saying that suit itself is not maintainable. And during 2000.
What is the will are you talking of?
My lord, his will pertains to 2000. It is called
2000,
for.
correct.
My will 2004, my lord. It is called for under the impugned order now. And my lord, he has not set up any defense or title under the will. Just he has disclosed the will. Now the partition between mother and the 3 children, my lord. So now the plaintiff is a senior citizen, and senior citizenship act also proceedings against this doctor. He is a doctor, son is a doctor. Writ petition is pending. Honorable court has stayed the proceedings of the DC and AC order. So now, my lord, 2000 will call for, under which only the property bequeathed in favor
ಈಗ
of.
2000 will is produced?
It is here, my lord.
ಅಲ್ಲ.
What is the response? Page number
ಐ allow ಮಾಡಿದ್ರ ಅದು?
24. I allow it. That is that I is allowed.
What? Nothing.
Straight
Yes.
away I said no objection to allow that application.
You should also say no objection. If you have objection, I will pass it. ಬರ್ಲಿ ಬಿಡಿ ಆ ವಿಲ್, ನಿಮ್ಗೇನ್ ಪ್ರಾಬ್ಲಮ್? ಅದು ವಿಲ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ ತಕ್ಷಣ ಪಾರ್ಟಿಷನ್ ಆಗೋಗುತ್ತಾ? ಈಗ so what if it is brought before the court? So what? So what, tell me? ಈಗ ನಿಮಗೆ why are you apprehensive of a will coming over? Then why are you worried? That's, you leave it, don't worry about those technicalities. Pleading ಇದೆಯೋ ಇಲ್ವಾ? ಈಗ will, ಸರಿ, ಪರವಾಗಿಲ್ಲ, CPC not followed, we will see.
Both are registered will, my lord. I have.
ಅವರ ಕಷ್ಟದಲ್ಲಿದ್ದಾರೆ, ಸುಮ್ಮನೆ ಇರಿ.
Father has executed a will in my favor with respect to the suit schedule property. Not only that, my lord, that is what I will kindly turn page number 26. Whereas dependent number 3 in the suit.
Your sister?
That's my sister. She also got another one more property from the father. The same will where father has executed a will. In that, petitioner got one property, whereas my sister got other property. Whereas in that, my lord, when you see, my lord, witness column, unknown money, MS.
ಬರ್ಲಿ ಬಿಡಿ ವಿಲ್, so what?
No, you asked me to that is complete, my lord.
ಅದೇನ್ ಅವಾಗಿಂದ ಹೇಳ್ತಾನೆ ಇದ್ದೀರಾ, ಕಂಪ್ಲೀಷನ್ ಬರ್ತಾನೆ ಇಲ್ಲ.
See, my lord, she was one of the witness, she also got the property, and in the suit file, both the sisters, except filing their wakalat, they have not filed the return statement. In all the dates of hearing, sister who got the property during, as per the will
4.
not 2000, along with the petitioner, she was all the dates of hearing, she will be present before the court. And
ಪರವಾಗಿಲ್ಲ, it's your sister, sir. Let's see what is there.
And at that time, I requested the court to permit us to examine the sister before this, but she was not to be.
No problem. Now she will do that. Your grievance will be taken care of. She has not examined herself. Want to examine, will permit. But will come.
And 2000 will has been cancelled in 2004 will, my lord. There is a recital in the.
ಸಿಕ್ಕೆ ಭಯ ಅವ್ರಿಗೆ. ಮತ್ತೆ ಬಿಡಿ ಸರ್, ಯಾಕೆ? Anything else? Yes. The petitioner is before this court, calling in question. ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಮಾತ್ರ ಅಲೋ ಆಗ್ಬೇಕು, ಅವ್ರದ್ದು ಆಗ್ಬಾರ್ದಾ? ಮತ್ತೆ we will say yes. The petitioner is before this court, calling in question an order dated 24/4/2025, rejecting and allowing an application in IA 26 in OS 1236 of 2023, filed by the present filed by the respondent number 1 plaintiff seeking partition of the property. The
Defendant number 3, my lord.
defendant number 3, yeah.
You are not plaintiff.
Filed by defendant number 3 seeking partition of the property. That is correct. The issue heard so and so. The issue revolves around existence of two wills. One will that is executed on 29/5/2000, a copy 29/5/2000, which was summoned to the court on an application filed by the present petitioner, who is the son of the first son of the plaintiff, and one late Shivanna. It transpires that late Shivanna had bequeathed certain properties in favor of the son and the daughters. In terms of the will dated 29/5/2000, on an application so filed as observed herein above, the will is summoned. Likewise, the first petition, plaintiff. The plaintiff then prefers an application seeking summoning of a will that is said to have come into existence in the year 2004.
22/12/2004.
On 22/12/2004, the learned counsel for the respondent applicant submits that the will earlier, which was made in favor of the petitioner, stood cancelled, and a subsequent will has been executed by the father on 22/12/2024. Therefore, the said application, therefore the application is filed for summoning the said will. If the application of the petitioner, the defendant number 3, could merit favorable consideration at the hands of the concerned court, the same could not have been denied to the plaintiff who wanted to place on record a particular will. And since the entire issue before the concerned court revolves around the claim for partition, the two wills that are said to be in subsistence are necessary to be considered by the concerned court. In that light, there is the order that is passed allowing the application filed by the plaintiff seeking summoning of the will dated 2/12/2022.
25/9 yes, my lord.
22/12/2024 does not warrant any interference, as I do not find any perversity in the order. The submission of the learned counsel for the petitioner is that there was no pleading with regard to the existence of the will, and they have not filed their written statement, plaintiff written statement. I will see. Yes, so and so.
Lord,
In that light,
I pray for speedy dispose. My client is 85, my lord.
is suit hours to this, sir.
Suit filed in 23,
Yes.
my lord.
So and so. Do not find any warrant to interfere. Petition stands dismissed. The concerned court shall endeavor to conclude the proceedings as expeditiously as possible in the light of the advancing age of the first defendant, the plaintiff, before the concerned court. Yes, next.
48.
Time may be fixed.
No, sir.
Lords, Lords, in both the petitions I appear for the petitioners. The issue, my lords, I had is concerning the violation of the
Objection, Saki.
my lords, on the last day. On the last day,
Nitin sir, interim order is there.
my lords, in fact, your lordship expressed the opinion that the interim order itself is worthy of being the final order, my lords. Clear violations, it's almost.
Will consider that.
My lords, a short date may be given. It's irrebuttable questions on law, my lords.
The learned HCGP seeks 2 weeks' time to file statement of objections. Objections, if any, by the next date of hearing, list the matter on 25th. Yes.
My lords, interim order may continue.
Interim order subsisting would continue till the next date of hearing.
49.
Please, grateful.
Respondent.
Application allowed or rejected? Who else should do it? Who else should do it? Correct, sir. Who else should do that in the FDP? Maybe. Yes, sir.
Lord, my application is this, my lord. My lord, the A scheduled property consisting 4 shops and 2 residential house, my lord. My lord, the petitioner is getting the 40,000 rent per month, my lord. My lord, till this date, he has not disclosed the rent, my lord. And also, my lord, the B scheduled property is getting a more than 50,000 income per year, my lord. Now, he has not disclosed the income.
ಅಪ್ಲಿಕೇಶನ್ ಏನ್ ಸಂಬಂಧ ನೀವು ಹೇಳ್ತಿರೋದು?
ಅಲ್ಲ ನಾನು ಆ ಅಪ್ಲಿಕೇಶನ್ ಅದಕ್ಕೋಸ್ಕರ ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿ
ಏನ್ ಫಾರ್ ದಿ ಪರ್ಪಸ್ ಆಫ್ ಡಿಟರ್ಮಿನೇಷನ್ ಆಫ್ ವಾಟ್?
ಫಾರ್ ವೆರಿಫೈಯಿಂಗ್ ದಿ ಇನ್ಕಮ್ ಅಲ್ಲ.
ವೆರಿಫೈಯಿಂಗ್ ದಿ ಇನ್ಕಮ್?
ಎಸ್ ಮಲ್.
ಯಾಕೆ ಹೆಂಗ್ ಕ್ಯಾಶ್ ಅಲ್ಲಿ ಕೊಡ್ತಾ ಇದ್ದಾರಾ? ವೇರ್ ಇಸ್ ದಿ ರೆಂಟಲ್ ಅಗ್ರಿಮೆಂಟ್ಸ್?
My lord,
let the commissioner go and assess the rent. So
my lord, the said application allowed on 7/2/2024, my lord. Now he has challenged, my lord.
7/2 na?
Yes, my lord. 7/2/2024, my lord.
What has happened after that? Anything else, sir? Yenna? On what? When did you produce it? When did you produce it? When? Long ago. That is not considered, is it? Now it is considered and rejected. Where is what is the order? Where is the order? Impugned order also, sir.
And in fact, the matter was once posted for argument on the mail also. At that stage, this IA was filed by the respondent.
Yes, sir.
My lord, for modifying the preliminary decree, my lord, he has not filed any application before the court, my lord.
Any objection itself to the FD, and my prayer is to modify the share. They sought half share. In the preliminary decree, 1/3 was allotted to the respondent. It's only let the court pass or then commission will be appointed. That's all. Nothing else.
ಈಗ ಯಾವ್ದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ?
Well, my respectful submission is this, my lord. My lord, in my objection, I have detailed stated, my lord, page number 78, my lord. 78, my lord.
Could it list the matter on Wednesday? Yes. Could you judgment could?
Is divergent findings. I sought for injunction, partition and injunction. And the trial court has granted injunction till the disposal of the suit. Subsequently, the respondent.
First appellate court has reversed it?
Yes, yes, madam.
Yes. Really.
And the respondent number 2 has purchased pendant litte for 50 lakhs. Where there is pecuniary jurisdiction.
Who are you?
I am the plaintiff. Yes, yes.
Vendor.
No, I am the partner.
Suit for what?
Suit for declaring that I am got a share.
In what?
In the social property. We have purchased jointly. We have purchased the property. 2 survey numbers. That is survey number.
The petitioner shall serve the counsel who represents the defendant number 1 before the concerned court. List the matter on 25th.
The property, already they have taken conversion.
the petitioner shall serve on the council of representatives, so list the matter on 25th. Status quo que, the property be maintained till the next date of hearing. Status quo que, the suit schedule property be maintained till the next date of hearing. Yes.
P1.
My lord, I am for the petitioner respondent, petitioner defendant, my lord. Exist the divergent finding of the learned appellate judge, I am before, the defendant is before your lordship. My lord, few facts are necessary for the purpose of disposal of my application for interim order. My lord.
We and Welfare Association, the problem.
How?
Yes,
My lord.
You are the plaintiff.
Welfare Association, represented by the secretary. He has been lodged a complaint before the competent authorities about the illegal construction and also violation of the building bylaws. No action has been taken. So that he has filed a suit. Well, not to put up construction in violation of the building.
You have filed a suit.
Yes, Your Honor. And they also filed a suit. Their suit for injunction has been dismissed.
I'm sorry, my lord, we have not filed any suit. It is their suit. We are defending the case.
Suit in OS?
201, I next just see, my lord.
Yes.
Let me, at page 35 to 42, in page, I'm sorry, my lord, copy of the plaint at page, annex D, in page 43. Annex D, copy the plaint in OS 201 of 2025, filed by the respondent plaintiff before the learned principal.
You will undertake not to put up any construction?
My lord, beg your pardon?
Commercial.
No, it's not a commercial building.
I thought you undertake not to put up any construction.
No, my lord, there is an finding by the learned appellate judge. He has modified the order based on my submission.
What is that?
Permit him to put up construction.
No, my lord, my
what is that, sir?
No, after filing my first two injection later on after filing my petition, the defendant moved the learned appellate judge for modification of the order.
Which is the suit filed by him?
We have not filed any suit.
Wait.
One nimsha. OS number 459 bar 2025.
459 bar?
2025. On the fine of the JMFC at Anekal, civil judge and JMFC Anekal.
ಅದೇನೋ ಆರ್ಡರ್ ಏನಾಗಿದೆ ಕೊಡಿ ಇಲ್ಲಿ.
ಯಾವ ನಂಬರು?
Reject ಆಯ್ತು. ಒಂದು ನಿಮಿಷ ಕೊಟ್ಟದ್ದು.
Let me have the idea. I don't know anything.
You have no idea?
I have no idea. That's let me have the idea.
Then we'll take it after 2 weeks. You develop the idea.
No, not necessarily, my lord. Let me have the. In fact, this is.
Wait, sir. ಏನಿದು ನೋಡ್ತಾ ಇದ್ದೀನಿ ನಾನು. Even I have no idea. Wait.
Ex parte ತಗೊಂಡಿದ್ರು. ಒಂದು ನಿಮಿಷ. Ex parte ತಗೊಂಡಿದ್ರು. We appeared filed our objection.
Sometimes surprises come like this.
ಹೌದು. It is suppression of error.
Our surprise and suppression. Wait, sir. You are Krishna R.
Also.
Krishna R, my client.
Petitioner.
Krishna R is the defendant in the suit. All right. OS 201 of 25.
Yes, my lord.
Injunction rejected.
By them, filed by them. Filed by the plaintiff, respondent.
Orders are ನೀವು ಹಾಕಿರೋದು ಇದು
ಯಾವುದು ನಮ್ದು
201 ನಿಮ್ದೆ
ಮೈ ಸಬ್ಮಿಷನ್ ಕೃಷ್ಣ ಸಿ ನಮ್ದು OS ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಸಿ ಒಂದ್ ನಿಮಿಷ ಹೇಳ್ಬಿಡ್ತೀನಿ
201 ಯಾರ್ದು
ಒಂದೇ ನಿಮಿಷ 201 ನಮ್ದು ಸ್ವಾಮಿ
ಈಗ ಇದ್ಯಾವುದು
ಇದು 201 ಮೇಲೆ ಬಂದಿರೋದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ರಿಜೆಕ್ಟ್ ಮಾಡಿ
ಇನ್ನೊಂದು ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ ಅಂದ್ರೆ
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ರಿಜೆಕ್ಟ್
ನಿಮಿಷ ಒಂದ್ ನಿಮಿಷ ಇನ್ನೊಂದು ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ ಅಂದ್ರೆ ಯಾವ್ದು
ಹೌದು ಅದು ಅಲ್ಲಿ ಕೊಡ್ತೀನಿ ಸುಮ್ಮನೆ ಒಂದು ನಿಮಿಷ ಕೊಟ್ಟು ಬಿಲ್
ಅವ್ರಿಗೆ ಕನ್ಫ್ಯೂಸ್ ಆಗ್ತದೆ ನಾನೆಲ್ಲ ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ತಾರೆ
ಒಂದು ನಿಮಿಷ ಸರ್
ಅವ್ರಿಗೆ ಐಡಿಯಾ ಇಲ್ಲ ಈಗ ವೇಟ್ ಸರ್
ಕನ್ಫ್ಯೂಸ್ ಮಾಡೋ ಅಂತದ್ದು ಏನಿಲ್ಲ ಅದರಲ್ಲಿ ಕೋರ್ಟ್ಸ್ ತೀರ್ಮಾನ ಮಾಡುತ್ತೆ
ಅವರು ಕೃಷ್ಣ ಸಿ ನಮ್ದು
ಯು ಆರ್ ರೆಫರಿಂಗ್ ಟು ದಿ ಸೂಟ್ ಫೈಲ್ಡ್ ಬೈ ಹಿಮ್ ಓನ್ಲಿ ಆ ಸೂಟ್ ಅಲ್ಲೇ ಇಂಜಂಕ್ಷನ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರು ಅಂತ ಹೇಳಕ್ಕೆ ಇನ್ನೊಂದು ಸೂಟ್ ಅಂತ ಇದ್ದೀರಾ
ಒಂದ್ ನಿಮಿಷ ಕೊಡ್ತೀನಿ ಇಂಟರ್ ಮಾಡ್ರ ಸರ್
ನೀವು ಹುಡ್ಕೊಂಡ್ ಬನ್ನಿ
Just
on Monday.
My lord, let me make one submission, my lord.
Monday.
Here is a case where you will make
ಈಗ Monday ಅವ್ರಿಗೆ ಏನಾಗುತ್ತೆ
let
Monday ಅವ್ರಿಗೆ ಏನಾಗುತ್ತೆ
my lord, stay of that
Monday ಅವ್ರಿಗೆ ಏನಾಗುತ್ತೆ
the divergent finding, my lord.
the learned trial judge has given a very good
Based on-
finding.
Very good finding.
Yes, my lord, because
Yes,
yes,
Your Honor.
my lord, the learned trial judge has opined that the plaintiff respondent has no locus standi to file the suit. In fact, if I am permitted, kindly see annexed the
ಈಗ
complaint,
1 minute.
complaint,
ಬಿ- ಒಂದ್
plain
ನಿಮಿಷ,
copy.
ಒಂದ್ ನಿಮಿಷ. ಇದು BBMP ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದೀರಾ?
ಏನ್ ಸ್ವಾಮಿ?
ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದೀರಾ?
ಹೌದು.
ಎಲ್ಲಿ?
ಲೋಕ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ ನೋಡಿ ಸ್ವಾಮಿ.
ಯಾರ್ಯಾರು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದೀರಾ?
I produce documents, nearly about 20 documents or 23 documents produced. Your Lordship, see that what is my complaint, Your Lordship. Your Lordship, in page number 8. First complaint. Then Your Lordship, Karnataka, avರಿಗೆ ಒಂದು second complaint, internal page 9. Then Your Lordship, Panchayati has been issued a notice to that one, Your Lordship, about complaint, my complaint. Thereafter, Your Lordship, complaint to the Karyadarshi, the Anekal town, ಇವರಿಗೆ Anekal authority, planning authority. It is in page number 9, 11.
ಒಂದ್ ನಿಮಿಷ, ಈಗ ಅವ್ರ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಪುಟ್ ಅಪ್ ಮಾಡ್ತಿದಾರಲ್ಲ.
ಆಯ್ತು ಸರ್.
My lord, let me make it
One
clear.
minute, 1 minute. Where are the statutory clearances for putting up construction?
My lord, the.
ಎಲ್ಲ ಕೊಡಿ.
Yes, in fact,
Give-
my
give
learned friend
everything.
himself, my learned friend has himself has produced before your lordship about getting my license as well as license grant, I mean, plan sanction to me. My lord, I do
ಗ್ರಾಮ ಪಂಚಾಯತ್
concede,
ಕೊಟ್ರದ?
my lord, I do concede.
ಗ್ರಾಮ ಪಂಚಾಯತ್ ಕೊಟ್ರದ?
ಹೌದು, ಗ್ರಾಮ ಪಂಚಾಯತ್ ಲೈಸೆನ್ಸ್
ಎಲ್ಲಿದೆ? Where is the license?
ಆನೇಕಲ್ ಪ್ಲಾನಿಂಗ್ ಅಥಾರಿಟಿ ಅವರು ಲೈಸೆನ್ಸ್ ಕೊಟ್ಟು ಇದು ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ?
ನಮ್ಮ ಫ್ರೆಂಡೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
Where is the application and where is the sanction?
My lord, your lordship will be pleased to find.
That portion, Your Lordship, from the additional document ಇದೆಯಲ್ಲ ಸ್ವಾಮಿ, in page number 40 ನಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. ಅವ್ರು ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಪ್ಲಾನು ಮತ್ತೆ ಅವ್ರದ್ದು ಲೈಸೆನ್ಸ್ ಪ್ರಾರಂಭಿಕ ಪ್ರಮಾಣ ಪತ್ರ ಅಂತ ಒಂದು ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ ಆನೇಕಲ್ ಟೌನ್ ಪ್ಲಾನಿಂಗ್ ಅಥಾರಿಟಿ ಅವರು. 2 ಫ್ಲೋರ್ ಕಟ್ಟಕ್ ಮಾತ್ರ ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ನೆಲ ಮತ್ತು ಮೇಲಿನ 2 ಅಂತಸ್ತುಗಳಲ್ಲಿ
ಇವ್ರು 4 ಫ್ಲೋರ್
ವಸತಿ ಕಟ್ಟಡ ನಿರ್ಮಾಣಕ್ಕೆ ಪ್ರಾರಂಭಿಕ ಈಗೇನ್ ಕಟ್ತಾ ಇದ್ದಾರೆ?
4 ಫ್ಲೋರ್ ಕಟ್ಟಿದ್ದಾರೆ. 4 ಫ್ಲೋರ್ ಕಟ್ಟಿ.
ಎಲ್ಲಿದೆ? ವೇರ್ ಇಸ್ ಇಟ್?
My lord,
ಫೋಟೋ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ.
my lord, let me make it clear, my lord.
ಒಂದ್ ನಿಮಿಷ ಸಾಹೇಬ್ರು ಅವ್ರು ಕೇಳಿದಾಗ ನಾನು ಹೇಳ್ತೇನೆ.
ಎಲ್ಲಿದೆ ಫೋಟೋ? ಎಲ್ಲಿದೆ?
ಇಂಟರ್ನಲ್ ಪೇಜ್ 54, 51 ಇಂದ 50 ಇಂದ ತಗೊಳ್ಳಿ ಸ್ವಾಮಿ.
ಇದಾ?
ಹೌದು ಸ್ವಾಮಿ. 48 ಇಂದ ಇದೆ ಸ್ವಾಮಿ, ಫೋಟೋಗಳು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ. 47 ಇಂದ ಯಾವ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ತಾರೆ ಡೇಟ್.
ಅಲ್ಲ, let me make one submission, my lord. Let me have the base of
ಗ್ರೌಂಡ್ ಪ್ಲೇಸ್ 2 ಇರೋದು, ನೀವು ಎಷ್ಟು ಕಟ್ತಾ ಇದ್ದೀರಾ?
ground plus 2 plus penthouse, ಮೇಲೆ ಒಂದು penthouse ಕಟ್ಟಿದ್ದೀನಿ.
ಪೆಂಟ್ ಹೌಸ್
ಅಂದ್ರೆ
ಎಲ್ಲಿದೆ?
In fact, my lord, may kindly appreciate, Anekal Planning Authority have permitted me to go for deviation in case of necessity.
Permitted to go for deviation.
Orally it was given.
Which orally permitted?
Yes, my lord. Let me be very, my lord, G+2 is the sanction of plan.
Whoever has told you, Anekal Planning Authority annalla, I will ask criminal proceedings to be initiated against that man who was orally told you.
No, this has been done in the usual course, my lord.
Usual course.
It cannot be done in writing. Let me make it very clear, my lord.
Oh.
He is so influenceable person.
ಏನಂದ್ರೆ
ಇದು ರೈಟಿಂಗ್ ಅಲ್ಲಿ ಕೊಡಕ್ ಆಗಲ್ಲ. Usual course ಅಲ್ಲಿ ಆಗಿದೆ.
ನನ್ಗೊಬ್ಬನ್ಗೆಲ್ಲ ಲೋಟಸ್ ರೆಸಿಡೆನ್ಸಿ ಅಸೋಸಿಯೇಷನ್ ಅಲ್ಲಿ there are 35 constructions have gone.
ಎಲ್ಲರಿಗೂ we will
Everybody has
direct
gone for
action to be taken.
My lord,
Anekal Planning Authority party ಇದರ ಇಲ್ಲ?
ಹೌದು ಮಾಡಿ.
ಇಲ್ಲ
ಅವರು ಫೈಲ್ ಮಾಡಿರೋದು. ಅಲ್ಲಿ ಆನೇಕಲ್ ಗ್ರೌಂಡ್ ಪ್ಲಾನಿಂಗ್ ಅಥಾರಿಟಿ.
No problem. Implement Anekal Planning Authority.
ಅಲ್ಲ ಸುಮ್ಮನೆ ಒಂದ್ ನಿಮಿಷ, let me make it clear, my lord.
You are making it clear. ಅವಾಗಿಂದ ಕ್ಲಾರಿಟಿನೇ ಬರ್ತಾ ಇಲ್ಲ.
ಅಲ್ಲಲ್ಲ, 109 ಸೈಟ್ಸ್ ಅಲ್ಲಿ 35 ಸೈಟ್ಸ್ ಎಲ್ಲ ಡಿವಿಷನ್ ಆಗಿದೆ. ನನ್ನ ಒಂದ್ರ ಮೇಲೆ ಮಾತ್ರ ಕೇಸ್ ಹಾಕಿರೋದು. 35 ಸೈಟ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲ
ಅದು you have not gone and met him in the usual course.
ಅದಕ್ಕೆ ಆಗಿದ್ದು. ಈಗ ಇದಾಗದಿದ್ದಕ್ಕೆ ಈಗ ನಾವು ಸರಿಯಾಗಿ ನೋಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ರೆ ಅವ್ರನ್ನ, ಅವ್ರ ಕೇಸು ಆಗ್ತಾ ಇಲ್ಲ, ನಮ್ಗೆ ಪ್ರಾಬ್ಲಮ್ ಬರ್ತಾ ಇರ್ಲಿಲ್ಲ. ದಿಸ್ ಇಸ್ ದಿ ಸಿಚುಯೇಷನ್.
ಸರ್, ವೆಲ್ಫೇರ್ ಅಸೋಸಿಯೇಷನ್ ಅವ್ರ ವೆಲ್ಫೇರ್ ನೋಡ್ಕೊಳ್ದೆ ಹೋದ್ರೆ ಇದೆ
ಆಗೋದು. 10,000 ತಗೊಂಡ್ಯಾರ ಸ್ವಾಮಿ, ಮತ್ತೆ 25,000 ಕೇಳಿದ್ದಾರೆ, ನಾನು ಕೊಟ್ಟಿಲ್ಲ. ಯಾಕೆಂದ್ರೆ ಸ್ಟಿಲ್ ಐ ಆಮ್ ನಾಟ್ ಎ ಮೆಂಬರ್ ಆಫ್ ದಟ್ ಅಸೋಸಿಯೇಷನ್.
ಮೆಂಬರ್ ಆದ್ಮೇಲೆ ಕೊಡ್ತೀನಿ ಅಂದ್ರೆ?
ಹೌದು, ಯಾಕೆಂದ್ರೆ they have, in fact they have sought 25,000 if I put up construction over and above ground floor.
ಈಗ now we will implement Anekal Planning Authority.
ಅಲ್ಲ, not necessarily in this case. Let me make
ಬರ್ಲಿ ಬಿಡಿ.
ಅಲ್ಲ ಸ್ವಾಮಿ, let me make it clear.
ಅವ್ರು ಯಾರು ಓರಲಿ ನಿಮ್ಗೆ ಹೇಳಿದ್ರು ಅದೆಲ್ಲ?
ಅಲ್ಲ, out of record, let me not make it very.
ಇಲ್ಲೇನು ಔಟ್ ಆಫ್ ರೆಕಾರ್ಡ್ ಆಗ್ತಾ ಇದೆ ಅಲ್ಲ?
ಅಲ್ಲ, ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ, but let me make it clear, my lord.
ಅದೇ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ.
ಅಲ್ಲ, ಇವಾಗ submission, my lord. How the suit has been framed, ಅದು ಇಂಪಾರ್ಟೆಂಟ್.
ಅದಲ್ಲ,
how have you built the house unauthorizedly? ಅದು important.
ಅಲ್ಲ ಅವ್ರಿಗೆ ಅಥಾರಿಟಿ ಇದೆ ಸ್ವಾಮಿ ಕೇಳೋದಕ್ಕೆ. ಆನೇಕಲ್
ಯಾರಿಗೆ ಅಥಾರಿಟಿ ಇದೆ?
ಸ್ವಾಮಿ ಆನೇಕಲ್ ಪ್ಲಾನಿಂಗ್ ಅಥಾರಿಟಿ.
ಅವ್ರನ್ನೇ ಈಗ ಕರೆಸ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾ ಇದೀನಲ್ಲ.
ಸ್ವಾಮಿ ಅದು ಇವಾಗ ಸದ್ಯಕ್ಕೆ ಅವ್ರು ಹಾಕಿರೋ ಪ್ಲೇಂಟ್ ಪ್ರಕಾರ ದೇ ಆರ್ ನಾಟ್ ದಿ ಅಥಾರಿಟಿ ಟು question my authority, question my construction.
Who has to question?
Anekal planning authority has to question my construction.
ಅವ್ರನ್ನೇ ಇಂಪ್ಲೀಡ್ ಮಾಡಿಸ್ತೀನಿ.
No. For this case, as per their pleading, I need not have to make Anekal planning authority as a party to this proceedings.
Court is saying you make Anekal planning authority.
Let me
make it clear.
Allala, let me make it clear.
Make it clear.
Allala, Annex D may kindly be seen. What is the suit framed by the plaintiff? If I am permitted to take your honor's kind attention.
Now you are against an order. Here, I will, for answering that order, I will need the presence of Anekal planning authority. Because the association has said ground plus 2 ಗೆ ground plus 4 ಬರ್ತಾ ಇದೆ. ಅದನ್ನ ನೀವು penthouse 1, penthouse 2 ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಾ.
ಅಲ್ಲ ಸ್ವಾಮಿ, let this submission may not be taken as so much.
ಅಷ್ಟೊಂದು
ಬೇಕಾಗಿಲ್ಲ. ನಾನು ಹೇಳ್ತಾ ಇರೋದೇನು ಅಂದ್ರೆ, ಇದೇ ತರ ಡಿವಿಷನ್ ಬೇಕಷ್ಟಾಗಿದೆ, 35 ಸೈಟ್ಸ್ ಅಲ್ಲಿ ಆಗಿದೆ. ಅದು ಯಾರು ನೋಡಿಲ್ಲ. ನಾನು ತಾವು ಹೇಳಿದ
Anekal planning authority I will direct to take action on all those sites.
Your last rightly question me. In fact, the local Gram Panchayati have issued notice to those persons who have violated the building construction.
It's all right. Now one ನಿಮಿಷ.
ಅಲ್ಲ, kindly see, ನನ್ಗೆ ಹೆಂಗೆ ಇವರು ಸೂಟ್ ಫೈಲ್ ಮಾಡಿ ನನ್ಗೆ ತೊಂದರೆ ಕೊಡ್ತಾ ಇದಾರೋ,
ಬೇರೆ ಯಾರಿಗೂ
ಯಾರಿಗೂ ಮಾಡಿಲ್ಲ. ಅವರೆಲ್ಲ ಡಿವಿಷನ್ ಮಾಡಿ ಸುಮ್ಮನೆ ಇದ್ದಾರೆ, ನನ್ನ ಮೇಲೆ ಮಾತ್ರ ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ. That's how I'm placing before your lordship. That's the reason why I'm seeking your lordship.
Article 14 violation. Article 14 violation.
ಅಲ್ಲ, whether the respondent plaintiff has authority or locus standi to come before the court. Adu important.
According to you, who has the authority?
Well, Anekal planning authority has to question me.
Anekal planning authority, I will direct you to implead.
Well, may make one submission. Before that, there is licensing authority is that Vanakanahalli Gram
Panchayat. ಅಂದ್ರೆ ಇಲ್ಲ, Anekal planning authority ಬಂದ್ರೆ ಅದೆಲ್ಲ ಬರುತ್ತೆ ಆಚೆಗೆ.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಮುಂಚೆ should your lordship should not look into the other issues.
No. First this issue I will decide. Other issues ಆಮೇಲೆ ನೋಡಿ.
109 sites ಅಲ್ಲಿ 35 sites ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆದಾಗ Anekal planning authority ಆ ಕಡೆ ತಿರುಗಿ ನೋಡಿಲ್ಲ.
ಈಗ ನೋಡ್ತಾರೆ.
ಇವಾಗ ಇವರು ಹಾಕಿದ್ಮೇಲೆ ಅವರು Anekal still today they are not prepared to question me. The difficulty is
madam, Anekal planning authority ಯಾರು?
ಯೋಗೇಶ್ ನಾಯಕ್.
ಅದು ಗೊತ್ತಲ್ಲ. Correct. Yes.
Melod,
petitioner to serve set of papers upon.
I don't mind making them as a party. In the meantime, may I make one submission? Kindly see Annex D in page 43, how the suit has been framed. We are guided by the plaintiff.
No problem. Suit has been framed, you are also framed.
Melod,
yes.
May one suggestion. In view of the same, the case attempted to be built by the plaintiff respondent appears to be suffering from fatal infirmity. So much so.
We will see. We'll get the Anekal planning authority. What fatality is there?
Matter, my lord.
No problem.
It goes root of the matter.
Petitioner
and it checks the very foundation of the case.
Petitioner to serve set of papers upon the counsel Sri Yogesh Nayak, who is said to be representing the Anekal planning authority with complete annexures forthwith. The respondent also shall serve the entire set of documents placed before this court to the said counsel Yogesh Nayak. List the matter on 11th in preliminary hearing.
My lord, one submission, my lord. Here is a case where the learned appellate judge diverting his view and made a order upon my application seeking modification of that order. He has modified his own order after filing my writ petition.
Same way, sir. Here is a judge who is not listening to that order but getting Anekal planning authority.
Swami, unnecessary ಅವನ್ನೆಲ್ಲ
ಯಾಕೆ ಅನ್ನಿಸ್ತು?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರು ಹಾಕಿರೋ ಕೇಸ್ಗೆ ನಾನು ಡಿಫೆಂಡ್ ಮಾಡ್ಕೋಬೇಕು. Anekal planning authority ಯಾಕೆ ಸ್ವಾಮಿ ಕರ್ಕೊಂಡ್ ಬರ್ಬೇಕು ಈ ಕೇಸ್ಗೆ?
ಅಲ್ವಾ? ಇರ್ಲಿ ಬಿಡಿ.
ಅಲ್ಲ, I seek your lordship's indulgence. ಯಾಕೆಂದ್ರೆ we are guided by the plaintiff, not by the.
Don't worry, sir. What you will be guided by ಅಂತ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ ಆಮೇಲೆ. ಎಲ್ಲ ಇಲ್ಲಿಗಲ್ ಅನಾಥರೈಸ್ಡ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿ
ಸ್ವಾಮಿ, ನನ್ನ ಒಬ್ಬಂದೇ ಆಗಿದ್ರೆ ಐ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್.
ಅದಕ್ಕೆ ನಿಮ್ಮ ಒಬ್ಬರದೇ ಅಲ್ಲ ಅಂತ Anekal ಕರೆಸ್ತಾ ಇರೋದು. ಎಸ್.
Much work.
Yes.
52.
petitioner, Your Lordship. This is a matter pertaining to a partition suit, Your Lordship. The court issues the notices to the defendants number 1 to 3, Your Lordship. And this was returned as endorsement refused. And subsequently on 3rd of June 2025, the judge places this for judgment on 5/7/2025. On 5th of June, I filed an advance application seeking to file an application under Order 9, Rule 7. That was rejected, Your Lordship. On that behalf, I am before Your Lordship.
The petitioner shall serve on the counsel for the plaintiff. Next date in.
Nalige, Your Lordship.
Serve on the counsel for the plaintiff. List the matter on Monday. List the matter on Wednesday. The concerned court shall defer its proceedings till the next
And
day.
deliver, Your Lordship.
Yes. Next.
53.
My lord, in this matter, my lord, I appear for the petitioner. My lord, I must first, my lords, right at the outset, say that there are two defaults that I am responsible for. My lords, I did not complete the project on time. And my lord, I was supposed to refund the money. I've refunded part of it. My lords, a couple of checks bounced. But what has happened, my lord, is that case after case is being filed against me. Firstly, my lords, a section 138 case is filed against me. Then,
No,
my
that's
lords,
all right. What is the case? What is this case about?
my lord, this case, my lords, is after my lords getting a decree.
How are you seeking stay of RERA proceedings?
Yes, my lords, because my lords is barred by res judicata. The same respondent has obtained a decree.
GM, why is it before special order?
My lord, before, because my lords, the roster
File an
judge had
appeal.
a disseminate.
File an appeal, sir.
My lord, the order is passed without jurisdiction, my lord. And there
Why
is, my
without
lords, it is barred-
jurisdiction?
my lord, it
Why
is
without
barred by res
jurisdiction?
judicata. My lord, the reason is this, my lords, kindly have, my lords, the order of the civil court at page 74, annexure H. My lord, on the same cause of action, my lord, the respondent files a complaint, files a plaint in Ahmedabad, gets a decree for 1 crore 10 lakhs. And then, my lord, suppressing the fact that he's got a decree on the same cause of action, he files a complaint before the RERA again.
But the
And he
learned
gets
senior
also
counsel
higher.
Pramod Nair appearing for the petitioner. The petitioner, emergent notice to the respondent petitioner shall also serve the respondent apart from taking out steps by way of hand summons. The district commissioner, deputy commissioner,
Deputy Commissioner, I will
learned HCGP is directed to accept notice for respondent 3. Counsel Shri Gautam Dev Ullal is directed to accept notice for the 4th respondent. 1 and 2 matra, madam. First edit. Emergent notice apart from so and so. List the matter on 25th. There shall be an interim order as prayed for till the next date of hearing.
Deeply
Next.
obliged, my lords. Very grateful.
List 2.
It's number 2.
It's for the respondent. Let's kindly pass on, my lord.
For the defendant.
Pass over.
Preliminary hearing, seal number 2.
Mandamus to dispose IA 3 and 4. Kodi. Score ಎಷ್ಟಾಗಿದೆ? Score ಏನು? Score ಏನು? Score ಏನು? The petitioner is before this court seeking the following prayer. IA 3 and 4 ಯಾವಾಗ ಹಾಕಿದ್ದು? ಫೈಲ್ ಇಲ್ಲಿ ಓದೋದಲ್ಲ. ಓದಿಲ್ವಾ?
ಓದಿದ್ದೀನಿ ಸರ್.
ಎಲ್ಲಿ IA 3 and 4 ಏನು?
Order 21 Rule 97.
ಯಾವಾಗ ಹಾಕಿದ್ದು?
29/8/24.
The petitioner is before this court seeking the following prayer. The heard so and so. The petitioner is said to have filed application under Order 21 Rule 97 in FDP 12 of 2023. The said applications are pending adjudication and further proceedings are continued is the allegation of the petitioner. The application is filed on 28/3/2024 and no order is passed on the said application. Therefore, the petitioner is before this court seeking a direction by issuance of a writ in the nature of mandamus to direct orders to be passed upon the said application. In the light of the said application's pending consideration, from 21/8/2024, the concerned court shall endeavor to conclude, shall endeavor to pass necessary orders on on the applications IA 3 and 4 filed under Order 21 Rule 97 with an outer limit of 2 months, if not already passed. Ordered according. Yes, next.
3,
The order passed by the trial court on the application. filed by the
2190.
Plaintiff's petition.
I'm
Or-
the second respondent.
Yes.
And for the 3 and 4, who is the auction purchaser?
Respondent number 1 is the contesting party. He filed an application under order for 21 Rule 90 for set aside of action sale, on which the trial court opined that there is need of inquiry. Your Lordship, kindly see, the suit was filed by the father of the petitioners and the
Where
respondents.
is the opinion of the court that inquiry is needed? Which page?
Impugned order 81, impugned order.
81 ಅಲ್ಲಿ ಇದೆಯಾ?
ಹೌದು.
Paragraph.
Page 82, my lord.
82.
142, ink page. 141 and 142.
141, 142.
Page, ink page 141 and 142.
One 142, sir.
Annex Z, my lord.
Reasons are not.
Auction ಆಗೋಗಿದೆಯಾ?
Auction ಆಗಿದೆ. I have
He
deposited-
participated, he has taken permission for.
There was a precondition is imposed by the court. Whoever wants to participate in an auction, they should deposit 10 lakhs. I have deposited the 10 lakhs and I have participated in the auction. And the auction has conducted and I have been made as a, declared as a auction purchaser.
Your
And I
Lordship,
have
kindly see.
deposited 25% also.
One nimsha.
Suit is for partition.
Allah, suit is for partition.
Wait, suit is for partition.
It's for partition.
You are the co-sharer?
I am the purchaser, auction purchaser.
Action.
For a third party?
Yes.
Was an option given to the co-sharers to purchase?
Earlier,
Yes,
there
my
was
lord.
an
Yes, my
option
lord.
given. Earlier,
then-
there was an option given to the
All
first
right. Have they
respondent.
said, no, they are not going to buy, sell it to third parties?
After that,
may-
That is said.
May I make a submission, my lord? In fact, action sale was conducted on earlier occasion. None have come forward for purchase of the property. Later on, the respondent number 1 given proposal for purchase of the suit scheduled property, which is an house property consisting of ground first and second floor, measuring about 40 into 60, situated in Jayanagar, at the rate of rupees 26,000 per square feet. We agreed for it. He has filed an undertaking, agreed to deposit the sale consideration at the rate of rupees 26,000 within 1 month. Despite granting 2 months' time, he did not deposit the amount. As such, having no other alternative, the court passed order for auctioning of the suit scheduled property for the second time. And he has been permitted to participate in the action. On the action day, the respondents 3 and 4 participated. They are the only bidders. And they have proposed for purchase of the property at the rate of 27,000.
Now what are you challenging?
That is the order for conducting of inquiry. There is no need of conducting of inquiry. He participated, he has given proposal. There is no fraud or irregularity.
Deposit ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದಾರೆ.
25% deposited as per the condition fixed by the court.
And where is the question?
Only for the confirmation ಆಗ್ಬೇಕಾಗಿತ್ತು.
Where is the question of inquiry now? Under section 2 and 3 of the Partition Act.
First respondent filed an application at 21.
All that stage is over. Where is the
Yes,
question of inquiry now?
That is
Yes, my
exactly. And the court has passed an order directing for the inquiry.
Even on the said day, he was very much present in the venue.
No, there is no question of 2 and 3 comply ಆದ್ಮೇಲೆ inquiry ಏನಿಲ್ಲ. Yes.
In fact, after depositing, I am at hardship now.
We will set aside this order and direct the court to regulate
The
its procedure.
confirmation of the sale, please.
Yes,
Please, ma'am.
to proceed further. Yes. Allowed, quashed. Next.
Great.
Much of. Name is not shown.
First time ಬರ್ತಾ ಇರೋದು.
ವಕಾಲತ್ ಹಾಕಿದ್ವಿ.
ಯಾರ್ಯಾರ್ದು ಬರ್ಕೊಟ್ಬಿಡಿ ಎಲ್ಲರ ಹೆಸರು ತೋರಿಸ್ಬಿಡಿ. Yes.
4,
Recall of PW1 at what stage?
Oh,
posted for arguments, my lords.
Yes.
Thanks.
ಎಷ್ಟನೇ ಸರ್ತಿ?
ಇಲ್ಲ, first time.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement. List the matter on next 11th in preliminary hearing till such time further proceedings shall remain stayed.
Grateful, my lords.
That day will dispose it.
Please.
Serve ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ I will vacate the interim order.
Please.
Yes.
5,
Compromise decree ಯಾವಾಗಿಂದು sir?
11th January 2024, my lord.
Why, what's wrong with it?
ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, ಅದರಲ್ಲಿ ನಾನು
ಯಾವುದು ಲೋಕ ಅದಾಲತ್ತಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಕೋರ್ಟಲ್ನಲ್ಲಿ
ಕೋರ್ಟಲ್ ಆಗಿರೋದು
ಹೌದೌದು.
23(3) ಅಲ್ಲಿ ಹಾಕಿ.
ಅಲ್ಲ ಮೈ ಲಾರ್ಡ್, ಸ್ಟಿಲ್
Anything else?
ಸ್ಟೇಟಸ್ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ರೆಸ್ಪಾಂಡ್ 1 to 10 ಅವ್ರು ನಮ್ಮ ಬ್ರದರ್ ಮೈ ಲಾರ್ಡ್, ಅವ್ರು ಅಲಿನೇಟ್ ಪ್ರಾಪರ್ಟಿ ವಿತೌಟ್ ಮೈ ಕನ್ಸರ್ನ್, ದೇರ್ಫೋರ್
ಅದಕ್ಕೇನೆ
ಅಲ್ಲ,
file
till
before the
filing
same court
application.
sir.
ಅಲ್ಲ, till
ಲೋಕ
file-
ಅದಾಲತ್ ಆದ್ರೆ ಮಾತ್ರ ಇಲ್ಲಿ. Yes.
ಅಲ್ಲ, till filing application.
No sir, nothing doing. Yes, the petitioner is before this court seeking recall or setting aside of a compromise decree entered into between the parties to the list on 28/11/2024. If the petitioner has to challenge the same on the ground of fraud or otherwise, it should be before the same court under Order 23 Rule 3A. The subject petition challenging the compromise decree entered to before the competent civil court is not entertainable. Reserving such liberty, the petition stands disposed. Next.
6,
That's defendant's application in a suit for declaration.
Court fees.
Please, my lords, under section 11(2), that issue has to be decided before commencement of evidence.
ಸ್ಟೇಟ್ ಯಾಕೆ ಪಾರ್ಟಿ ಮಾಡಿದೀರಾ? ಎಷ್ಟು ಅಂತನಾ?
Please, my lords.
ಲರ್ನೆಡ್ ಎಲ್ಲಿ ಯಾರು ಇಲ್ವೇ ಇಲ್ಲ? ಗವರ್ಮೆಂಟಾ? 1, 2, 3, 4 plaintiff ಯಾರು? 1 emergent note. The petitioner shall serve on the counsel who represents the first respondent before the concerned court. Respondents 2, 3, 4. 7 ಯಾಕೆ? Yes, 7. iPad ಅಲ್ಲಿ ಕಾಣಲ್ವಾ?
Only 5.
ಇಲ್ಲಿ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 7 ಯಾಕೆ 5 ಅಂತ ಕೇಳಿದ್ದಾರೆ?
ನಮಗೆ ಕಾಪಿ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ, ಕಾಪಿ
ಕೊಡ್ತಾರೆ.
They were formal parties.
So and so. 2, 3, 4 HCGP petitioner to serve set of papers upon the 11th HCGP forthwith 11th. Yes, next.
Let's interim.
ಯಾವತ್ ನೆಕ್ಸ್ಟ್ ಇರೋದು?
It's 11th
ಬರ್ಲಿ ಆಮೇಲೆ. Yes, next.
Seal number 7, my lords, has to be connected with the other writ petition which has been filed for amendment of allowing the amendment application.
Which one?
This seal number 7 has to be tagged along with the other petition.
Number kodi.
WPFR number 19964 of 25.
Tag the petition along with?
WPFR number 19964 of 25.
We have not yet developed the habit of tagging FR numbers. If you want to tag, it should be writ petition.
I'll give the number.
What absurdity is this?
Because it has been filed because there's.
ಇನ್ನ ಬಿಟ್ರೆ ಇನ್ನು ಫೈಲ್ ಮಾಡ್ತಾ ಇದೀನಿ ಅದನ್ನ ಟ್ಯಾಗ್ ಮಾಡಿ ಅಂತ ಕೇಳ್ತೀರಾ?
No, I apologize.
Yes. Make it a writ petition and then come. Next.
Bill number 8,
I appear for the petition, Lord.
Who are you?
That I am the son of the defendant number 4.
Ah.
The lesser.
Compromise decree ಯಾವಾಗಿಂದ?
The compromise decrees of 6/3/2005, 25. 6/3/2025. The suit filed on 28/2/2025.
Compromise where?
Compromise before the Lokara.
All right, yes.
That the lesser side has, the shares has been allotted to the father. So based on that, I am.
Why did you sign?
I have not signed. I am not a party. Therefore, I filed an application seeking leave of this honorable court to present this writ petition.
Who are you in relation to them?
That the son of the defendant number 4.
Defendant number?
4.
Defendant number 4.
4.
ಯಾರು?
The respondent number 4, that's Sadashiva Reddy.
Sadashiva?
Sadashiva Reddy.
Sadashiva Reddy is the
He is the
signatory?
defendant number 1 before the trial court. Here he is the respondent number 4.
Sadashiva Reddy. Sadashiva Reddy and Srinivas Reddy are brothers, sir.
Please,
is serve on the council. Yes.
Please.
The petitioner to serve on the council represented the respondents before the court in OS
In
401
OS,
of 2025
Please.
and file an acknowledgement of such service.
at
Yes.
the stage that they
11th.
cannot alienate.
11th.
Please.
Yes. Sign Ekman, yes. Not you.
9,
Same order.
Same as
serial number
Milords,
6,
next
madam.
date of hearing is 11/7, Milords.
List on 10th.
6 and
6 and 9, both same order, list on 10th.
10,
Petitioner in this case.
Are they represented now?
Will not
Are the respondents represented there, defendants?
represented.
Huh?
Respondent not represented.
ಯಾವತ್ತಾಗಿದ್ದು ಆರ್ಡರ್ ಇದು?
My lord, the
13/5/25, what is the next date?
next date is on 16/7, my lord.
Elli page? Where do I get that?
The order sheet was not disclosed.
ಇದೆ ಆರ್ಡರ್ ಶೀಟ್ ಎಲ್ಲಿದೆ? ವೆಕೇಶನ್ ಕೋರ್ಟ್ ಇದು ಆರ್ಡರ್ ಶೀಟ್ ಎಲ್ಲಿದೆ?
5/6/2025.
ರಿಟರ್ನ್ ಬೈ
Page number, ink page number 18, my
5/6
lord.
ಏನಾಯ್ತು?
My lord,
5/6 ಗೆ ಏನಾಯ್ತು?
my lord, the application was issued the emergent notice against the defendants.
ಅದು ಗೊತ್ತು. 5/6 ಗೆ ಲಿಸ್ಟ್ ಮಾಡಕ್ಕೆ 5/6 ಗೆ ಏನಾಗಿದೆ?
The court has heard the plaintiff and has said that there is no prima facie case, and as such issued the.
ಅದು ಆರ್ಡರ್ ಇಲ್ಲೇ ಇದೆ. It was directed to be relisted on 5/6. I want to know whether ಅಲ್ಲಿ ಡಿಫೆಂಡೆಂಟ್ಸ್ ರೆಪ್ರೆಸೆಂಟ್ ಆಗಿದಾರಾ?
Defendant ಇನ್ನೂ reference ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
ನೆಕ್ಸ್ಟ್ ಆರ್ಡರ್ ಶೀಟ್ ಏನಾಗಿದೆ ಕೊಡಿ ಇಲ್ಲಿ. ಸರ್ವ್ ಮಾಡಿ, ಹ್ಯಾಂಡ್ ಸಮನ್ ಸರ್ವ್ ಮಾಡಿ. The respondent
No,
shall
no, my
serve-
lord, my lord, day after tomorrow, the date may be given. I will furnish the fresh order sheet.
Yes, list the matter on Monday
11,
in preliminary hearing. Yes.
For petitioner.
OS of which year?
9, my lord. 33 page. Issues framed in the year 2017, my lord. Annexure C,
Suit for
partition, my lord.
ಈ ಪಾರ್ಟಿಷನ್ ಮುಗಿಯಲ್ಲ, ಏನ್ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟರು?
ಅಲ್ಲ, ಒಂದು
ಯಾಕಂದ್ರೆ
ಏನೋ
ಎಲ್ಲಾರು
3-4
ಒಂದೊಂದು
months date
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಅಪ್ಲಿಕೇಶನ್ GM/CPC ಆಗಿ
ಅಲ್ಲ, ಒಂದ್ಸಲ ಡೇಟ್ ಕೊಟ್ಟು 3-4 months ಕೊಡ್ತಾರೆ. That is the problem.
the petitioner is before this court seeking the following prayer. You are what defendant?
Plaintiff, my lord.
Plaintiff.
Plaintiff number
The
2, LR subject plaintiff
petitioners-
number 2.
The petitioner is the second plaintiff and the legal representatives. The plaintiffs are the legal representatives of the deceased second plaintiff and are before this court seeking a direction to expeditiously dispose the suit which is of the year 2009. OS 322 ಅಂತಿದೆ?
ಇಲ್ಲ, ಎರಡು ಆರ್ಡರ್ ಶೀಟ್ ಇದೆ. ಅದು ಮತ್ತೆ ಅದು ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಹೆಚ್ಚು ಕಮ್ಮಿ ಆಗಿದ್ದಕ್ಕೆ ಸೀನಿಯರ್ ಡಿವಿಷನ್ ಬಂತು. ನೆಕ್ಸ್ಟ್ annexure E, page number 33.
Suit of the year 2009, which is OS 333 of 2009. On erroneous valuation, it was presented before the wrong court and is now before the JMFC Anikal in OS 302 of 2022. The issue, since the issue is of the year 2009, I deem it appropriate to direct the concerned court to dispose the suit in a, young stage alide.
Plaintiff evidence, my lord.
So and so with an outer limit of 9 months from the date of receipt of the copy of the order.
Your lordship may kindly 6 months, my lord.
ಅದೇನಾಗಲ್ಲ. ಎಸ್, ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ ಬೇರೆ ಯಾವ್ದು ಹೇಳ್ಬೋದು. ಎಸ್, ನೆಕ್ಸ್ಟ್
number 12,
6 months ಅಂತಾನೆ ಮಾಡಿ. ಎಸ್,
Blood. On an application without there being a counterclaim, my lord.
ಆಯ್ತು. ಈಗ ಎಷ್ಟು ಡೆಪಾಸಿಟ್ ಎಷ್ಟು ಮಾಡ್ತೀರಾ?
Blood, he is not the person who is entitled to it. He is the builder, my lord. He is not formed the association of owners. He is claiming, my lord.
3 lakh ಎಷ್ಟು ಈಗ ಕ್ಲೈಮ್?
Your lordship may kindly direct, my lord.
ಡೆಪಾಸಿಟ್
Deposit
30%. The petitioner shall deposit a sum of rupees, a sum ಬೇಡ, ಎಷ್ಟು ಟೋಟಲ್ ಎಷ್ಟು?
3 lakh and 1 lakh and all.
3 lakh and 1,80,000.
Yes.
Deposit a sum of rupees 1,80,000 before this court in the next 4 weeks. Subject to the aforesaid deposit, there shall be an interim order of stay as prayed for. list the matter on 4th August.
13.
Appearing for the petitioner, my lord. Petitioner is
ಯಾವ
the
ವರ್ಷದ ಸೂಟು?
2019.
Commercial
my lord.
OS.
Oh, it's an SC, my lord. Ejectment suit in the Court of the Small Causes.
2009.
19, my lord.
19. Yes.
19, it's still stuck in the same stage, my lord. The IA has been pending for the past
Which IA?
4 years. 7 Rule 11, my lord.
You are,
Evidence
you are
hasn't-
the defendant.
I'm the plaintiff, my lord.
7 Rule 11, you want,
Been pending,
you want
my
an
lord.
order on that?
No, my lord.
Then?
I'm asking for the disposal of the suit within the period of 3 months, my lord. The defendant continuously,
ಎಲ್ಲಾದ್ರಲ್ಲೂ ಈ ತರ ಮಾಡೋದು ಕಷ್ಟ.
it's an ejectment suit, my lord.
List the matter, next Friday we'll do it. ಒಂದು ವಾರ breather ಇರ್ಲಿ. Yes. Preliminary hearing.
14.
Petitioner. Lord, there is a connected writ petition, my lord, WP 18793,
Tag this petition along with
WP 18793 of 2025,
this next week,
Monday.
11th.
11. Apply.
15.
Please. My lord, amendment of written statement.
At what stage?
My lord, the defendant evidence is not yet commenced. That's my anxious. Only one letter, my lord, the entire continuous reading we have denied in the written statement. There is no question of.
Petitioner to serve set of papers upon the counsel representing the plaintiff 1 and 2 before the concerned court.
Please.
And file an acknowledgement by the 9th. What is the next date?
My lord, the next ಈ month ಅಲ್ಲೇ ಇದೆ, date I could not say.
ಈ month 31st ವರೆಗೂ
ಇಲ್ಲ
ಇದೆ.
I did not inquire, my lord.
List the matter on 18th.
Please.
16.
For the petitioner in this case, my lords.
ಎಷ್ಟು ದಿನ ಆದ್ಮೇಲೆ ಲಿಸ್ಟ್ ಆಫ್ ವಿಟ್ನೆಸ್ ಹಾಕಿದ್ರಿ?
My lords, kindly see, my lords.
ಎಷ್ಟು ದಿನ ಆದ್ಮೇಲೆ ಹಾಕಿದ್ರಿ ಸರ್?
My lords, it was filed on 24/1/2025, my lords. My lords,
What
the
was
reason
the-
is,
Along with the plaint ಯಾಕೆ ಹಾಕಲಿಲ್ಲ?
my lords, one receipt, my lords, dated 23/11/2016 was produced in OS number 56 of 2019, my lords. The same was marked, my lords, on 10/1/2025, my lords. The certified copy of which it is at page number 31, my lords, annexure D.
The petitioner shall serve on the counsel who represents the defendants before the concerned court and file an acknowledgement by the 9th. List the matter on 18th.
Stay, my lords, it's posted for cross of DW1,
There
my
shall
lords.
be an interim order of stay of further proceedings before the concerned court till the next date of hearing. Yes.
Great.
Permitted to represent.
Petitioner number 1 and not the respondent number 1 and 2 are the not of the co-sharers, not of the inherited the properties, not certain property. That is suit shell number 1 to 5 properties. Not of this petitioner number 1 here in not of the forced to construct his house. Since not of the ancestral property is not in dilapidated condition, about to fall. Not this is the reason.
About to fall.
Yes, no.
In what condition?
My lords, dilapidated condition. My lords, may I take not of the page number 53, my lords, pages. Lords, and my lord, the last page is the my lord, now he is putting up the construction, my lord, the last page. Present house.
ಇದನ್ನ ಹೊಡೆದಾಕಿದ್ದೀರಾ?
ಇನ್ನ ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಬೀಳ್ತಾ ಇದೆ, ಅದಕ್ಕಾಗಿ ನಾವು
ಅದಕ್ಕೆ ಬೀಳ್ಲಿ ಅಂತ ಕಾಯ್ತಾ ಇದ್ದೀರಾ ಅಥವಾ ಹೊಡೆದಾಕ್ತಿದ್ದೀರಾ?
kindly see the not of the condition. Lords,
I am seeing
the
that condition.
fact is this note. In such a circumstances, not he proceeded with the construction. At that time, not the other co-sharer come up with the application that not to proceed with the construction. Not the honorable trial court, not without considering the which is the not the grievance of the petitioner herein, and not more irreparable loss to cost to him. Kindly see the not of the judgment.
Cost to whom?
Cost to the plaintiff, not in case of not permitting to proceed with the construction. In similar aspect, not of the honorable, not of the.
ಅಯ್ಯೋ, ಈ ಮನೆ ಅದಕ್ಕೂ ಜಡ್ಮೆಂಟ್ ಬೇಕಾ? Yes, sir.
Lord, firstly, it's an appealable order. Secondly.
What is the order?
It's an injunction order.
Order is granted.
Order is granted.
Lords, the application is filed under section 94.
94.
94 C and D.
94.
94 C is not 39 1.
It's Lord, goes together, my lord. There is no independently, it will not be. 94 is enabling provision.
Give it, sir.
Yes, yes. Lord, in 2004 Supreme Court.
Paragraph.
Lord, first, Lord, after the main head note, the source of power of the court to grant interim relief under section 94. However, the exercise of that power can only be done if the
Yes, sir,
circumstance.
file an appeal.
Lords, may full bench of not of this honorable court, not on para number 10 also. Lords.
And the photographs he is produced is only a portion of the house. No, it's a
And
very
what are
huge house, 30 mane anta ಹೇಳ್ತಾರೆ. And the construct 30 mane 4.
Fact
And
is
construction
this,
is illegal without any license. And he wants an
And
approval
Lord,
from the court
Lord,
for
the
construction.
respondent number 1 and 2 are not residing in Bangalore. This is the person, Lord, he is in possession of the property.
Appeal.
ಅಲ್ಲ, appeal
Well, license
ಹಾಕಕ್ಕೆ Lords,
ಇಲ್ದೇನೆ.
ಅಯ್ಯೋ ಅಪೀಲ್ ಹಾಕ್ಲಿ ಬಿಡಿ ಸರ್.
may I request Lords? Lords, even Lord of the, even to decide 90, not even application itself is not maintainable.
The Supreme Court says 39, 1 and 2 and 94 go hand in hand.
Correct, Lords. The
Correct.
fact and
Then appeal
circumstances,
ಹಾಕ್ಬೇಕಾಗಿತ್ತು.
that fact and circumstances should be looked into, Lord. That is the fact. Here, Lords, the both
Any
are.
fact, any circumstance looked into, file an appeal.
Till that date, Lord, the, I may be permitted to go on with the construction, Lord.
ಓ ಅಲ್ಲೇ ಅಪೀಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೇಳಿ.
ಅಲ್ಲ, ಅದು ಬರೋ.
ಏನ್ ಒಂದ್ ವಾರ ಮಾಡದೆ ಹೋದ್ರೆ ಏನಾಗಲ್ಲ.
ಲೈಸೆನ್ಸ್ ಇಲ್ಲ.
ಅಲ್ಲ, ಆಲ್ರೆಡಿ ಅಲ್ಲಿ ಗುಂಡಿ ತೋಡಿ ಅಲ್ಲಿ ತೋರಿಸಿದ್ದೀನಿ ನಾನು. ಅಲ್ಲ, ಯಾರು ಬಿದ್ದು ಹೋಗ್ಬಿಟ್ರೆ ಕಷ್ಟ ಅಂತ.
ಹೋಗ್ಲೇಬೇಡಿ ಯಾರು ಅದ್ರ ಹತ್ರ. ಅಪೀಲ್ ಆಗೋವರೆಗೂ ಹೋಗ್ಬೇಡಿ ಯಾರು.
But even a deviation is questioned and stayed. Here the whole construction is illegal without license.
ಅಲ್ಲ,
In a joint kata property.
Now they have made e-kata and all model that.
But it's a huge house he is residing.
And
He has
he is
produced
happily
the wrong
residing in
photograph.
Bangalore. Not this poor farmer, not is residing, not in the.
Poor farmer.
Yes, not he is a farmer, not he wanted to construct not the.
Wanted farmer.
House, dwelling house in the house, because since not
Whole
the
house
ancestral
is
intact.
property is not in dilapidated condition.
ಅದ್ಯಾವ್ದು ಬೇರೆ ಪೋರ್ಷನ್ ಹೇಳಿದಾರೆ.
ಅದು ಹಿಂದ್ಗಡೆ ಒಂದು ಹಳೆ ಪೋರ್ಷನ್ ಇದೆ, ಅದನ್ನ ಫೋಟೋ ಹಾಕಿದ್ದಾರೆ. Front side it has been renovated long back. It's a huge house in the village.
In Bangalore, is it?
I am in Bangalore.
ಅದು ಇದೆಲ್ಲಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಎಲ್ಲ ಆಗ್ತಿರೋದು?
ಇದು ಕುಣಿಗಲ್ ಅವ್ರ ಊರಲ್ಲಿ.
ಹಳ್ಳಿಯಲ್ಲಿ ಆಗ್ತಾರೆ.
What's your problem?
No, it's a joint kata property.
Yes. Appeal. Learned counsel of the petitioner, after arguing the matter at length, would seek leave of this court to prefer filing an appeal, MFL, prefer filing a miscellaneous first appeal.
MA ಬರೋ.
MA na? MA. First appeal in the light of the order being passed under section 94 C and E of the CPC. Yes. Reserving such liberty, the petition stands disposed. The petitioner shall serve on the counsel who represents the respondent in the trial proceedings and file an. Nimda.
18.
I'm sorry.
We will grant stay. Good evening.
I'm sorry, my lord. But I am extremely sorry. It's not.
Yes, heard the learned
Lord, I am
commander.
extremely.
Stay ಕೊಟ್ಬಿಡೋಣ ಆಮೇಲೆ.
Lord, I'm sorry. It's not
Kindly see
intentional.
the fact and circumstances, not.
ಅಯ್ಯೋ ನೀವು ಅದನ್ನೇ ಅಡ್ವಾಂಟೇಜ್ ತಗೋಬೇಡಿ ಅವ್ರು. ಫೋನ್ ರಿಂಗ್ ಆಯ್ತು ಅಂತ ಹೇಳಿದೆ ಅಷ್ಟೇ. ನೀವೇನ್ ಖುಷಿ ಆಗ್ಬಿಟ್ರಿ. Facts and circumstances.
Even in, not he is in staying in rural area.
ಅಲ್ಲ ಅಪೆಲೆಟ್ ಅದು ಅಪೆಲೆಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಫೋನ್ ರಿಂಗ್ ಆದ್ರೆ ಹೇಳಿ ಅವಾಗ. ನಾಟ್ ಹಿಯರ್. ಫೋನ್ ಯಾಕೆ ಕೇಳ್ತಾ ಇದ್ದೀರಾ? ಎಮ್ಮೆನ ಸರ್.
18.
Yes.
For the petitioner, without there being an order of attachment.
The petitioner to serve on the counsel who represents the respondent in the trial proceedings. The petitioner is before this court calling in question a sale notice, the sale of which is slated to be?
Sale of the writ petition schedule property.
ಯಾವತ್ತು?
ಅಲ್ಲ, the proceedings are on.
So and so. Till the appearance of the respondent, there shall be an interim order of stay of the sale of the suit schedule property. Yes, next.
Further proceedings qua the writ petition schedule property anta, because.
And any further, and all further proceedings qua the petition schedule property. Next.
19.
Seeking direction
The
to
petitioner
consider
is
my
before this
application.
court seeking the following prayer. The petitioner is said to have, petitioner is the plaintiff who is said to have filed, institutes a suit in OS 1060 of 2019 and files an application under Order 39 Rule 1 and 2. The said application is pending consideration for the last 6 years is the allegation of the petitioner, and no orders are passed. In that light, and the fact that the prayer sought is innocuous, I deem it appropriate to direct the concerned court to dispose the application so filed under Order 39 1 and 2 within the next 15 days, if not already decided, ordered accordingly. Next.
20.
petitioner, madam.
ಡೆಲಿವರಿ ವಾರೆಂಟ್ ಮ್ಯಾಂಡಮಸ್
Purely mercy petition.
ಅಲ್ಲ ಅದು ಡೆಲಿವರಿ ವಾರೆಂಟ್ ಮ್ಯಾಂಡಮ್.
ಅದು ಏನಾಗಿದೆ madam? ಏನಾಗೋಗಿದೆ? My client actually, he has taken on lease in August 2024. Before December 2024, before the expiry of lease, this lady comes and locks the premises. I am supplying eggs to the government schools, madam.
What are you supplying?
Eggs to the government schools. I have a small shop there. What is happening is, before even the expiry of the period agreed under the compromise, she files the execution petition. And my only request is, what my client tells me is this: ಇವಾಗ ಆಷಾಢ ಅಂತೆ, ಆಷಾಢ ಮುಗಿದು ಕೂಡಲೇ he is going to get the premises in ಶ್ರಾವಣ ಮಾಸದಲ್ಲಿ ಜಾಗ ಸಿಗುತ್ತೆ, ಅಷ್ಟು ತನಕ ಟೈಮ್ ಬೇಕು.
ಈಗ ಡೆಲಿವರಿ ವಾರೆಂಟ್ ಆಷಾಢದಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಕ ಆಮೇಲೆ
ಆಷಾಢದಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಟ್
ಅಲ್ಲೇ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಬೇಕಾ? ತಪ್ಪ
ಅಲ್ಲ, ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ತಾರೆ. ಅದಕ್ಕೆ ಸ್ವಲ್ಪ some time till the month end, otherwise what happens is
serve the respondent.
Yes, I don't have case on merits as such, except
heard the learned counsel Madhusudan Rao appearing for the petitioner. Petitioner shall serve on the counsel idaralva. Counsel
trial court.
Petitioner shall serve on the counsel representing the decree holder before the trial court. List the matter on 11th.
And a stay of execution.
ಆಷಾಢ ಮುಗಿದೋಗುತ್ತಾ?
ಇಲ್ಲ, ಆಷಾಢದಲ್ಲಿ ಅಲ್ಲ, ನಮ್ಮನ್ನು ಹೊರಗಾಕ್ಬಿಟ್ರೆ ಏನು ಪ್ರಯೋಜನ ಆಗುದಿಲ್ಲ.
ಮೊಟ್ಟೆ ಮಾರದಕ್ಕೆ
ಹೋಗುತ್ತೆ, ಆಗ್ಲೇ ಹಾಳಾಗೋಗಿದೆ. We have issued a legal notice.
ಮೊಟ್ಟೆ ಹಾಳಾಗೋಗಿದ್ಯಾ?
ಅಲ್ಲ, ಏನಾಗಿತ್ತಂದ್ರೆ 15 ದಿವಸ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರು. We could not open the shop. We have lost the eggs.
ಏನ್ ಮಾಡಿದ್ರಿ eggs ಎಲ್ಲ?
ಹಾಳಾಗೋಯ್ತು eggs.
ಏನಿಲ್ಲ, ಕಲರ್ ಚೇಂಜ್ ಆಗಿರುತ್ತೆ. You can sell it as organic eggs.
Stay ಕೊಡಿ. We need a stay till that appearance.
The further proceedings in the execution shall remain stayed till the next date of hearing.
21.
Tahir, go before the division bench. No risk.
Now, the Lordship, it's already, order is passed. Extension I am seeking.
No problem. Enough. Twice I have shown mercy. Go, I'll reserve liberty to go before the division bench.
Lordship,
No, I don't want.
15 days, Lordship. May I request for 10 days,
No,
Lordship?
I acceded to request of yours twice, jokes apart, but please go before the division bench. The petitioner is at liberty. The petitioner was granted in interim bail.
Interim release.
Interim release on 2 occasions.
Petitioner
Excising jurisdiction under Article 226 of the Constitution of India. In fact, the present petition had to be preferred before the division bench. Therefore, reserving liberty to the petitioner to knock at the division bench, seeking any relief that he wants, the petition stands disposed.
My application will be not pressed, Lordship.
On the learned counsel for the petitioner submits that the application is filed for extension of interim bail, interim release, be dismissed as not pressed. The same is disposed as not pressed. Next.
That's in the first line, it's petitioner's son who's enlarged on.
Petitioner's son.
Petitioner's son. Yes. ಅದೆಲ್ಲ ಏನು ಬರಿಬೇಡಿ, ನಾಟ್ ಪ್ರೆಸ್ಟ್ ಅಂತ ಬರೀರಿ. ಸನ್ ನೋ ಡಾಟರ್ ಅದೆಲ್ಲ ಏನು ಬೇಡ. ಎಸ್ ಪ್ಲೀಸ್. ನೆಕ್ಸ್ಟ್ ಟು ದ ಡಿಮೂವ್ ತಗೊಳ್ಳಿ ಫಸ್ಟ್. ಎಷ್ಟಿದೆ ತಗೊಂಬಿಡಿ.
33 matters. Vinuta P. Kale.
Who is Vinuta? ಕೊಡಿ. FTP.
And for the petitioner.
ನೀವಾ?
Vinuta P. Kale.
ಹಾ. 1992 FDP ಈಗೇನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ, ಏನಾಗಿದೆ, valuation report we have filed after the commissioner's report. Valuation reports we have filed at annexure J. The valuation of the property is 5.5 crores. Now the court orders for public action on the ground.
Did you offer to buy?
I am also intending to purchase the bid.
You are the purchaser.
No, my lord, I am one of the co-personer. Now, my lord, what had happened, the court has fixed the action, public action tomorrow on the premises that the bidder fixing the base value as low as 3.5 crores. Admittedly, the property value is more than 5 crores.
Where is the valuation with the commissioner?
Annexure J is our report, my lord.
What is the value?
5.15 crores, my lord. Page 78.
Where is the auction notice? Page.
Page 95, my lord, is the order that action to be held on 5/7.
Value, sir.
Valuation ಅದು ಇದ್ರಲ್ಲಿ
Auctional value ಹೇಳಿಲ್ವಾ?
ಅಲ್ಲ ಇಲ್ಲಿ I'll come to that. Page 88, my lord, order dated 30/10/24. May I read?
Valuation report ಅಲ್ಲಿ.
The commissioner has not filed any valuation report, my lord. My valuation report is at annexure J, page 76.
How did the court come to that value? Did court get a valuation report?
My lord, without
Did the
appreciating.
court get a valuation
No, my
report?
lord. Now may I read this paragraph, my lord? The order dated 30/10/2024. Around 15 lines from the below. May I read it?
What is this, page 87? Base price 4 crore 50 lakhs ಯಾರು ಕೊಟ್ಟಿದ್ದು?
Earlier it was fixed as 4.5 crores. Now, my lord, after subsequently, this is the order.
Page
88, the next page, my lord. It has reduced the valuation to 3.5 crores since the bidders are not coming. That is the reason assigned.
You serve on the
Read
respondents.
three lines, my lord.
1 minute. I have seen that, yes.
Yes, my lord.
The petitioner shall serve on the counsel to represent the respondent in the trial proceedings, in the FDP proceedings.
Please.
List the matter on 11th, list the matter on 15th, Tuesday, 16th. That the sale that is slated to be held tomorrow shall be deferred till the next date of hearing.
Much obliged.
Next.
Number 2, Srinivas SV.
K-wait ಇದೆ.
Served again.
K-waiteರು ಇದ್ದಾರೆ.
My lords, the petitioner is a judgment debtor, my lords. The judgment in execution is one for eviction.
Correct.
I have suffered a decree all the way up to the Supreme Court, my lords.
Now what do you want?
I have purchased 6 of the 8 shares, my lords, in the property. It's a small property, shop premises, which is not divisible by meets and bounds. Now the other 2 decree holders, my lords, who are co-owners, they are seeking for possession of the entire property by insisting on issuance of a delivery warrant.
When did you purchase them?
My lords, 1 share I have purchased during the pendency of the suit, and the other 5 shares during the pendency of the execution proceedings.
Yes, sir.
Yes, that is right, my lord. But even if they have purchased, the tenant has purchased the share of some of the co-owners, that will not take away the right of executing the decree. That's all our Supreme Court says. In 2005 Supreme
Now
Court.
what do you do with the sales? All right, we'll see.
After that, if the petitioner succeeds in that specific performance suit, she has to file either because some of the co-owners have not signed the agreement to sell, admittedly. And if they succeed that, they have to file a suit for partition.
Now the
My lords, may I
property
submit
cannot
my-
be divided.
It cannot be divided.
Lords,
They have
I
to file a
have-
suit for partition, and they have.
Filed a suit which is pending, my lords. I only want for the execution to be stayed until disposal of the partition suit, my lords.
It cannot
Because
be.
My lords, the Supreme Court, I am backed by judgment, my lords. It is what my learned friend
I'll
is.
take it on Monday, give it.
Please.
List on Monday in preliminary hearing. Next. Kodi. And delivery. Yes,
3,
Siddharth.
Arrest warrant has been issued without issuing a show cause notice to me. There's a rise out of execution proceedings where the counterclaim, there's a counterclaim of 96 lakhs. Counterclaim is rejected. They file execution despite that. And now, my lord, from 2023, it's kept
Whose
pending.
counterclaim is that?
Defendant's counterclaim, my lord. The landlord's counterclaim against me. IA number 6, my lord, where their counterclaim itself is rejected.
That is Sarvan Sunil. I
Please,
think
my lord,
he
it is
appears.
tomorrow, my lord. I'll just show
No
my
problem.
lordship.
Petitioner shall serve on the counsel who represents the respondent.
I was arrested, picked up, my lord, and then I was picked up, my lord. I was produced before the court, and tomorrow, my lord, if I do not pay 20 lakhs, I'll be sent back to jail.
1 minute. Yes. The learned counsel for the petitioner shall serve on the counsel who represents the defendants before the
Please.
defendants before the concerned court. Defendants.
It will be the DHR here, my lord.
Decree holders before the concerned. I think Sunil Rao has appeared.
Please, please, please.
Or on the counsel, T. Sunil Rao, who said to have appeared in the execution proceedings and file an execution proceedings forthwith. List the matter on 16th for the proceedings. The order dated, which order?
My lord, 13/6/2025.
Order dated 13/6/2025 and all further proceedings before the concern. All further proceedings taken thereto shall remain stayed. Next.
Please, grateful, my lord. My lord, handily may I request produce Nade. Please, grateful.
Arrest Nale ide.
Nade ide.
Arrest Nale ide.
If I don't-
Event.
Illa, he was picked up, my lord, I have to give surety tomorrow and then pay 20 lakhs.
You will be dropped, don't worry. Yes.
Please, my lord, oblige.
Yes.
Or relation.
She engaged a senior counsel, lords, but she is held up in court hall number 7, my lords.
List the matter on 11th.
Plus Monday, my lords.
Monday, all right.
Oblige,
Yes.
lords.
Move ಮಾಡ್ಬಿಟ್ಟು adjournment. ನೀವು file ನೋಡಿಲ್ವಾ?
Lords, she is held up in lords court hall number 7.
What's the matter?
Lords, it is GMCP, proxy counsel.
Oh, GMCPC ನನಗೂ ಗೊತ್ತು ಸರ್.
Lords, I am proxy counsel.
ಪ್ರಾಕ್ಸಿ ಅಂದ್ರೆ ಅದು ಗೊತ್ತಿರಬಾರ್ದು ಅಂತ.
Lords, Monday, my lords.
Ah.
Oblige, lords.
Continue ಮಾಡಿ.
Discontinue. Admission. 54.
They have 3:30 further hearing ಎಲ್ಲ ಇದೆ ಮೇಡಮ್. One minute.
54.
1 minute. Admission ಮುಗಿಸ್ಕೊಳ್ಳೋಣ.
54.
What's one more connected matter is not listed.
Tag this petition along with.
It's 10,125 of 23.
List on 11th. Yes.
Yes.
55.
55.
I appear for the petitioner's counsel, my lord. Worship had heard this matter last week regarding the company not being made an accused.
Correct. ಅದು close ಮಾಡೋಣ ಅಂತ.
Please. Even otherwise, my lord.
Let Jagdish come 10th.
Yes, like he was heard.
I know. Yes, it's only the way the cost title is described as a
That is
company
one,
is a
and I had
party.
to clarify, my lord, one small clarification. Even otherwise, the complaint is bad by virtue of your lordship's judgment in Krishna Swami Shrita. So either
see,
ways,
yes.
my lord, it will have to be allowed.
Heard the learned senior counsel Murthy Nayak appearing for the petitioner. List the matter on 10th to hear the additional SPP.
Can it be at 2:30?
Yes, next.
The interim order maybe.
Interim order will continue.
Grateful.
56.
Ah, 11th ಹಾಕಿ. ಯಾರಿಲ್ಲ ಅಂದ್ರೆ 11th ಹಾಕಿ.
57.
The petitioner, for the respondent, my lord. A3 squashing petition, lord.
The voluntary statement.
Voluntary statement, my lord. The facts are somewhat different, my lord. I may be permitted to persuade my lords with.
A1 and A2 cost ಅಲ್ಲ?
No.
A3 ಮಾತ್ರ.
Only A3. A3 is the person who had the benefit of anticipatory bail and with certain condition that he is supposed to appear before the investigating agency. He did not appear before the investigating agency. Then since we had arrested the other person, we were compelled to file the complaint within the timeline. We filed the complaint. Thereafter, the lookout circular was issued to him. Then after issuing lookout circular, after 2 years of complaint, lodging of the complaint, then he was arrested in the airport. Then he was taken into the custody. Then his statement was recorded. Then after that, my lord, he filed an application before my lords to enlarge, to relax the condition so that he can travel. So my submission is that, my lord, with respect of this particular accused, the leniency, what we can show for others cannot be shown. The reason is that earlier.
Telling me or you're telling yourself?
No. I mean, this is a prayer which I have to make before my lords. Yes. Yes, my lord. This is one aspect which I want to highlight, my lord. The other aspect, my lord, here in this case, with respect of the confessional statement made by the others, in the light of section 27, my lord, of the Indian Evidence Act, there are certain discovery. Those discoveries are
corroboration ಇರಬೇಕು.
Yes. Those discoveries are available in this case and which is required to be substantiated, my lord. I request my lords to consider that particular aspect. My one more submission, my lord, it is a request. somewhat this particular case is connected with that of the Chetan Bombalikar, which is already my lords have
ಅದಕ್ಕೂ ಇದಕ್ಕೆ ಸಂಬಂಧ ಇದೆ.
ಅಂದ್ರೆ ಕಂಟೆನ್ಷನ್ ಒಂದೇ ಇದೆ ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ.
Yes, Angat.
Yes, my lord. Your lordship should have the complaint at page 20. But information is received by the NCB that a certain parcel in the DTDC agency was suspected to contain ketamine.
There is no corroborative material at all.
No, Lord. I am not the sender of the parcel. I am not the receiver of the parcel. There is no recovery at my instance. The only incriminatory material in the charge sheet is my own confessional statement and a statement of a co-accused. My own voluntary statement is hit by Tufan Singh. The statement of the co-accused cannot be led in evidence against me unless he turns approver. The entire charge sheet material, not if your lordship were to take it, I'm not the sender. There is no recoveries on me. The only incriminating statement is I have given instruction to book.
ಅಷ್ಟೇನಾ?
No. Independent.
Oh, sir.
There are discovery, my lord. Those discovery I may be permitted to show, my lord. I will just prepare a short synopsis.
ಡಿಸ್ಕವರಿನ ರಿಕವರಿನ?
Discovery.
ಡಿಸ್ಕವರಿ ಆಗ್ಬೋದು, ರಿಕವರಿ ಆಗ್ಬೇಕು.
ಅದೇ ಡಿಸ್ಕವರಿ ಆಗಿದೆ. ಅದಕ್ಕೆ ನಾನು ವೆರಿ ಕೇರ್ಫುಲ್ ಇನ್ ಯೂಸಿಂಗ್ ದಿ ವರ್ಡ್. There is no recovery, there is only discovery.
Discovery not pursuant to my statement.
Yes, now that is the issue.
The discovery
If
not
there is
pursuant
any
to my
discovery, to that extent, the statement of co-accused as well as the discovery would become relevant against all the accused.
ಇವತ್ತು ಟೈಮ್
The
ಇಲ್ಲ.
co-accused cannot be led in evidence.
I'll take it on 10th, Angat. You file your synopsis,
Yes.
whatever you want.
Objections already filed.
You want something to be filed today, no time today. Yes, list on 10th, heard the learned counsel Angat Kamath appearing for the petitioner and counsel Madhukar Deshpande. The
ಒಂದೇ
list
ಏನು
on- list
ಚೇತನ್
on-
ಬೊಂಬಾಲಿಕರ್ ಆದ್ಮೇಲೆ ಇದು ಬಂದ್ರೆ ಒಳ್ಳೇದು.
ಬೇಡ, list on 10th, ಅಷ್ಟದು ಬರುತ್ತೆ ನೋಡ. Yes, list on 10th.
There's nothing in the complaint about this Chetan Bombali.
ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಸಂಬಂಧನೇ ಇಲ್ಲ.
ಅಲ್ಲ, the contentions are more or less one and the same.
List on 10th. Intermodal subsisting would continue to the disposal of.
There's no intermodum.
No intermodal.
We're not sought for an
Detailed order ಏನ ಮಾಡಿದ್ರು?
We're not sought for an
Then I am sorry. ಕೊಡಿ.
58.
Yes.
ಅದೇನೋ ಬರೆದು ಬಿಟ್ಟಿದ್ದೀನಿ.
Your lordship, I'm for petitioner in 58.1 and 58.2, your lordship. I pray for short accommodation, your lordship.
You pray for?
Short accommodation, your lordship, any day.
All right, let's 11th.
Interim order may be extended.
Continue.
59.
My lords, in this matter, the petition filed by the accused number 3 and 4, the sub-register has been withdrawn by them after arguing. My contention is that there is no such person as a petitioner who has filed the petition.
11th and on. List on 11th. Intermodal continue ಮಾಡಿ. Next. 60.
60.
Respondent number 2 in this matter.
Same. No representation way of the petitioner, list on. Yes. 11th.
11th.
Intermodal continue. Yes, next.
No, there is no interim order.
Intermodal, that will also continue.
If I have a benefit of an order.
If there is no intermodal, that also will continue. Yes, next.
61.
Next.
Counsel to the respondent.
Offenses alleged are 498A of IPC and 3 and 4 of
61 na?
61.
Yes, sir.
Yes, my lords, I filed my detailed objection, my lord.
Detailed objections. Husband,
My lord's husband, mother-in-law
His
and
for wife.
sister-in-law.
Offenses alleged are 498A.
Husband adene. Yes.
Husband, mother-in-law and
Yes, my lords,
sister-in-law. My lords
apparently
have passed an order, last date of hearing. Lord, please see the last date.
My lords have.
My discharge application, Lord, came to be rejected.
Is it sir? Last hearing.
Yes, sir.
Yes, my lords. I'm ready to hear, my lords. My lords, firstly, my lords, we'll have to make a reference.
To what?
To the order that has been passed by the honorable magistrate, my lords. The case of the petitioner is very simple, my lords. He says that he introduces a certain documents during a trial when he is preferred an application under section 239 of CRPC.
You forget about that, sir.
Yes, my
Come
lords.
to the complaint, come to the charge sheet.
Yes, my lords, I'll come to the
What
charge
is the allegation is the husband, mother-in-law and sister-in-law? Tell me.
My lords, I've extracted, if my lordship could take the
Page.
objections that I've.
Page.
My lordship,
What is the offense against the husband?
I will demonstrate, my lords.
No demonstration. Come to page 56.
My lords, at page number 3 of my objections, I've extracted the relevant portions in the complaint. from the complaint which he had given.
Charge sheet bunny, sir.
Yes, my lords.
After the charge sheet, complaint would pale into insignificance.
Yes, my lords.
What is there, sir?
My lords, what is
What
given
is there that would become the ingredient of 498? Tell me.
My lords, their joint doctrine alive, the joint doctrine principle applies to this is because of section 34. My lords, in the
34. 34 cannot be a standalone offense for me
No,
to
no, not
sustain
for the
that, sir.
standalone, my lords. Let me see, my lords. What
Not
happens?
even an offense, yes.
No, my lords, what happens is in column number 4,
Only
6.
fine can be imposed there.
No, my lords, here the allegations have been made in the complaint. There are total close to about 12 witnesses who have been examined. Everybody's 161 statement has been recorded.
161, no use.
No, my lords. They have said that whatever is the demands of dowry that has been done, whatever has been said, there
That
has
is in
been.
161.
Yes, my lords, it's been done. Now that has to stand the test of trial for them to disprove the contentions
Yes, sir.
that the mother, because here, apart from that, my lords, there has been an admission from the hands of the first petitioner in the Seamus case that certain amount of dowries has been received by him. This is well demonstrated in the judgment of the Sessions Court also.
Okay.
There is sayings that, and money has been transferred. The issue here, what it stands is, as on the date of the marriage.
Page 56 and show me one line that would meet 498A. One line.
My lords,
One line.
498A.
Yes, sir.
It definitely also deals with mental agony in pertaining to the demand of dowry.
That is in BNSS, not in 498.
Yes, one minute. Yes. Let me just read this, my lord. Column number 4.
Column number 7, no, page 56 ಅಲ್ಲಿ ಒಂದು ಲೈನ್ ಇದೆ ಹೇಳ್ಬಿಡಿ.
ಕಾಲಂ ನಂಬರ್ 4ರಲ್ಲಿ ನಮೂದಿಸಿರುವ ಆರೋಪಿ ಒಂದು
ಅವರು ಕನ್ನಡ ಬರಲ್ವಾ?
ಸರ್ ಬರುತ್ತೆ, ಸುಲಭವಾಗಿ ಓದ್ತೀನಿ ಸ್ವಾಮಿ ಅಷ್ಟೇ.
ಬೇಡ, 5:30 ಆಗ್ಬಿಡುತ್ತೆ ಬೇಡ.
ಆರೋಪಿ 2ರವರ ಮಗ ಮತ್ತು ಆರೋಪಿ 3ರವರ ಸಹೋದರನಾಗಿರ್ತಾನೆ. ಕಾಲಂ ನಂಬರ್ 6ರಲ್ಲಿ ನಮೂದಿಸಿರುವ ಸಾಕ್ಷಿ 1 ಮತ್ತು ಸಾಕ್ಷಿ 4, ಸಾಕ್ಷಿ 5ರವರ ಮಗಳಾಗಿ.
ಇದೆಲ್ಲ ಯಾರು ಬರೀತಾರೆ ಗೊತ್ತಲ್ಲ ನಿಮ್ಗೆ? ಯಾರು ಬರ್ದಿದ್ದಾರೆ? ಅಲ್ಲಿ ಸಮ್ಮರಿ ಯಾರು ಬರ್ದಿದ್ದಾರೆ? ಪೊಲೀಸ್ನವರಲ್ಲ, ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ರೈಟರ್. ಅವರು 498 ಒಂದು ಫಾರ್ಮ್ಯಾಟು, 307 ಒಂದು ಫಾರ್ಮ್ಯಾಟು, ಎಲ್ಲದಕ್ಕೊಂದು ಫಾರ್ಮ್ಯಾಟ್ ಇಟ್ಕೊಂಡಿರ್ತಾರೆ.
Absolutely.
ಅದು ಕಾಪಿ ಪೇಸ್ಟ್ ಮಾಡ್ತಾರೆ.
Well, as far as we know, the complaint also forms a part of the charge sheet.
The complaint does not form a part of the charge sheet when charge sheet is filed.
My lords,
It
there are several judgments in which it says
loses
that.
its value. Yes.
No, my lords, there are several judgments which says that the statement of the prosecutrix is alone enough without any corroborative evidences.
That is in POCSO.
No, my lords, in general totality, my lords, I could produce that judgment.
ಆ ಕಾಲ ಹೋಯ್ತು ಸರ್. 498A ಅಲ್ಲಿ wives glorifying the complaint
There are several
and small skirmishes between the husband and the wife projected to become a crime under 498A. Gone are those days.
My lords, this is not a case which submerges with the other cases. My lords, there is video evidences, there is audio evidences, there is photographs at which there has been exchange of golds, exchange of materials. There has been admission from the.
ಕೊಡ್ಬೇಕಾರೆಲ್ಲ ಫೋಟೋ ತೆಗಿತಾ ಇದ್ರಾ?
Yes, my lords.
ಯಾಕೆ? What was the intention?
The intention was nothing, my lords. It is just that
Future plans.
It was
Future
celebrated.
plans of registering the crime?
No,
Then
absolutely not, my lords. See, my lords, what happens to the vindicative of the petitioner number 1 is, as on the date of the marriage, he's only a clerk in the said bank. On the date of the marriage, he has written a departmental exam previously. He gets announced as a bank manager. That is where the issue starts. From the very first date, the real intention has been that after you become a bank manager, he would have sought out for another wife who had better dowry. That is the whole allegation gist of this. My lords, there are multiple cases in this which the wife is desperately fighting till date. Even though an offer was given from the side of the husband saying that I am ready to settle this matter, she has not accepted it. She has filed a restitution of conjugal rights, and there are video recordings in which, my lords, if in the objections.
what video recordings?
Audio recordings, my lords. This was played in CMS also. In my statement of objections.
So you continue CMS, you continue MC, whatever you want to continue. You can't set the criminal law into motion on such things.
No, my lords, it's
That
already
is
there.
husband. What are the other two?
My lords, when there has been a voice recording from accused number 2, that is petitioner number 2, where she is demanding dowry, that's prima facie sufficient material to demonstrate that she's been involved into the act, my lords. That is
Where is the?
My lords, at page number 53 at annex C.
Where is the transcript and 65B certificate?
Well, I'll file the 65B, my lords, but this is an evidence. This
Give
is
it,
the
give
material
it.
which
Where
I
is
have
that?
gotten.
Give it. We'll see.
My lords, it's at page number 53.
Give certificate file ಮಾಡಿ.
Martin, I'll demonstrate this because there is a clear audio clipping where the petitioner number 2
Transcript and certificate.
I will do that in the next.
And what about the third petitioner?
My third petitioner also, my lords, after I got shifted to the first floor. After I got shifted to the first floor, there was constant provoking from her That has also been.
What is provoking got to do with first floor?
My lords, after, when all these issues came to an end, after going, see, the one more thing, what happens here, my lords, is the petitioner relays on few complaints which have given before the other police stations, which have not revealed everything. But what the petitioners should what the court should understand is, under what circumstances I have given that complaint. It was just 6 months after my wedding. I could not narrate.
How long were you together?
Well, it's 1 year, my lords. 1 year I was together, my lords. And then I will put the entire video clippings before this honorable.
Audio, sir. Video.
Audio, sorry, audio.
ಯಾವಾಗಲೂ video clipping ಅಲ್ಲೇ
That is not part of the charge sheet, my lord. The audio that what my learned friend is
What
saying.
my learned friend is relying also is not part of the charge sheet.
So that I have a right to produce before the, my lord, the trial
That
court,
is what I
my lord, which I have produced under section 239.
So ಹಂಗಾರೆ ಟ್ರಯಲ್ ಹೋಗ್ಲಿ ಬಿಡಿ.
ಅಲ್ಲ.
Yes, list the matter on 11th, 10th. Yes.
Interim order.
Produced by then.
62.
Interim order.
That will continue. Yes.
Nadima. Nadima.
Eh?
Will be taken up on Tuesday, my kind.
ಎಲ್ಲಿ ಯಾವಾಗ ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ. ಎಲ್ಲ next week ಅಂತಾನೆ ಇದ್ದೀರಾ?
No, my lord,
ಜಗದೀಶ್ ಇಲ್ಲ ಅನ್ಸ್ಮೆ. Yes, 10th.
I informed him also.
List on 10th. Yes.
And entry matter 9th kindly, my lord.
No, 10th.
10th have some personal information.
No problem. ನಿಮ್ ಕೊಲಿಗೆ ಇರಕ್ಕೆ
Kindly, my lord. Or otherwise any date after.
10th. Yes.
14th kindly at least. Because family function.
No, you're not cooperating with the I'll vacate the interim order of the wife.
No, but I till now, as of now.
If the husband dodges the issue, I'll vacate the
No,
interim order of the wife.
we instructed him and he'll be definitely coming to India. That's the reason I.
Not doing any meharbani, sir. He has to be here.
No.
Yes.
9th or at least 14th kindly.
9th, all right. Yes.
Deeply.
Interim order ಯಾರ್ದು? Wife. Second petition interim order 62.1. Yes. No representation. List on 17th. Next.
63.
ಇಲ್ಲೇ ಇದ್ದೀರಲ್ಲ ಯಾಕೆ?
ಅಲ್ಲ ನಾನು my lord, this is the CRP filed on the order of the district judge dismissing the appeal, miscellaneous appeal, that the based upon miscellaneous 38 of 2007.
CPC
It is a, my lord, the facts or judgment was passed for partition.
Serve on the response.
I filed RA.
2024 matter.
Yes, I filed RA.
The petitioner to serve on the counsel appearing for the respondents in the trial proceedings. Yes, next.
The FDP is there, fixed. My lord, final stage has come.
ಒಂದು ವರ್ಷದಿಂದ ಸುಮ್ಮನೆ ಇದೆ. Next. Yes.
ಇಲ್ಲ, my lord.
List on 17th. Yes,
Till otherwise the FDP will go on and last stage has come.
Let it go on. Yes.
ಇಲ್ಲ, my lord.
Let it go on, sir.
Till then.
No.
Otherwise, because
I am not staying FDP at all. Yes, next.
RA was dismissed for default.
No problem.
And it was restored on payment of fine.
No problem.
And
Yes.
even though the fine was paid.
17th. Yes, next.
64.
Till then.
No, sir. ಒಂದು ವರ್ಷದಿಂದ ಸುಮ್ಮನೆ ಇದ್ದೀರಾ ಈಗ. Next.
The respondent number 1, 2, 3, my lord, plaintiff before the trial court, my lord, they have filed a suit for partition.
Rejected,
ನಮ್ಮ
711.
711 rejected. My lord, on the ground that, my lord, what happened, my lord, earlier there was a partition among the family members of plaintiff and defendants. My lord, in the year 2008, my lord, subsequently Khata has been mutated in their respective names, my lord. Survey number 406, my lord, followed to the share of plaintiff.
Partition suit.
Partition suit.
711 ಬರೋದೇ ಇಲ್ಲ. Anything else?
This is the reason. Subsequently, what happened? The suit shall property ಇದ್ರ ಬಗ್ಗೆ ಏನಾಗಿದೆ? We in the year 2008, my lord, kindly peruse the, my lord, they have admitted in para number 6 of the plaint that, my lord, para number 6 kindly very moment. It is further submitted that after the death of Ningayya, the legal heirs of said Ningayya, that is Anumaya, Gauramma, Devegowda, Jairama, changes the Khata illegally without consent of the knowledge.
They rely not on administrative partition deed up to the year 2008 was, but as per the decision of the oral partition or what administrative partition is not valid, subsequently amendment of section 6.
No, but it has evidence, my lord.
Yes, list the matter on 18th.
Till then, my lord.
No, till then, yes. Dismiss ಮಾಡಕ್ಕೆ ಟೈಮ್ ಇಲ್ಲ ಈಗ ಅಷ್ಟೇ. Yes.
65.
applying for the petition, Your Lordship. Your Lordship, I'm filing the affidavit to taking, undertaking the, get the premises, Your Lordship.
ಏನ್ affidavit?
As per the, this honorable court, 6 months, my lordship.
6 months.
As per the order of this honorable court, my lordship.
ಅಷ್ಟೇ, it closes all proceedings. Yes.
And also, my lordship, the
Also ಏನಿಲ್ಲ, will record this and close it.
memo of calculation also paid, everything rent has been paid, my lordship. There is no such rent has been. No, my lordship. I have
ಕಟ್ತಾರೆ.
given the-
ಅಲ್ಲ ಈಗ 6 ತಿಂಗಳಿರೋ ರೆಂಟ್ ಕೊಡೋದು ಬೇಡವಾ?
ಅಲ್ಲ ಸ್ವಾಮಿ, ನಾನು ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ, ಇದು ಒಂದು
6 ತಿಂಗಳು, ಈಗ ಮುಂದೆ ಇರೋ 6 ತಿಂಗಳು.
ಅದಲ್ಲ ಸ್ವಾಮಿ. ಅದಕ್ಕೆ I have undertaking to pay the without default, my lordship.
The petitioner is the tenant, the respondent, the landlord. The respondent institutes proceedings in SC 453 of 2023 seeking eviction of the petitioner, and the suit is decreed. The petitioner is before this court. ಅಲ್ಲ, ಇದು order 7 rule 11 ಇಲ್ಲ, suit is decreed. Yes. So the petitioner is before this court challenging the said order. The learned counsel for the pursuant to the orders passed by this court, the petitioner has filed an affidavit of undertaking that he would, ಎಲ್ಲಿ affidavit? Has filed an affidavit of undertaking that he would vacate and deliver vacant possession of the property to the petitioner, to the respondent within 6 months from today. And also has filed a memo of calculation with regard to payment of rent, and would also undertake to diligently pay the rent for the next 6 months that he is permitted to stay. In that light, I deem it appropriate to close this suit itself. In that light, close ಆಗಿ ಮಾಡ್ಬೇಕೇನ್ ಬೇಡಲ್ಲ? ಅದಕ್ಕೆ ಡಿಕ್ರಿ ಏನ್ ಮಾಡೋದು ಬೇಡ. In that light, the petition stands disposed without interfering with the judgment and decree in SC 453 of 2023 recording the undertaking of the petitioner.
Kindly direct the respondent to return the advance amendment at the time of vacating.
At the time of the petitioner delivering vacant possession, the respondent shall also return the security deposit / advanced in the manner that it is produced, subject to adjustment of any arrears as on the said date. Yes. Ordered accordingly. Next.
Further hearing, 30 matters.
ಎಷ್ಟಿದೆ?
330 matters.
ತಗೊಂಡು ಕರೆದು ಬಿಡಿ.
94.
Admission ಮುಗಿತಾ ಮೇಡಮ್ ಎಲ್ಲ?
For the case PCB, my lord.
94.
Okay.
Lords.
Yes, sir.
Number 105, my lords.
ASG, I'm told that
Lords, we had obtained sanction in that. Learned ASG is online.
Which one, sir? Which matter?
105.
105 appear ಆಗ್ತಿದೆ ಸರ್.
330 list.
ಇಲ್ಲಿ ಯಾವ್ದೋ ಫರ್ದರ್ ಹಿಂಗ್ 330 ಅಂತಿತ್ತು. 105. 105 ಏನಿಲ್ಲ. 95. Which serial number ಕರೆದಿದ್ದು ಮೇಡಮ್?
94 ಕರ್ದೆ और 105.
105 ಅಲ್ಲಿ ಯಾರಿದೆ? ಓ ದಟ್
ಬಿ ನಾಗೇಂದ್ರ ಸ್ಯಾಂಕ್ಷನ್ ಮ್ಯಾಟರ್.
ಈಗೇನ್ ಅದು ತಗೋಬೇಕಾ? ಕರೆದಿದ್ದು 95.
We would request some time. We had obtained sanction.
Time ಬೇಕು ಅಂತ.
Seeking for an adjournment.
I'll just call the cases. 5 ನಿಮಿಷ sir. I'll just run through the list.
And for the case BCB, my lord.
Appearing to petitioner relation.
Respond number 2.
94. Yes.
Your Lordship, they are alleging that the STP was not working properly and they had instituted a criminal suit. And basically what happened, we have deposited 6 lakhs before the KSPCB saying that we'll properly function STP. They have revoked that. And then we had appointed a third party also.
Is
to-
offense under the pollution.
Section
Air Act.
49 allows.
Yes.
Because CFO was not.
Of the Air
obtained.
Act.
Please, sir.
Your Lordship.
Because
Who appears for the pollution?
Me,
You
my
are.
lord. I'm for pollution control.
Vacating stay or Akiral.
respond number 2, Your Lords.
Who are you?
I'm the complainant, Your Lords, one of the resident.
Yes, what's the problem?
In this, Your Lords, the occupancy certificate is taken in 2015 without even obtaining a consent for operation for the operations of the STP. Subsequently, a complaint was given, inspection was done. When the inspection was done, he gave an undertaking in 2019 stating that within 45 days, I will set up the CFO. So he admits in 2019 that I haven't set up the CFO, I will set up. That per se is an offense under section 25 of the Water Act. Laws. Thereafter, subsequent several correspondences have been exchanged between the parties after the Maser. He has subsequently stated that I will complete the CFO, but he has not completed the CFO. As per the section 49 of the Water Act, a final notice was given. He did not even complete. Laws. Thereafter, cognizance has been taken. Complaint has been filed before the magistrate. Thereafter, cognizance has been taken. That cognizance they have challenged before this.
Your Lordship, it would have not been an offense at all. In 2017, a gazette notification was there which amended the Environment Protection Rules in 1968. They gave 5 years time to all the builders to comply with the STP.
From what date?
From 2017. So till 2022, they couldn't.
When did you complete it?
We completed it in 2016. So after that, STP was set up, Your Lordship.
When? 5 years olagaita.
Yes, Your Lordship.
Where
They
is-
had filed they filed the complaint in 2019 or so, Your Lordship.
2015 occupancy certificate has been taken without the CFO.
No, no.
That
Now,
has been withdrawn.
Was that the law then?
That I have not.
Then look into it. If it has come into effect in 2016 and 5 years, 17 and 5 years is given from that date, till 2022, it's not an offense then.
That I will receive a copy.
Look into it, yes. The learned counsel appearing for the, what's your name?
Shravani, sir.
The learned counsel appearing for the petitioner submits that the offense that is alleged became an offense, could become an offense only on the year 2022 as the amendment to the Environment Protection Act, is it?
Yes, Your Lordship.
Environment Protection Act with regard to establishment of, what is this?
STP.
STP comes about in the year 2017 and 5 years period, 5 years time was given to all the concerned to establish STP from the date of the notification. The STP is established well within 5 years is the submission of the learned counsel for the petitioner. Therefore, the learned counsel for the respondent seeks time to verify and make his submissions. List the matter on 24th. Yes, next.
Your Lordship,
Interim order subsisting will continue to the next.
After 26th, Your Lordship.
List the matter on 30th.
Much obliged.
Interim order subsisting will continue to the next date of hearing.
55.
For the petitioner 95.1, my lord. This is that Santosh Hospital's matter, my lords. Lords in.
Akil Son, yes, list on 11th interim order subsisting will continue to the next.
Wherein my
25.
items
Sorry,
that are
96.
seized, my lord, I sought for release before the magistrate. Because
Yeah,
of
no,
the stay-
telephone, for mobile phone.
Mobile phone and other items, my lord.
11th, yes.
Based on this.
11th,
stay-
10th,
Based on this stay, my lord.
10th, yes.
96.
Interim order mechanism.
Okay, good.
Give for the respondent.
96
This is that
again.
PDA case. I should be in a position to.
10th.
Please.
Yes. Interim order subsisting will continue to the next date of hearing. Yes.
97.
No time, there's a meeting at 5 o'clock, so otherwise I would have sat till 6 and finished, yes.
97.
7A.
Yes, teapot case.
Huh?
It's covered by the
Correct.
teapot
Ille
case.
Varun Barlailwala. There was no representation on behalf of the petitioner previous date only. There is no representation on behalf of the petitioner even today. The learned counsel for the petitioner respondent Lokayukta submits that the issue in the list stands completely covered by what is rendered by this court. Tavali madam, no?
Please.
What is rendered by this court in WP 8776 of 2024 disposed on 2nd June 2025. As a last chance awaiting the appearance of the petitioner, they list this matter on Thursday. In the event the petitioner would not be present, orders would be passed following the judgment dated 2nd June 2025, passed a criminal petition 8776 of 2024, subject to the aforesaid intermod idea. Subject to the aforesaid intermod stand section to the next date of hearing. Next.
98 for the petitioners, my lord. That's for the respondents in this.
In this matter, my lord.
ಇವತ್ತ ಟೈಮ್ ಆಗಲ್ಲ. 5 o'clock ಒಂದು ಮೀಟಿಂಗ್ ಇದೆ. ಮಂಡೇ. 8th ಬೇಕಾ? 8th ಇಲ್ಲ, 8 ಟ್ವಿಟರ್ ಇದೆ.
7th at 3:30 or 4.
7th ಹಾಕಿದ್ರೆ 3:30ಗೆನೆ ನೋಡೋಣ, ವಿಲ್ ಸಿ. ಎಸ್, ಮಂಡೇ.
7th both the Dharwad mining and steel hypermarket.
ಇದು ಇರ್ಲಿ. ಎಸ್, ಅದೆರಡು ಅರ್ಜನ ಆಗ್ಬಿಟ್ರೆ
99.
ಸಿ ಜಗದೀಶ್ ಅವ್ರು ಇದ್ರಲ್ಲ ಇಲ್ಲೇ. ವಿಡ್ರಾ ಇಲ್ಲ ಕೊಡಿ.
ಅಲ್ಲ, ವಿಡ್ರಾ ಅಲ್ಲಿ ಒಂದು ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡ್ಬೇಕು ತಾವು, ದಯಮಾಡಿ.
ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದಾರೆ.
ಒಂದ್ ನಿಮಿಷ.
ನೀವಿದ್ದೀರಾ?
99.1 year.
Kindly, before that, my lord.
ಆರ್ ಜಿ ಹೆಗ್ಡೆ ಅವರು ವಿಡ್ರಾ ಮಾಡ್ತಿರೋದು ಯಾವುದು?
901.
99.4.
901.
901 ಯಾವುದು?
First matter 90, serial number 90.
Lord, he addressed the letter to the government, making use of this, seeking permission to prosecute the persons who doesn't give a certificate. It runs contrary to section 7 of the Karnataka Scheduled Tribe other backward classes.
ಆಯ್ತು, ಅದ್ರ ಪೆಟಿಷನ್ ಇದ್ದಿದ್ರೆ ಬರಿಬೋದಿತ್ತು.
ತಾವು ಹೇಳಿದ್ರು ಒಂದು ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಾಯ್ತು. ಇಲ್ಲಾಂದ್ರೆ ಏನಾಗುತ್ತೆ ಗೊತ್ತಾ, ಇದು ನಾನು ಹೇಳ್ತಾ ಇರ್ತೀನಿ.
ಅಲ್ಲ, ವಿಡ್ರಾಯಲ್ ಅಲ್ಲಿ ನಾನು ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿದ್ರೆ
ಅಲ್ಲ, he has argued at length, later after ನೀವು ವಿಡ್ರಾ ಅಂತ ಬರೀರಿ ಸ್ವಾಮಿ. ಇಲ್ಲಾಂದ್ರೆ ಏನಾಗುತ್ತೆ ಅಂತ
ಅಲ್ಲಿ ಮೆಮೊ ಹಾಕಿದರೆ ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ವಾಟ್ ಹ್ಯಾಪನ್ಸ್ ಲಾರ್ಡ್?
ಇದನ್ನ ರೆಫರ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಪೆಟಿಷನ್ ಶುಡ್ ಬಿ ಲೈವ್.
ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ, ಅಟ್ಲೀಸ್ಟ್ ಕಾಸ್ಟ್ ಆದ್ರೂ ಹಾಕಿ.
ವಿಡ್ರಾ ಮಾಡೋ ಕಾಸ್ಟ್ ಹೆಂಗ್ ಇಂಪೋಸ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
My lord, he has issues this court forum for so many hours. Should be allowed to allow scot free? Yeah, free. Agli.
3 minutes.
I respected the.
ಅಲ್ಲ, 3 minutes, 70 minutes ಅಲ್ಲ.
23.
ಟೆರರೈಸ್ ಮಾಡೋದು ಲೋಗಿ ಅಫಿಷಿಯಲ್ಸ್ ಗಳಿಗೆ
ಯಾವಾಗ?
ಅದ್ರಲ್ಲಿ ಇದೆ ನೋಡಿ, ಲೆಟರ್ ಅಲ್ಲಿ. ಅದು ಏನು ಬೇಡ ಜಂಗಮ ಅಂತ. ಬಸವಣ್ಣ ಏನಾದ್ರು ಬದುಕಿದ್ರೆ
ಅಲ್ಲ, ಈಗ
ಕಮಿಟೆಡ್ ಸುಸೈಡ್.
ಈಗ ಆಯ್ತು, ವಿಡ್ರಾ ಮಾಡಕ್ಕೆ ಬೇಡ್ತಾ ಇದ್ದಾರೆ, ವಿಡ್ರಾ ಮಾಡ್ಬಿಡುವ. ಎಸ್, ಯು ವಾಂಟ್ ಟು ವಿಡ್ರಾ?
ಇಲ್ಲ, I am retiring from the case.
My lord, we have already filed wakalat in 99.1.
The learned counsel R.G. Hegde files a memo seeking withdrawal of the petition in WP 901 of 2023 and files a memo in writ petition 41202 of 2019 to withdraw himself from the case. Both are allowed. Yes.
My lord, we have already filed wakalat.
Of course, he will not insist for this memo to be.
No, ಅವರಿದ್ರೆ ಹೇಳ್ತಿದ್ದೆ ಇನ್ನೂ ಚೆನ್ನಾಗಿ.
ಇರ್ಲ್ವಲ್ಲ, ಹೋದ್ರು.
My lord, one respectful submission. In 99.1, Shri Akash VT has entered appearance on behalf of the petitioners.
ಏನಿದು 99. ನೀವು ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ದೀರಾ?
Petitioners 2 to 4.
Council Akash VT submits that he has entered appearance for the petitioner. Registry to print the name of so and so is appearing for the petition. ಎಷ್ಟು ಜನ ಆಗಿದ್ದಾರೆ ಈಗ?
Petitioners 2 to 4. Petitioners 2 to 4, my lord.
2 to 4.
We have entered
ನೀವು
appearance.
ಯಾರಿಗೆ ರಿಟೈರ್ ಆಗಿದ್ದೀಗ? 1. ಸರಿ, ನೀವು ಯಾರಿಗೆ ಎಂಟರ್ ಆಗ್ತಾ ಇದ್ದೀರಾ ಸರ್? ಆಕಾಶ್
2 to 4, my lord.
1ಗೆ ಯಾರು? ಯಾರು ಇದ್ದಾರೆ ಬಿಡಿ. ಮಠದ ಚಿದಾನಂದ ಸ್ವಾಮಿ. ಇಲ್ಲೇ ಇದ್ದೀರಾ? ಆಯ್ತು.
Lordship rightly observed last opinion that my name is to be deleted. It was right observation.
Right observation.
From the advocates.
Advocates?
ಅಲ್ಲ, ಕಾಸ್ ಲಿಸ್ಟ್ ಇಂದ ಡಿಲೀಟ್ ಮಾಡ್ಬೇಕು. ನೀವು
ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ
ಡಿಲೀಟ್ ಮಾಡ್ಬಿಟ್ರೆ ನೀವು ಆಮೇಲೆ ಎಲ್ಲೋ.
ಅಲ್ಲ, ನೀವು rightly observed that my name should be deleted from the advocates. And you are saying right observation.
ಅಷ್ಟು ಟೆನ್ಷನ್ ಕೊಟ್ಬಿಡ.
ಕಾಸ್ ಲಿಸ್ಟ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ನೀವು ಬಂದ್ರೆ ಸುಮ್ಮನೆ ಟೆನ್ಷನ್ ಮಾಡಿ ಸುಮ್ಮನೆ ಇರಿ.
ಅವ್ರ ಕ್ಲೈಂಟ್ ಗಳು ಕೊಡೋದು ನಾವಲ್ಲ. He is a good friend of mine.
ತೊಂದರೆ ಇಲ್ಲ, ಈಗ ಇದಾರೆ ಬಿಡಿ ನಿಮ್ಗೆ. ಎಸ್,
ಇದನ್ನ ತಾವು ದಯಮಾಡಿ ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್
ಅಂದ್ರೆ ನಿಮ್ ಬಗ್ಗೆ.
My lords have to erase this cloud.
ಇನ್ನ he'll have a tough time ಅಂತ.
No, I'm going to have a tough time.
Polaral case ಅಲ್ಲಿ my lords have erased the eclipse. Now the state is
eclipse.
ಗ್ರಾಣ ಬಿಡಿಸಿದ್ರಿ ನೀವು.
ಅಲ್ಲ, ಅದೇನಾಯ್ತದು? Stay ಆಗಿದೆಯಲ್ಲ?
ಏನಾಗಿಲ್ಲ.
Stay ಆಗಿಲ್ವಾ?
ನೋ ಸ್ಟೇ. ಅಷ್ಟು ರೀಸನಬಲ್ ಆರ್ಡರ್ ಬರೆದು ಸ್ಟೇ ಮಾಡಿದ್ರೆ ಹೆಂಗೆ ಸ್ವಾಮಿ? ಆಗಲ್ಲ, ಸ್ಟೇ ಆಗಿಲ್ಲ ಅದು ಇನ್ನ. ಎವ್ರಿಥಿಂಗ್ ಎಸ್ ಪುಟ್ ಮೆಲಾಡ್ ವೈಟ್ ಅಂಡ್ ಬ್ಲಾಕ್ ತಮ್ಮಿಂದ.
ಎಸ್.
ಇದ್ರಲ್ಲೂ ಅಷ್ಟೇ. ಇವ್ರು ಏನ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅಂದ್ರೆ ಗಂಡ ಹೆಂಡತಿ ಹೋಗ್ತಾರೆ ಇದ್ರೊಳಗಡೆ.
ಯಾವ ಗಂಡ ಹೆಂಡತಿ?
ರೇಣುಕಾಚಾರ್ಯ ಇವನು ದ್ವಾರಕೇಶ್ವರ
ಇವನು ಎಲ್ಲ ಬೇಡ.
ಅಲ್ಲ, ಐ ಆಮ್ ನಾಟ್ ಅಡ್ರೆಸಿಂಗ್ ಇವನು. ದ್ವಾರಕೇಶ್ವರ ಅಂಡ್ ಇಸ್ ವೈಫ್ ಎಲ್ಲಾರ ಮೇಲೂ ಇದನ್ನ ಕೇಸ್ ಹಾಕ್ತಿವಿ ನಾವು, ಡಿಫರ್ಮೇಶನ್ ಕೇಸ್ ಹಾಕ್ತಿವಿ ವಿಡಿಯೋದಲ್ಲೆಲ್ಲ ಬಿಡಿ. ಇದು ಹೇಗಾಗ್ತಾ ಇದೆ ಅಂದ್ರೆ
ನೀವು ಅಪೇರ್ ಆಗ್ತಿದ್ದೀರಾ ಅವ್ರಿಗೆ?
ಅದಕ್ಕೆ ಬೇಗ ತಗೊಂಡು ಈಗ ಡಿವಿಷನ್ ಬೆಂಚ್ ಹಸ್ ಆಲ್ರೆಡಿ ಡಿಸೈಡೆಡ್. ಮಂಡೇ ಬರ್ದಿದ್ದಾರೆ.
ಮಂಡೇ ತಗೊಂತೀನಿ.
2:30 ಅಂತ ಫಿಕ್ಸ್ ಮಾಡ್ಬಿಟ್ಟು
2:30 ಎಲ್ಲ ಫಿಕ್ಸ್ ಮಾಡಿದೀನಿ, ತಗೊಳಕ್ಕಾಗಲ್ಲ.
ಇದನ್ನ ತಾವು ದಯಮಾಡಿ ಮಾಡಿದ್ರೆ ಲಾರ್ಡ್ಸ್, ವಾಟ್ ಐ ಆಮ್ ಪ್ರೇಯಿಂಗ್
ಯು ಆರ್ ರೆಡಿ ಮೇಡಮ್?
There's a rejoinder that the council C wants to file and we'll have it filed any day.
To the objection. Objection ಹಾಕಿದ್ದೀರಾ?
ಪಿಟಿಷನ್ ಅದಲ್ಲ ಅವರ
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ದೀರಾ?
I will demonstrate.
ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀರಾ? ಮತ್ತೆ ಯಾವ್ದಕ್ಕೆ ರಿಜಾಯಿಂಡರ್ ಆಗ್ತಾ ಇದ್ದಾರೆ?
To their objections because they brought
I have filed one objection.
ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೇನೆ ಅದರಲ್ಲಿ.
ಅಬ್ಜೆಕ್ಷನ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ ಜಗದೀಶ್ ಅಂದ್ಮೇಲೆ ಅದು ಸ್ಟ್ರಾಂಗ್ ಕೇಸ್ ಇದೆ. ಇಲ್ಲೇ ಯು ವಿಲ್ ಕನ್ಸಿಡ್ ಅದು ಅಪೆಲೇಟ್ ಅಥಾರಿಟಿಗೆ ಹೋಗ್ಲಿ ಅಲ್ಲೋಗ್ಲಿ ತೊಂದರೆ ಇಲ್ಲ ಅಂತ. ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ ಅಂದ್ರೆ
that's why it deserves a rejoinder.
ದೆನ್ ನೋ ರಿಜಾಯಿಂಡರ್ ಹಾಕ್ಲಿ ಬಿಡಿ.
ರಿಜಾಯಿಂಡರ್ ಹಾಕಿ ನಾನೇ ಹೇಳ್ತೀನಿ.
ಅವ್ರ ರಿಜಾಯಿಂಡರ್ ನೀವೇನ್ ಹೇಳೋದು?
ಹಾಕ್ಲಿ ಅವ್ರು ರಿಜಾಯಿಂಡರ್ ಹಾಕ್ಲಿ. ಕೈಯಲ್ಲಿರೋವನ್ನು ಕನ್ನಡಿ ಹಿಡ್ಕೊಬೇಕು.
10th
ಆಯ್ತು
10th. ಎಸ್, ಲಿಸ್ಟ್ ಆನ್ 10th. ನೀವು ರಿಟೈರ್ ಆಗಾಯ್ತಲ್ಲ ಇನ್ನೇನು. 10th ಇರ್ಲಿ, ನೀವು ಆಮೇಲೆ ನೋಡೋಣ. ಮೇಡಮ್ ಇದ್ದಾರೆ. ಎಸ್ ಯಾರು ಸರ್? ವೇಟ್ ಸರ್. ಎಸ್, ಸಿರಾಜುದ್ದೀನ್ ಬಹರೇನ್ ಕಬ್.
Next week only I will go Millards.
ಶಾಂತಿ ಭೂಷಣ್ ಎಲ್ಲಿ?
Only option ನನಗಿರೋದು ಏನಂದ್ರೆ
ಮಂಡೇ 4:15 ತಗೊಂತೀನಿ. ಅಫಿಡವಿಟ್ ಹಾಕಕ್ ಹೇಳಿದೆ ನಿಮ್ಗೆ. ನೀವು ಬಹರೇನ್ ಪಾಸ್ಪೋರ್ಟ್ ತಗೊಂಡು ಬಹರೇನ್ಗೆ ಹೋಗಿ ಇಂಡಿಯನ್ ಪಾಸ್ಪೋರ್ಟ್ ಇಲ್ಲಿ ಬ್ಲಾಕ್ ಮಾಡಿಸಿ.
Bahrain passport I cannot go Millards because it is not renewed. ಅದು 1984 ಚಿಕ್ಕ ಮಗು ಇದ್ದಾಗ ಮಾಡಿಸಿದ್ದು.
ಚಿಕ್ಕ ಮಗು? ಎಷ್ಟು ಜನ ಮಕ್ಕಳಿದ್ದಾರೆ?
No Millards. When I was child.
You were ಚಿಕ್ಕ ಮಗು. Yes. All right.
I should be permitted there to surrender my passport in Indian embassy.
Indian embassy Bahrain. ನೋಡಿ ಶಾಂತಿ ಭೂಷಣ್ ಬರ್ಲಿ. Yes.
Appear for the petitioner in 101, my lord. This is the case of the para swimmer, my lord. Throughout the
1,26,000 ಕೊಟ್ಟಿಲ್ವಾ?
ಇನ್ನು ಕೊಟ್ಟಿಲ್ಲ, my lord.
ಈಗ ಅದಕ್ಕೆ ಡಬಲ್ ಕಾಸ್ಟ್ ಅಂಡ್
your lordship had said that with interest and with cost they'll have to pay in case they do not pay within the next day.
Monday in preliminary hearing. Yes. After this ಇಲ್ಲ ಏನಿಲ್ಲ. Monday in preliminary hearing. Yes.
Obliged.
ಅದು Monday in further hearing. Yes.
My lord.
Monday ಬೆಳಗ್ಗೆನೆ ತಗೊಂತೀನಿ.
I will substantiate the entire amount.
Yes. Next.
102.
ಇದೇನು 6. ಏನ್ ಮೇಡಮ್ ಇದು? ಲಿಸ್ಟ್ ಆನ್ 11th 10th. Yes, next.
103.
Lord, these connected matters I got the order. I'll read it and make submission.
ಅಪ್ಲೋಡ್ ಮಾಡಿದ್ದೀನಿ. ಆಯ್ತು. 10th 11th
ಇನ್ನೊಂದು ಸ್ವಲ್ಪ
ಅಷ್ಟೊಂದಿಲ್ಲ ಓದಕ್ ಅದ್ರಲ್ಲಿ. ಡಿಲೇ ಮೇಲೆ ಅಷ್ಟೇ ಮಾಡಿರೋದು, ಬೇರೆ ಏನಿಲ್ಲ.
ಅಲ್ಲ, ನಂದು ಮ್ಯಾಟರ್ ಸ್ವಲ್ಪ ಡಿಫರೆಂಟ್ ಆಗಿದೆ. ನಂದು ಸೆಕ್ಷನ್ 20 ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀನಿ ಅದರಲ್ಲಿ.
ಅದು ಉಳಿದಿದೆಯಾ? ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಅದ್ರಲ್ಲಿ.
ಅದ್ರಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಕನ್ಸಿಡರ್
ಮಾಡಿಲ್ಲ. ಕರೆಕ್ಟ್.
ಅದಕ್ಕೋಸ್ಕರ
ಅದು ಬರೀ ಡಿಲೇ ಮೇಲೆ ಹೋಗಿದೆ.
ಹೌದು. ಅಲ್ಲ, ನನ್ನ ಕೇಸಲ್ಲಿ ನಾನು
ಆಯ್ತು ಸರಿ. ಯಾವತ್ ಬೇಕು?
ಎನಿ ಡೇಟ್ ನೋಡ.
18 18th.
ಪ್ಲೀಸ್.
All right, 18th. Yes.
104.
Please. My lord, the PC and PNDT, my lords.
Nice to see you, sir. E-court.
After the articles are seized since 2 years, the machine is seized, my lords, kept like that only since 2 years. And my lords
Scanning machine.
How though? Since 2 years, and I'm not be able to operate also the entire premises. The interim prayer is that
Monday,
please.
Yes, 105.
105.
No, 105 I'm appearing, my lord. Any convenient date? 24th, 25th July, my lords.
Nagesh sir, thumb. 10. Date convenient, please.
In fact, my lord, we had communicated to the other side.
24,
25th.
24th ಹಾಕ್ಲಾ? 25th Friday, you are there. CBI ಮಾತ್ರ ಅಲ್ವಾ ಇದರಲ್ಲಿ? ಅಲ್ಲ, ED
This is
ಮಾತ್ರ
ED.
ಅಲ್ವಾ? ED ಮಾತ್ರ ಅಲ್ವಾ? Raju sir will take it on 25th.
My presence may be noted, my lord, mine and.
Yes, yes. Heard the
Yes.
learned senior counsel, learned additional solicitor general of India, SV Raju. List the matter on 25th. Interim order subsisting will continue to the next date of hearing.
I am assisted by Mr. Zoeb Hussain, my lord.
Sir?
Great.
I'll pass the slip, my lord.
Yes, yes.
Grateful.
106.
My lords, I appear for the respondent number 2, my lord.
Petitioner, my lords.
Respondent number 1, my lord.
My lords, a date may be fixed in this matter, my lords.
10th.
Please.
Please, my lords.
107.
Interim order ಇದೆಯಾ?
Please.
No, my lords.
Yes.
107, my lord, the case of JCBs, my lords used to form a new road by the police, etc. And they were directed not to file.
ಬರ್ಲಿ.
ಅಲ್ಲ, they are directed. Your lordship, they are directed.
ರೆಗ್ಯುಲರ್ ಕೋರ್ಟ್ ಬಂದು ಬರ್ಲಿ.
ಇಲ್ಲ, ಇದ್ರೊಳಗೆ ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಬಾರ್ದು ಅಂತ ಹೇಳಿದ್ಮೇಲೆ ಬಿ ರಿಪೋರ್ಟ್ ವಿದ್ರೋನ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಪರ್ಸುವೆಂಟ್ ಟು ಮೈ ಲಾರ್ಡ್ಸ್ ಆರ್ಡರ್.
ಅಲ್ಲ, ರೆಗ್ಯುಲರ್ ಕೋರ್ಟ್ ಬಂದು ಬರದ್ ಬೇಡವಾ?
ಇದ್ರೊಳಗೆ
ಏನ್ 25 ಮ್ಯಾಟರ್ ತಾನೆ?
25 matters, my lord, because there is a it was heard substantively by my lord, but therefore it was parted. My lord. So lords may keep any day, my lords, for the present.
17th.
Please,
List on
interim order to continue.
interim order subsisting will continue to the next.
Most great.
108.
Lords, this is the matter wherein an order has been passed by RERA and they have been directed to pay money. A sum of rupees 10 lakhs had to be given by way of a DD. Till date, no
yes,
money
madam.
has been
My
paid.
lords, I have no instructions, so I'll be filing my memo of retirement. my lords.
Memo of retirement.
I'll
We'll dismiss
file
the case, no
Yes,
problem.
my
If there is non-compliance, we'll straight away dismiss the case. Yes, if the clients are playing smart by changing the advocate, you know what to do it. Yes, Kudi.
I have no instructions, my lords, so I.
No problem, yes. Allah, here, the client has taken the file from you,
Not yet, my lords.
then
ಅದಕ್ಕೆ ನಾನು
you should file a memo for
I
retirement.
will, my lords. I
File
will
it, list on Monday.
I will.
Yes. We'll dismiss it on Monday.
Much.
Yes, next.
End of list.
Hey, ಇದು 109. Oh, 109 ಆಯ್ತಲ್ಲ, sorry, yes, yes. End of the list.
Yes, this is my learned and moved it, this TV show.
Which is that show? Reality show.
This is called Quatley Kitchen.
Quatley Kitchen. Which language?
It's Kannada only. It's
Kannada?
Yes. It's on Jio Hotstar and Colors. Injunction is granted.
Now, what is the Quatley about?
The Quatley is about the fact that the plaintiff, Z, asked for an injunction against me, but does not make me a party. Does not make me a party. I'll show you what is the order.
Anything else, sir? 39 1 and 2, without making a party, you can't seek injunction at all.
I can make, I can seek for an injunction because. Yes.
Without making a party, you can't. Ex parte, yes, no problem.
But I have made the person with whom I have an agreement as a party.
Which is that?
Kindly have a look at, I do not know whether.
Where is the show?
Let me just show one line, please.
I have a few more. One minute. I'll get back.
Page 24. This is a prayer that is made. How cleverly, my lord, it's drafted. Please see how it is drafted.
Sir.
Page 24.
ಅದಕ್ಕೆ ಮತ್ತೆ ಇರೋದಿಲ್ಲ.
But this is unfair, I'm saying. We had filed a caveat. Please see the situation. I had filed a caveat. So to avoid a caveat.
Get over the caveat.
They did this. But interestingly, they filed a caveat in the writ petition against me.
Oh, that's why you're here.
Really, they now know.
ಅಲ್ಲೂ ಕೊಟ್ಬಿಟ್ಟಿದ್ರೆ ಆಗ್ತಾ ಇತ್ತಲ್ಲ. You should make them parties and take the order. Why all this?
Now, please see.
Go behind.
Let me
finish of the party concerned.
Let me.
Praying the court to grant expired ad interim order of temporary injunction directing defendant, including anyone claiming true under him, and any party engaging directly or indirectly the services of the defendant.
Now it's over, no problem. Now this has affected you.
Yes, because now they write a letter
now
to me.
Who are you? Jio Hotstar.
I'm Jio Hotstar.
Jio Hotstar, okay.
They write to me now saying we got an injunction, therefore you're also required to comply with this order.
You are not a party there.
I'm not a party.
Sir, anything else?
Yes, but I have few submissions to make, Lord.
Yes, sir.
Insofar as the injunction which is sought, Lord, I have sought it based on an agreement with the second respondent here who has been made as a defendant.
Second respondent here.
Lord, in this petition, Lord, they are made as a
Nataraj K.
Nataraj.
Lord, I have an agreement with him.
What agreement?
Agreement of services.
All right.
Where, Lord, he is actually shooting episodes even now with me. And therefore, my lord, there is an exclusive clause there.
That is Z Entertainment.
Yes, my lord. And therefore, my lord, those episodes are still being aired.
Quatley Kitchen is aired in Z?
No, my lord. It's in a different. Therefore, not, my agreement has a clause which restrains him
From what?
from not engaging with any other,
For any other program?
during,
Or every
during,
other program?
during, yes, my lord, during the, the pendency of my agreement.
You make
Then
him,
my lord, second, my
make
sec-
him, make Geo Hotstar a party.
But I
and
need
fight
not
it
make him
out.
a party, but I would make one submission to your lordship.
Yes.
First, this writ petition ought not to be entertained. But in the light of the fact, there is a
The
remedy
suit
by way
ought
of,
not to have been entertained.
by way of an appeal, which is available to the present petitioner. But in the light of,
We will answer that.
Lord, in the light of Venkatesubbaya's judgment, my lord,
Absolutely.
in the light of an appeal remedy being available to them, my lord, they ought to have filed a COMAP. Therefore, not if they are aggrieved by the order. Therefore, not a writ petition ought not to be entertained was my first submission. My lord. Second submission, my lord, would be that there is no locus standi, because insofar as, my lord, the injunction order is concerned, it is insofar as the person who has engaged.
1 minute. You have an agreement with Nataraj
Yes, yes, we have an agreement.
for airing this show?
For this kitchen, Quarterly Kitchen.
Program ಅಂತ ಹೇಳಿ.
It's actually, sorry. For the kitchen show.
Anything else, sir?
My lord, my submission is
We'll
insofar
hear it
as.
further on Monday.
Your lordship's orders him.
But,
ನಂದೇ ಇದೆ.
Your lordship's
Your lordship also, I have also seen that, my lord. It's in a completely different scenario where it was against intermediaries. And, my lord, the person who was directly affected was not made a party. That is, my lord, your lordship's order. Kindly see your lordship's order, my lord. That has no application because the person who has a direct engagement with me is made a party. Therefore, my lord, the question of this judgment being applicable does not arise.
Yes.
Kindly have a look at, my lord, your lordship's judgment.
We'll hear it on Monday again. Yes.
But then your lordship will permit me to file a counter also, but
Please do it.
I would oppose, my lord, any stay order being granted insofar.
Straight away granting.
But
sir.
kindly
No
see, there's an
problem.
order operating against second respondent.
The-
Second respondent has not challenged the order.
The
Then, not if
petitioner-
lordship then were to stay the order, my lord, it should be only insofar as insofar as petition is concerned, not against second
Only
defendant.
petitioners, sir.
Not against second defendant.
Only petitioners. Yes.
But that is also, but of course, my lord, I have objections insofar as this also
No
is
problem,
concerned.
but yes. The petitioner, Geo Star India Private Limited, is at the doors of this court calling in question an order dated 1/7/2025 passed in Commercial OS 907 of 2025 instituted by Z Entertainment, the plaintiff before the concerned Commercial OS. The issue is the petitioner. Issue revolves around a television show, reality show by name Quarterly Kitchen, which is set to be aired in Geo Star from tomorrow.
It's already started from 14th. It's already started.
Which is being aired in Geo Star from 14th June 2025.
And they have aired episodes without the second defendant also.
All right. So and so. The issue is that the second defendant, this defendant number 1, Nataraj K, has an agreement with Z Entertainment that he would air shows on Z Entertainment during the subsistence of the agreement. The allegation is Nataraj K has now sought to air the show Quarterly Kitchen.
He is not airing, but he is participating.
Is participating in Quarterly Kitchen, aired by GeoStar. Therefore, there is said to be a breach of agreement that is entered into between Z and Nataraj. In that light, Z and Nataraj. The effect is now felt by the petitioner as the injunction order is operating not to air the show Quarterly Kitchen in GeoStar.
That's not the order.
What is the order then?
Kindly have a look at the order.
Any party engaging him is also injuncted.
That is Nataraj K.
24.
The injunction now granted under Order 39, Rule 1 and 2.
Training the defendant from directly or indirectly through himself or through any entities from in any manner judging, hosting, anchoring, mentoring, participating, acting in any fiction or non-fiction programs, so and so or any platform, but not limited to show Quarterly Kitchen, except at all plaintiff show.
And say
the interim order, 1 minute.
Colors Kannada.
Page.
It's not an order, not to air the show. That's what I'm pointing out to you.
Page 24,
Page 23.
they've extracted it.
Page 20?
24, please see, my lord. There itself, they say, I pointed out any party, fourth line on the top, under.
So where is the order, sir?
So this he says this is IA number 3.
Operative portion.
And the operative portion, Lord, is at page number 28,
The
where IA 3
order,
is granted.
1 minute. The plaintiff's application is quoted in the order, which reads as follows, page 23 to 25, and an order is passed allowing the application. The order reads as follows, page 28. what is sought for is granted. What is sought for is that the first defendant should not, the first defendant,
Sole
should
defendant.
not be directly or indirectly engaging himself in the services of any digital content, including but not limited to Quatley Kitchen being streamed on Colors Kannada. Geo Hotstar, Colors
Colors is one of it.
Colors Kannada, or any medium, including but not limited to YouTube, Facebook, Instagram, or other platform. Therefore, the direction is that Quatley Kitchen, if it is associated with the first defendant, it cannot be aired. This is the unequivocal, this is the unmistakable inference of the order that is passed by the concerned court. All of this happens without Geo Hotstar being a party to the proceedings. Therefore, the injunction order that is now granted, straight away hits the petitioner without making him a party. Though the IA3 is tactfully worded and the order of the concerned court also follows suit. In that light, there shall be an interim order of stay as prayed for only insofar as the present petitioner is concerned.
Your Lordship, I clarify it continues insofar as
Present petitioner is concerned.
Your Lordship, I clarify, my Lord, it continues insofar as second respondent.
Only insofar as present petitioner is concerned. Yes. It is obvious that it continues against others. Yes.
Sometimes, my Lord,
No, but
obvious things need to be restated.
Obvious things need not be said, sir.
But filing a caveat in this court against me, my lord, when they don't make, he says I'm not a relevant party. But how do you file a caveat here then?
Everybody know everything, sir.
No,
That's
but
why they
then-
file.
But I don't think filing of a caveat should be
Yes,
made
yes.
into.
Why do you apprehend that he will file? You know the effect is his.
I have not, there is no doubt. I have said that he should not act in their show. I have said so.
Serious
But
ಆಗಿ ಅಲ್ಲ ಸೀರಿಯಸ್ ಆಗಿ ಹೇಳ್ಬೇಕು ಅಂದ್ರೆ ಟೈಟಲ್ ಪ್ರಕಾರ ಯಾವ ಕ್ವಾಟ್ಲೆ ಇದೆ ಸುಮ್ಮನೆ ಮಾಡಿದ್ರೆ ಆಗ್ತಾ ಇದೆ ಪಾರ್ಟಿ.
In fact, Lord, I may point out the petitioner before your Lordship filed a similar suit against me.
ಹಿಸ್ಟ್ರಿ ಇದೆಯಾ ಈಗ?
Illa. I will point out not what happened. That was beyond the period of the agreement. After the person had finished airing the show, the show was finished. For 6 months thereafter, they say and get an injunction against me.
This is a revenge injunction.
Whereas, I have there. Why I pointed out.
ಅದು ಯಾವ ಶೋಗೆ?
That is not on the ground that person had participated in Big Boss, Kannada, and that serial got aired in January and got closed.
At least you made your
And I was.
did it fairly.
And I was I had engaged the person for a serial called Karna. An injunction was granted 6 months later at the instance of the petitioner.
ಅಲ್ಲ ನೀವು ಪಾರ್ಟಿ ಮಾಡಿದ್ರೆ ಸರಿ ಹೋಗ್ತಾ ಇತ್ತು.
ಈಗ ಸರಿ ನನಗೆ ಆಫರ್ಸ್ಕೇಟ್ ಆಗೋಯ್ತಲ್ಲ. ಎಸ್.
But I request since Lordship would have short date for that, I'll.
ಯಾವ ಥರ್ಸ್ಡೇ ಹಾಕ್ಲಾ?
Tuesday,
Tuesday that Twitter matter is.
Wednesday.
Wednesday, let me see. Wednesday you take chance. ಹಾಕಿರ್ತೀನಿ. Rest on Wednesday.
Malad 77.
ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ ಸರ್?
An application was filed by the plaintiff, this defendant's petition, that he need to be.
What application?
To be examined through a GPA holder.
ಯಾವತ್ತಿದೆ next?
It is set down on 14th,
List the matter on Monday in preliminary hearing.
Grateful.
Yes, next.
Malad.
This meeting, I'm already late.
Permission. Serial number 77, your Lordship may have it on Monday, my Lord. Please at 2:30. Eviction suit.
Pradeep on the eviction.
77.
Post it on Monday.
2:30 register. 2:30. My Lord, serial number 19, my Lord.
69, my lord. Can you
All
have it on Monday?
dates will be given by court officer. Yes.
69.
My lord.
Tomorrow.
My lord,
Serial number
69,
No shouting.
Monday, my lord.
Yes. The Dharwad list repeat on Monday. Yes.
Malad 77.
Madam.